for recovery of money where, my lord, I had a counterclaim. Now, my lord, suit was partly decreed allowing the plaintiff's claim. The matter went to execution. In execution, the parties arrived at a settlement. But this is the order passed in the execution proceeding.
Yes.
Now, kindly see the next page. The decree also stands satisfied. My lord, I had a counterclaim. I do not wish to proceed with my counterclaim. Lordship can, my lord, keep it as to be mentioned and, my lord, dismiss my suit as
What
not.
is the case? CS?
But this is CS of 24 of 2018. My lord, it has been renumbered as CS Com 94 of 2014.
CS.
Great.
Praying, my lord, leave to file the written statement. It's within 120 days, my lord. It's 119th day. The department, my lord, has indicated that there should be a leave from the honorable court.
Leave grant kar do. Leave granted to submit the written statement in the department in course of the day, subject to acceptance.
I'm very deeply obliged.
Let may I pray for an identical leave that Mr. Bagh is also praying for.
How many days?
120th.
Sure.
Yes, certain.
Deeply obliged.
Obliged.
हाँ हाँ, एक फोटो कॉपी करके यहाँ रख देना, एक फाइल बना दो तो केस नंबर करके फोटो कॉपी करके यहाँ रख दो बैक पेज, फिर उनको दे देंगे.
Lord, may I have my lords kindly to mention the matter, my lord. I have indicated to the respondents. Now, this is the Rasandik matter where, my lord, the application was for additional documents to be disclosed. It's appearing tomorrow, my lord. I'm in some difficulty. If it can just be made not today, I have already
listed today.
No, my lord, it's there tomorrow. I'll not be there, my lord. So I'm just indicating.
Okay, any junior mention the matter.
Yes, my lord, the junior will be there.
Mention the matter.
Great,
my lord. My lord, CS 151 2021, my lord. It is appearing on Friday, my lord. But difficulty is only half an hour time we require. We are in reply. My lord, Mr. Ratnako Banerjee is leading us in the matter. He will not be there on Friday. Lord, our only break I have his date. If it could
What
be.
time? It is time fixed.
No time is fixed. But my lord, since my lord, Mr. Banerjee.
Okay, you mention that. I will see. If the matter is called, you mention.
Very may permit to mention, I'm mentioning on notice on Friday the specially assigned matter is running in the list. Lordship, I'm in some personal difficulty on Friday.
Why for especially fixed, especially mentioned?
Specially assigned matter. Lordship, it's not specially fixed. It's assigned. It's running in the list. Lordship,
okay, you mention any junior mention.
Lordship,
if your lordship permits, is called, if any difficulty, let the junior mention that.
If your lordship permits me, I be allowed to mention one matter. My lord, in CSCOM 524 of 2024, I'm for the plaintiff, my lord. The matter was fixed for further cross-examination on July 15, 2025 at 3:45 p.m. by order dated June 9. My lord, due to my lord's engagement in the circuit bench, it couldn't be taken up. If I may humbly request my lord to kindly
when it was fixed?
July 15, 2025 at 3:45 p.m. So he, my lord, kindly fix the matter on any day, my lord, names fit, because Mr. Lakmani was my other side, Mr. Lakmani was doing the cross-examination and he is on his final stage of cross-examination.
It is not in the list.
It is in the list, but it's running very low, my lord.
Yes, so serial number?
152.
152. CS 524.
Yes, my lord.
Who is for the other side?
Mr. Rachit Lakmani was appearing for the other side. I have served them.
Record and order. Serial number 152, CSCOM 524 of 2024. Though the matter is appearing at serial number 152 of the today's list, but the Land Council for the plaintiff mention the matter and submit that the matter was especially fixed on 15th of July 2025 at 3:45 p.m. for further evidence.
Yes, ma'am. Further cross-examination.
Plaintiff witness of the plaintiff witness, but due to non-ability of this court, the matter could not be taken up for hearing. Accordingly, he prays for fixing another date and time so that the plaintiff witness can appear before this court for further cross-examination. In view of the submission made by the counsel for the plaintiff, let the matter appear on 23rd September at 3 p.m. for cross-examination of plaintiff witness. Yes.
May I, my lords? May I, my lords, kind leave to mention a matter, please, my lord.
Yes,
My
Mr.
lord, I'm sorry, my lord, we've been troubling your lordship with this matter. This is that money versus Piramal matter, your lordship remembers.
Yes,
This
yes.
matter. This matter.
And the matter.
Yes, my lord.
My colleague mentioned the matter, Lordship.
I'm sorry to trouble your lordship like this for the same matter again. But this matter is supposed to come tomorrow. There are two defendants, my lord. Mr. Sarkar is appearing for one. I'm appearing for the second defendant.
Correct.
So your lordship was pleased to say that the matter will be taken up around 10:30.
Hmm.
He is in some, my lord, because he's not in India. There's some time gap difference. So I was humbly praying, my lord, if it could be taken up in the any time after 10:30, as in 11, 11:30, whenever. So I don't want to trouble your lordship when the matter is called on. That was the only humble prayer, my lord.
उसमें कल 2 बजे 3 बजे फिक्स है क्या फिक्स है विटनेस एक्शन अभी कोई ऐसा डेट नहीं है जॉन भी नहीं अभी कोई मेंशन किया था Actual all time after lunch, all the date times.
No, my lord, don't keep, I'm not praying for after lunch, my lord. If it could be on even on Friday at about 11:30, if your lordship takes up the matter, only that much, my lord. Only that indulges. No, instead of 10:30, 11:30, please. My lord.
11:30 also all fixed till September.
11:30, 12, whatever, my lord. I'm not praying for fixing only, my lord. We'll seek a Passover that will only upset the diary, my lord. That is the only thing.
12:30, 11:30 से 12:30.
11 बजे होगा क्या?
कोई डेट नहीं है. Yeah, you have any problem tomorrow? You can argue the matter, or you want Mr. Sarkar to be argued first.
Mr. Sarkar would want to argue first whether the seniority is there, but I can't. It'll be very embarrassing for me. But Friday, Malad, then 10:30, I'll start, Malad. Otherwise, can't be helped, Malad. We can't trouble your lordship every day like this. Then
Tomorrow, because my lord, I'll have to inquire from my lord 3 seniors, my lord, for
no,
Friday.
Mr. Mukherjee is also tied up tomorrow. Mr. Kanodia, Mr. Mukherjee is tied up tomorrow at 10:30 in an admiralty matter which has been fixed, and I am opposing him. That is the whole problem.
3 leaders, my lord.
On. हाँ. नहीं वो तो लिस्ट में मैटर है फिक्स नहीं है.
If your lordship's diary board does not permit, my lord, then I will start on the next day. Kindly only excuse us tomorrow. Any date, my lord, then I will start. We'll have Mr. Sarkar join later. We cannot have it.
There's a new motion, my lord. Then, my lord,
Okay,
whoever
okay. Friday it will be taken as new motion at first matter.
Grateful, my lord. Deeply obliged.
Much obliged.
Grateful. Deeply obliged, my lord.
Lordship, may I be permitted to mention one matter, Lordship? Lordship, this is an original side matter, commercial suit. Lordship, on 31st July 2025, a wrong submission has been made before your Lordship that the plaintiff has already been scrutinized. But the plaintiff has already not been scrutinized and not been admitted. Kindly, Lordship, include in the list on the head of presentation of plain, Lordship.
कहाँ है वो फाइल कहाँ है कल लगा कल लगा no to be mentioned man it will come
Lordship,
as to be mentioned
Lordship,
and you mention I will see what is to be done in
Lordship,
then the court will see what is to be done in the matter
tomorrow,
it will be listed as to be mentioned.
Lordship.
Yes.
But I have
Well, this is a commercial matter. Your lordship remembers 2023, the commission started. Till 10 adjournments were extensions were taken, your lordship. On last occasion, my lord, I submitted before your lordship, my lord. I am a BIFR company, my lord, and I have to bear all the cost up till commission. 35 sittings till today were there, my lord. 2023 commercial is a commercial suit, my lord. My lord, submissions were made with regard to the documents which are not on records that were being crossed. I particularly find out a judgment of your lordship, and that was given to the commissioner. But still the documents which were neither relied upon by plaintiffs nor by the defendants. With regard to that documents, unnecessary question was asked. I find out a judgment of your lordship in the matter of my lord, in the matter of Nursing Ispat Udyog Private Limited, and I produced the judgment before the learned commission. Nobody listened to me. It continued.
Yes.
My lord, may I? Well, I am for the defendant number 1 and 2, your lordship. We have completed our cross-examination, my lord. My lord, on board now, defendant number 3 is cross-examining the plaintiff witness, your lordship. Now,
Who is for the defendant number 3?
My lord, I appear for the defendant
Yes.
number 3.
Yes.
My lord, we're trying our best to expedite the matter. However, the issue is, my lord, for each and every question, we're having 2-hour sessions, but for each and every question, the plaintiff's witness is consulting documents, and she's taking a lot of time to answer any question at all.
Why you are harping upon the document which the parties are not relying upon?
My lord, it was part of the I'm for the surveyor, my lord. It was part of the survey report. We had asked them to supply documents, the originals. They had brought it on record. My lord, thereafter,
Under the commercial court act, how the new document come? Even the consent of the parties? Even the consent of the parties, how the new document will brought on record?
My lord, we are not going to ask any question on those documents.
So how soon you will complete the cross-examination?
My lord, 2 or 3 more sittings at the very.
2 or 3 more sitting. What you are doing? Okay, I am. Let your witness come here. I will fix on Saturday. As I will take the leave from the Chief Justice. I will fix on Saturday. Okay, I will fix a Saturday whole day for you.
My lord,
as a specially fixed matter. Only for the cross-examination of defendant number 3. Let me see how far you are cross-examining.
My lord, I bow down to my lord.
Then I am fixing on Saturday, no problem. This court is no problem. Even we want a Sunday, the court will sit. I will take the permission from the Chief Justice.
My lord,
3 sittings for cross-examination.
I apologize, my lord.
How many questions he has put?
15 sittings already.
How many questions he has put in the cross-examination?
300 questions.
Then
300 questions. It is an insurance company. Fire.
What is going on?
They are not paying me. 300 questions already asked.
My lord, it's only because of the volume of documents.
What is that volume? The document?
My lord, 7 volumes.
Maybe.
My lord, I bow down to my.
I am fixing on Saturday. Bring the witness and you cross-examine. I will see which question is relevant and which question is not relevant. 2022, the commissioner was appointed.
My lord, we started our cross-examination from December last year.
December, not July. 7 months for the cross-examination.
My lord, there have also been adjournments sought by the plaintiff, which is why sittings could not be held.
My lord, I'm the commissioner, my lord. May I
And why you are allowing all these things?
My lord, the adjournment is.
If your persons are not able to tackle the evidence, why you are not bringing them things to this honorable court?
My lord, what is happening, my lord, during the course of witness action, my lord, the witness is taking time for the and consulting with the documents. Thereafter, she is answering.
My lord,
Naturally, witness has to consult the document.
My lord, I cannot debar him.
Cannot debar, but you have to see whether the question which has been put that is relevant or not. Whether the document which they are relying on that is relevant or not. It is your duty. You are not. And 7 months for the cross-examination and 135 sittings. Unknown. The court has appointed the commissioner for expedite the trial. Otherwise, this court is having sufficient time. 7 months the court could have been, if the witness comes, the suit could have been disposed of. It is informed by the learned counsel for the defendant number 3 that cross-examination of plaintiff witness. Plaintiff witness is going on and he required further time to complete the cross-examination. Thereafter, how many witnesses you are having?
I am having singly.
Thereafter, you will not have this. Then
I want to.
Our evidence ready, your lordship. We are required to file affirm it, your lordship.
Okay, you will add his evidence and you will also add his evidence. Full stop. Counsel for the plaintiff submitted. The plaintiff will not adduce any further evidence. After the cross-examination, the plaintiff witness number 1. Full stop. Counsel for the defendant submitted. They will also adduce the evidence. Full stop. In view of the circumstances mentioned above, time to file report by the commissioner is extended till today we are on August, na? Till 12th of November 2025. 12th of November 2025. Full stop. The commissioner is requested not to give any unnecessary adjournment to the parties, and if possible, day-to-day hearing can be fixed so that the evidence of the witness can be concluded at the early. The commission is directed to file the report. Kab diya hai?
And my lord, not 2 sessions. If it is
12th November.
if it is necessary, he will fix 1 session 2 hours. He is telling
That's
2
why day to
sessions.
day.
After 1 hour, 2 sessions. 2 fix.
2 hours, my lord.
1 hour.
It
You are
goes
taking-
on
no,
for 2
no.
hours.
So,
It is not for
filing
technical
report by
learning.
the
So
commissioner.
1 session will be there. How much you take your time and finish it off.
That is not
Yes.
the order.
Next.
That I am submitting before the court.
Grateful, my lord.
Lordship, this was that section 8.
Yes, what has happened?
This is the order.
Then what remains?
We make a application for review, but that is separate. Cannot, what has been done cannot be undone. So it was a lesson for us also, because this, although it's there in the Mediation Act, but we are completely.
Where is the order? Passed by this court?
22nd December 2022. Which my lord allowed the section 8 application.
22nd December.
Yes.
2nd December. 2nd December 2020.
Hey, order कहाँ है?
My lord, I have the copy of the order.
Yes.
Probably, if things fall in place, we'll have to come back again to your lordship. But let's. I'm not seeing anything right now.
We also may not leave it to your lordship. My lord, possibly nothing remains now in the suit. My lord, if my learned friend wants my lord to take his chance in review, my lord, that's absolutely for him.
Counsel for the defendant, counsel for the parties have handed over The order passed by the Honorable Supreme Court in Civil Appeal number 445 of 2023, dated 29th of July 2025, wherein the Honorable Supreme Court dismissed the SLP, then dismissed the civil appeal referred by the plaintiff. Let the order be kept with the, let the order dated 29 July 2025 passed by the Honorable Supreme Court be kept with the record. In view of the judgment passed by the Honorable Supreme Court, nothing remains in the present suit. That already by order that it
Yes.
already
Yes.
remains in the suit as by an order dated 22nd of December 2022. This court has already appointed an arbitrator. To adjudicate the dispute between the parties. Next. इसमें न्यू लेने की जरूरत है, इसमें न्यू लेके तो डायरेक्ट फाइन.
Item number 4.
I appear for the plaintiff.
How about the respondent number 1 matter? In the last occasion, Mr. Bagh was arguing on Order 7, Rule 11.
Yes.
We have an application GA number 4.
In
the last occasion, Mr. Bagh was arguing the matter.
You are for the different number? 1.
Which side? I'm the respondent.
Our petition, my lord, Order 7, Rule 11. So I requested my learned friend. My lord, I had made submissions in this matter.
My lord,
my lord, only
Mr. Bagh starts, may I make one request? Will your lordship grant me leave for a few minutes? My colleague is there online, but she could not come to court physically. But no one will be there physically from our side, but she's there virtually. Your lordship kindly grants me leave.
Let's see.
5-10 minutes, we'll come back.
Let it continue or?
Yes, but it can continue.
Okay, no problem.
very briefly, my lord, the Order 7, Rule 11 is what we were moving. My first point, which I had argued, my lord, is Dhanbad Fuels after the judgment. 12-way leave, because my lord, this dispute is very interesting. It's essentially in the nature of a money claim. My lord, with the money claim, there can't be an extreme urgency unless, my lord, something is shown. My lord, because today, whatever, my lord, is, because as far as, my lord, now the cutoff date is clarified in Dhanbad Fuels, my lord, on the point that if it is post that date, my lord, then thereafter, my lord, what can be the premise of a leave under 12-way? No pleadings required, no petition required. But even then, if a leave is granted under 12-way, it can always be revoked, my lord, after seeing that what is the premise. The premise exactly matches, my lord, Dhanbad Fuels, my lord, ingredients which I had shown on the last day. My lord, with these ingredients, because today all that is shown here is it's a dispute with regard to, my lord, a bill of exchange, set of bills of exchange. There's no invoice through which, my lord, this is really claimed. The plaintiff does business from Singapore. We are in India. They export materials. We, my lord, purchase them. We make the payments. There is no agreement, my lord, pursuant to an invoice. So today, my lord, all that they have claimed, and my lord, it's not a case where there is a huge outstanding. They have claimed, my lord, 67 odd crores. They have not indicated it's 1150 crores which has been paid by us. And my lord, this amount that they are claiming, my lord, there is no credit facility which is, my lord, accorded to us. So the moment, my lord, the exports happen, we have to pay. Otherwise, my lord, we will not get the goods. The pleadings in the plaint is silent with regard to, my lord, how this was given to us. So, my lord, my case that I'm making out is, my lord, there's also no cause of action. And barred by laws, my lord, that I'll couple it, my lord, with Order 7, Rule 11A. Because D, my lord, what I'll be relying on now is, my lord, a Bills of Exchange Act 1949 of Singapore. My lord, this is the premise on which, my lord, a party has to act under the Singapore law, because I'm contending that the Honorable Court would then not have a jurisdiction to decide this issue because it relates to, my lord, a violation of a bill of exchange, which is guided by the Bills of Exchange Act 1949. My lord, I'm carrying a copy.
You're for the defendant number 1.
I'm for defendant number 1, my lord. Only for 1. My lord, may I, before placing reliance on, my lord, the provisions of this act, may I request your lordship to take up the petition once? I should be candid before your lordship, my lord. The primary hurdle that they have to cross is Dhanbad Wills. My lord, once they cross this, my lord, then comes my next point of, my lord, Bills of Exchange.
Where is the prayer in the money suit?
My lord, the prayers, your lordship kindly takes up volume 1.
You have disclosed the plaint.
You are not in the Order 7, Rule 11.
Plaint.
So we have. Achha, okay. Yes, I've seen that. You know, the internal page.
You have enclosed?
Yes, my lord, yes, we have. Without the annexures, my lord, it's page 36.
36 of this application?
Of the application. Simpliciter money claim, my lord.
Of GA1?
Well, this is GA4, my lord. Leave clause 12, letters patent, order to rule 3, 12A.
Where is the readings? Acha. Have an immovable property situated transactions.
Paragraph 23, my lord.
The dependents are also taking steps to alienate, create third party respect. Okay, no document. Persist in unfair condition of the repeated criminal offense. Yes.
May I request your lordship to kindly take up paragraph 23 once. It's at page 31.
Yes.
Jointly, severally bound and obliged to make a payment of 67 crores, out of which defendants are liable for an amount of 54 crores to the plaintiff number 1 and for an amount of 12 crores to the plaintiff number 2. The plaintiffs are entitled to recover the amount.
That is an entitlement.
But that's basically a money claim. So it's a money suit that they have filed.
That's the prayer B.
My lord. Now with a money suit, my lord, there's always an interest component which I had shown on the last day that there, my lord, if I fail to make this payment, then my lord, I'll be liable to pay that interest. With that premise, my lord, it can't be that they are not in such a, they'll be suffering such a discretion against them, you know, that this will not be remedied in any manner. So, my lord, we had indicated this, and with this, my lord, they have also paid for interest at the rate of 18%. That's the next paragraph, my lord. 24, the next page, page 32.
Entitled interest at the rate of 18%.
18% per annum. Towards this, on and from this date, towards plaintiff number 2. So, my lord, the exact amounts that they had, so they have made that prayer.
Correct.
With this, my lord, and then they say it's a commercial dispute, and
27.
the details given. That's paragraph 27, my lord.
They have recorded the urgency is 27.
27.
Not urgency with regard to this leave.
With regard to leave, my lord.
Leave.
With regard to leave and my lord, the disputes as commercial dispute in paragraph 28. 29, they say that's, my lord, perhaps their urgency. Repeatedly tried and denied lawful claims of the plaintiffs, paragraph 29, my lord. First, manufactured a deed of settlement. My lord, this is the deed, your lordship will be pleased to recall. My lord, this is page 400 of the plaint. My lord, I indicated. The only reason it, my lord, stays put is this is, my lord, a listed company. No signature of the directors. My lord, the plaintiffs amongst themselves say that yes, I'll show that document once, my lord, because that is very important for us to indicate how, my lord, they have. This is page 393 of volume 3 of the plaint. With this, my lord, I'll come back to this. My lord. May I only first complete paragraph 29? defendants first manufactured a purported undated deed of settlement in order to assert that there has been a full and final settlement between the parties. Defendants thereafter tried to attack the offices of the plaintiff through hooligans in order to threaten plaintiffs to not to claim any amount. This is absolutely, my lord, unfounded. However, both attempts had failed. Acknowledged their dues even before the court, the criminal proceedings, criminal complaint of the plaintiff. Since all attempts of the defendants to deny the lawful claims have failed, the defendants are now trying to dispose of and alienate or siphon off the misappropriate sums lying in the respective bank accounts. That's what the allegation is, without any substantiation. So Order 38 Rule 5 principles are not touched upon. And thereafter, my lord, kindly see the last 5 lines. In view of the precarious financial condition of the defendants, I pause here for a moment, my lord, none of our accounts have been disclosed. This is a bold averment where it's stated because of the precarious financial condition of the defendants and in view of the repeated criminal offenses committed, there exists immense reasonable apprehension. That's the apprehension there, my lord. And then the bank accounts are given. And then the case for 12-way leave at the last paragraph of page 35. And over the page, the valuation. And then the prayers. Now, my lord, kindly take up once before I indicate from the petition. Can you take up volume 3 of the plaint, my lord, page 393 once? I had indicated this. I'm only, my lord, for recapitulation. I'm just indicating this document. It's a deed of settlement. They say this is the document on which, my lord, they base their entire case. Lord, we are for defendant number 1, APL Metals.
Correct.
Lord, can you take up 393, deed of settlement?
Yes.
We, the undersigned, being directors of Khaitan International PT, that's the plaintiff before your lordship, and Caprio, that's plaintiff number 2, have already received rupees 67 crores from APL Metals and have stated that they have no claim against APL Metals and we have no further claim from APL Metals. Kindly see who has signed this document. It's, my lord, signed by plaintiff number 1 and plaintiff number 2.
No, Khaitan is the plaintiff.
The plaintiff, my lord.
APL
So the
is
plaintiff signs a document amongst themselves where they write that now we, the undersigned, being directors of plaintiff number 1 and plaintiff number 2, have received the sum of money from the defendant number 1 and we have no more claim from the... So, my lord, this, they say, is a forged document manufactured by us. Our signature is not there. Nothing. So, my lord, it is a document made by them, signed by them, which is being contended before the court that it's a forged document manufactured by us. And this was shown during the injunction, my lord, hearing to contend that we have, my lord, committed fraud. A document which does not contain our signature, does not have our name.
Yes, yes.
This is the basis. So, my lord, why I am submitting this is, my lord, 12A, the urgency was pleaded through this. My lord, the order, your lordship's order, my lord, records this categorically, my lord, that this is the, my lord, instance by which, my lord, it was argued by the plaintiff that a fraud is being committed. A document where, my lord, our signature doesn't exist. It's only recorded there that according to them, it's purported, my lord, that undersigned being directors of plaintiff 1 and 2, we have received the money, this, and no claims remain. They say this is a forged document by us only for the purpose that they can't claim money from us. That's the urgency for them. So 12A after Dhanbad Fuels, my submission is that this would not, my lord, fulfill the parameters laid down in Dhanbad Fuels. So the suit has to...
The document which they are relying upon as an urgency, that document itself of the plaintiff, not of the...
My lord, I'm very grateful. That's my submission. And my second submission with regard to, my lord, 12A, but after Dhanbad Fuels, it has become more stringent. So today, my lord, they had to satisfy a lot of criteria which they did not. So, my lord, I'm praying for revocation of that leave. My lord, if that leave is revoked, my lord, my Order 7, Rule 11 has that prayer. Now, next point, my lord, kindly take up the petition once. And more than any judgments on this, I rely on the law, my lord. First, the premise, my lord, as to why I'm making this second leg of submission. Your lordship will kindly take up.
What is your prayer for revocation as well as dismissal of the suit?
My lord.
Rejection of the plaint.
Rejection of the plaintiff. Master summons, your lordship will find plaint be rejected, dismissed, stay of all further proceedings.
Reject proceeding, but you are not paid for revocation.
Lord, revocation separately because we have pleaded that, my lord.
Maybe.
So it will mean, my lord, that we are praying, Lord, that
revocation of.
I understand that, my lord. Kindly take up. I understand what's falling from your lordship, my lord. Kindly take up paragraph 13 once. And after Dhanbad Fuels, I need to, my lord, draw inspiration from the judgment to the extent that, my lord, it's stated in Dhanbad Fuels that for revocation, my lord, the court always has inherent power.
That is
Even, and in Order 7, Rule 11, the court can always
the
take up this.
automobile also says the court can so moto
Lordship,
reject it.
So, my lord, the court, I'll my lord, beseech your lordship to exercise that discretion because of paragraph 13. Your lordship will kindly take up paragraph 13 once.
Yes.
This defendant submits that the plaintiffs have filed instant suit without being complied with the mandatory requirement of undergoing pre-institution mediation and settlement under the provisions of the Commercial Courts Act 2015. However, the order dated 5th of October 2024 does not provide that the said mandatory requirement of 12A has been dispensed with. The plaintiffs should not be allowed to institute the suit without exhausting the mandatory requirement for pre-institution mediation and settlement in accordance with and in such manner and procedure as described by the laws. This is, my lord, the angle. Now, my lord, kindly take up paragraph 6 at page 5, my lord, of the petition. I'll very briefly encapsulate, my lord, the premise of my second submission.
Yes.
Page 5, my lord, paragraph 6. We say, while reading the plaintiff as a whole,
yes.
We'll kindly see 6C. The instant suit is expressly barred inter alia in the provisions of the Negotiable Instruments Act, and no relief in favor of the plaintiffs can be granted in view thereof. Now, the reason is the next page. But the period is indicated 19th November, this is page 6. 19th November 2018 to 9th March 2024, it exported lead metal, and it should be scrap, my lord, not scrap, of diverse specifications, scrap. Iron ore scrap, my lord, at the factory of the defendant from Singapore. My lord, kindly mark this. During the said period, defendant number 1 had been time to time, they made payments against bills of exchange issued by defendant number 1 for such import of goods. And they paid a total sum of 1159 crores. This is this is the amount which we have paid to the plaintiff in the course of the transaction. Mechanism, this is very important. Mechanism for export of the goods by the plaintiff and import by the defendant number 1 was that the plaintiffs used to issue sale contract towards the sale of a particular quantity of goods in favor of defendant number 1. Pursuant to such sale contract, a commercial invoice was to be issued describing the quantity and the value of goods along with the commercial invoice. There's a packing list. I'm not traveling a lot with the next 5-6 lines. Lord, kindly take up from the 6th line thereafter. Payments through bill of exchange only issued by the defendant number 1, which was payable at Singapore. So the bill of exchange was payable at Singapore. Those were the procedures of export of the goods. In the course of such procedures, supply of goods, the defendant number 1 is only entitled to get delivery of the goods from the ship upon payment being made against the full value of goods and clearing the Department of Customs. Sales contract, can you see the last part? No provision in the sales contract. This is the last 2 lines.
Yes.
And the commercial invoice that an interest of 18% would be charged over the page, my lord. Again, the middle, therefore, there was no occasion which arose without making the payment of commercial invoice, and goods would be delivered to the respondent number 1. We've indicated the page numbers, my lord. Commercial invoice are annexed to the plaint. They do not contain provision that the goods would be supplied on credit. Moreover, it has been submitted that during the course of transaction between this period, plaintiff has exported the reiteration, my lord, of the fact that we had paid 1159 crores. Next paragraph, paragraph 8, my lord, they failed to establish their purported claim through commercial invoice. The plaintiffs now have purportedly been contemplated that the personal guarantee executed by the defendant numbers 2 and 3, thereby guaranteeing the credit facilities, one of such purported personal guarantees execute. Details of the personal 2 guarantees are given in this paragraph. Over the page, my lord, kindly take up paragraph 9. Defendant number 1, that upon the plaintiff failing, paragraph 9, failing to establish the purported claim through the commercial invoices, the plaintiffs have purportedly been further
Contemplated the two.
they have contemplated that by 2 separate letters, they have given an outstanding. This paragraph is stated that the outstanding in USD and Indian rupees, they do not match. That's what we've stated here. And this conflicting. Thereafter, my lord, over the page, we have stated that this bill of exchange is what they had raised. And with the bill of exchange, kindly take up, my lord, paragraph 14 at page 10. I'll not trouble your lordship with the details in this. The page numbers are indicated. Paragraph 14, page 10, my lord, is the point. However, the 4th line, my lord. May I read from the beginning? This, my lord, is important. The alleged bills of exchange annexed to the plaint were drawn by the banker in India and accepted by the plaintiffs payable of their banker in Singapore and dishonored. However,
the alleged bill of exchange annexed to the plaint were drawn by the banker of the defendant in India. And accepted by the plaintiff payable to their banker in Singapore. So, the payment,
dishonored.
Where the payment was made in the India?
No, my lord, it was presented in Singapore. So, my lord, that however, plaintiffs did not protest such dishonor and did not give notice in accordance with law, because, my lord, we had prepared the bill of exchange here. We sent it, my lord, to Singapore. It was dishonored. Now I'll show, my lord, from this.
The bill of exchange was executed here. No,
executed is prepared here, my lord.
Prepared here.
And sent in Singapore. So, my lord, there is a particular procedure which they have to follow, which otherwise discharges us completely. That, may I just pause here for a moment and show that provision first, that I've handed over with a flag the Bill of Exchange Act of Singapore.
Correct.
1949. The notice of dishonor and effect of non-notice. But first, may I request your lordship to once take up, my lord, the index. Because there are separate heads. I'll just indicate, my lord.
Index.
The arrangement of sections, the first page, my lord. Lordship will find after the preliminary bills of exchange, form and interpretation is, my lord, 3 to 21.
Yes.
Then capacity of the parties is from 22 to 26.
Yes.
Consideration of the bill is 27 to 30. Negotiation is 31 to 38. 38 is, my lord, the rights of the holder. So that is, my lord, important. General duties is what I am on, my lord, 39 to, my lord, 52. I will be relying on 48 and 49. 45 is, my lord, rules as to presentment for payment. 47 is dishonor by non-payment. 48 is notice of dishonor and effect of non-notice. This is very important. So today, my lord, if there's a dishonor, there has to be a notice. If there is no notice, what happens is, my lord, laid down in section 48. But kindly take up that provision once. But 48, yes. Subject to the provisions of this act, when a bill has been dishonored by non-acceptance or by non-payment, notice of dishonor must be given to the drawer and each endorser, and any drawer or endorser to whom such notice is not given is discharged. Kindly mark this, my lord.
So like 138.
Very similar, but I will not be arguing 138, my lord, because of a judgment delivered by the Supreme Court yesterday. Carrying that, I will not, my lord, make that submission. I'm handing over a copy. This is, my lord, delivered. It was uploaded, I think, yesterday, my lord. Lord, there, my lord, it is where the bank is there, so, my lord, of the pay. So I wanted to place that and distinguish that before, my lord, my learned friends start placing reliance on it. My case is different, my lord. My case is entirely different. Lord, 48.1 is what I'm basing my submissions on. Lord, that in case this notice is not given.
So this is mentioned at paragraph 14.
My lord.
Paragraph 14.
Paragraph 14, my lord. Paragraph 14 is to be read with, my lord, section 48 of this act.
That's why.
My lord.
This
Lordship.
You are mentioning with regard to the paragraph 14 because the dishonor, no notice.
And no notice. No. And from the plaint, my lord, they have not disclosed anything. They have not made any averment.
Okay. Yes.
But kindly also permit me to read 48.2, where a bill is dishonored by non-acceptance and notice of dishonor is not given. The rights of a holder in due course subsequent to omission shall not be prejudiced by the omission. So, my lord, whatever steps they have to take in those courts, my lord, which have jurisdiction to decide this. That is why, my lord, Order 7, Rule 11. On this premise, my lord, kindly take up and, my lord, permit me to read paragraph 14 again. These are the two provisions I'm placing reliance on, my lord. In the plain, there is no pleading. My lord, this is the middle of the page.
Yes.
Since the alleged bills of exchange are made payable in Singapore, the laws of Singapore, where it is made payable, determines what constitutes a dishonor and what notice of dishonor is sufficient. That's because 48.2. In the plain, there is no pleading against such alleged dishonor of bill of exchange, and no notice for such dishonor ought to be issued in terms of the law of Singapore disclosed in the plaint. Therefore, the instant suit filed by the plaintiffs is beyond the jurisdiction of the court. And we have taken one more point, my lord, that's paragraph 15, with regard to, my lord,
if it is okay, if it is there, lacuna, why it is not commercial?
It's not
bill of exchange.
My lord.
Okay, the notice was not issued.
My lord, if the notice is not issued, the cause of action does not arise.
Cause of action does not arise.
But that's my submission. It's not my submission that, my lord, it's whether it's a commercial dispute or not. No, that's not my
line.
No, that is wrong. That's not my submission. My submission is that commercial dispute I'm not arguing.
That's no, because
indeed I have seen that, my lord. I've seen that. That's why, my lord, wholly beyond the jurisdiction of the court, commercial division of this court. That's perhaps not right. It should only be, my lord, the honorable court. Because my case is, my lord, that under Order 7, Rule 11A, the cause of action would only arise with the notice.
Correct.
No notice, no cause of action.
That's
and to what extent that notice would suffice, my lord, the act of a cause of action would be determined by courts in Singapore because of 48.2. That even if there is an omission, what is the extent of the omission will be decided by those courts. These are my very respectful submission, my lord. I had placed Dhanbad fuels on the, my lord, first day when I made the submissions. I know, my lord, your lordship has read this more number of times and my lord knows this much better than I can try even
no
to
problem.
Make submissions on.
You submit.
So, my lord, Dhanbad fuels is only, my lord, to that extent that the law has now been settled with regard to 12A. It's a money suit, money claim, purported money claim, my lord, where there's an interest component. So, if there's a failure, it can't be contended by them.
So you are arguing on 62F.
F. My lord. That's my submission. These are my submissions.
Thank you.
So, two legs, basically, my lord, one 12A and one, my lord, the cause of action. I'm very deeply obliged.
Come back, my lord, next week, my lord. I do not have this act.
I'll hand over a copy.
Bill of Exchange Act Singapore. Although, my lord, my overall my submission would be plaint has to be read. Nothing else. That is all. In Order 7, Rule 11, my lord, nothing much can be looked. But my lord, I'll come back. My lord, the lord will keep it next week, my lord.
Only for, my lord, clarifying to what my learned friend is submitting. I have not, my lord, indicated anything beyond the plaint. Not one line beyond the plaint.
2 points he has raised.
Only 2 points.
Urgency, I'll satisfy. I have the necessary
Urgency
pleadings.
and with regard to this bill of exchange.
The Bill of Exchange Act.
If it is not dishonor, where is your cause of action? That is the main point.
Dishonor, I'm not suing on the dishonor. I'm suing on the outstanding payment which has been
then outstanding is of the view if it is Singapore, how this court has.
Well, I'll have to meet that. Well, should give me some time.
Okay.
Next week. But there is also another application which has come up today, GA5. That is
That's the Order 39, Rule 4, which we have filed.
The
now.
vacating application of the injunction, which is
of the
passed
injunction.
almost a year back.
But not if this is heard out, my lord, and then, my lord.
No, if you want to argue, then both can be taken together. That be no.
I'm only, my lord, expecting. If my learned friends do not meet up this point, perhaps I'll not be required. And only this expectation.
I'm expecting that I will be able
Of course, we have different expectations. That's obvious.
But court is silent now.
I'm very deeply obliged for the patient.
Or Lordship may pass directions for affidavit on GA5 and keep GA4 pending, or Lordship may hear GA5 after your Lordship decides GA4.
Let it be decided.
Very well, my lord.
If suit remains otherwise,
my lord, otherwise
exercise will futile. Counsel for the defendant number 1 has concluded his argument in connection with GA4 of 2025. Counsel for the plaintiff prays for time. According case is adjourned. Let the matter appear on 19th August.
I'm deeply obliged. Grateful.
Your Lordship, I am appearing on behalf of defendant number 2, Your Lordship.
Yes.
Yes.
Defendant number 2.
Yes, Your Lordship. The partnership firm, I'm one of the director. I'm one of the partner. Niket Saraf. Defendant number 3 has already expired, Your Lordship.
Which
Your
is the
Lordship, it is
plaintiff?
I was appearing for one of the proposed defendants. Mr. Ghosh was leading me. We have completed.
Yes. Plaintiff has to give answer.
Yes, Your Lordship. I think if Your Lordship wishes, we can, a short pass over.
Pass over.
Six is my application. There are two applications, one by the plaintiff, one by the defendant. On both the last two occasions, my lord, the defendant has taken adjournment and has not done the matter. But this is that matter. Just to recapitulate, my lord, initially when the defendant submitted that they will not be pressing the point for 12A or the section 10 point, only the vacating point. So your lordship was of the opinion that since your lordship is hearing out the injunction application after completion of affidavits, everything will be decided threadbare on the injunction issue. And the vacating need not be otherwise separately considered. Everything is there. So, my lord, may I just place it? But if your lordship kindly takes a look at my application. We are not having.
Yes, where is Mr. Banerjee? You are appearing.
I am being led by Mr. Banerjee. He is there at court 39. If your lordship kindly give a short pass over. Mr. Banerjee is on his legs. He's coming.
May I just start with just to recap?
IA2, if lordship please to take it first.
What is IA? What is IA2?
That is the vacating.
And IA1? GA1?
On the essential counts. Look, I'll section 10 point I won't argue, but the commercial suit point your lordship will allow me to address, because I checked up, my lord. Even your lordship is aware of the recent Supreme Court decision that even if I have to address your lordship on the question of interim order, the court has to look at the maintainability. And it's not a point that today my previous lawyer has given up or I can give up. It's a point that somebody can take at any point of the suit, because it actually goes to the root of the issue. It's the jurisdiction of the court. So I'll just place that, my lord, with regard to two aspects to my really vacating application. One is that this is not a commercial suit. In the event your lordship holds that this is a commercial suit, there's also a prayer that the leave under section 12A that has been granted be revoked. So on both, I'll address your lordship. I think your lordship has a matter fixed at 11:30. This will take a little time, but I can start immediately, my lord. Lord, may I just beseech your lordship to have a look at the plaint? I'll first address your lordship on the ground that this is not a commercial suit at all.
So you are arguing on 2, J2.
J2. Look, the plaint is at page 7 of my supplementary affidavit.
Would I take your lordship's leave for?
Yes.
So the suit is for recovery of money on the basis that the loan was granted by the plaintiff in favor of the solitary defendant, on the basis of an oral agreement. These 3 paragraphs I'll show and come straight to the judgment. Your lordship has held and just rely on one decision. Kindly have a look at paragraph 3. The plaintiff is an NBFC.
Yes.
That is paragraph 1.
Yes.
Paragraph 3, my lord, if I may. The defendant sometime in the month of September 2012 approached the plaintiff at his registered office situated outside the jurisdiction of this honorable court through a finance broker seeking financial assistance and or a loan. Upon enquiry, the defendant disclosed that he has an urgent requirement of rupees 1.5 crores for his business purpose. It was specifically undertaken by virtue, kindly mark this, my lord, of an oral agreement that the defendant, he shall repay the loan on demand, and till the time the same is repaid, the said amount shall bear an interest of 15% per annum to be calculated and paid every 4 months. Such undertaking was given by the defendant in presence of the finance broker, namely so and so. On enquiry, my lordship will not be troubled by that. And paragraph 6 is pursuant to the undertaking and agreed terms of loan, the defendant started paying 15%. So his agreement that he refers to in paragraph 6, based on which the payment is made, is in paragraph 3 of the plain.
Oral.
But one more paragraph, if I may just place. 7, kindly see. So basically 7 and 8, 2 notices are mentioned. That after his demand was made, because he says loan, verbal agreement, payable on demand. Paragraph 7 and paragraph 8 are 2 notices which are the demand. These 2 legal notices. My lord, if your lordship gives the rest a cursory glance.
Yes.
Except paragraph 15, there is no pleading as to why this is a commercial suit either. I'm not saying it has to be pleaded, that's not really, but at least if your lordship looks at from the perspective of now 12A being revoked, kindly have a look at paragraph 14 and 15. The plaintiff has been able to ascertain the bank account operated by so-and-so. Defendant is contemplating to siphon off all monies lying in the above account to the prejudice of the plaintiff. The defendant is trying to evade any connection made by the plaintiff. Under such circumstances, there is an imminent threat to the plaintiff's claim, and the defendant, in order to defeat the claim of the plaintiff, might dispose of the assets of the defendant existing as on date. The plaintiff contemplates of taking out applications in connection with this suit, seeking urgent relief, praying for protection against the defendant's intention and tendency to defalcate and evade the payments due to the plaintiff, thereby securing the claim amount. 15, in the circumstances pleaded, paragraph number 4, there is an extreme urgency and urgent reliefs are required to be claimed in the suit. As such, the plaintiff plays for leave under clause 12 of Commercial Courts Act. Lord, please have a look at paragraph number 19. Lord, I understand that this suit was filed in 2021. With regard to Commercial Courts Act, it had not really crystallized. These aspects of law had not really crystallized as it now has been. But this, when the Supreme Court or your lordships lay down the law, it's the law as it always has been, unless the judgment specifically provide that it's prospectively overruling. Please have a look at paragraph 19, Manoj. The cause of action of the above suit has arisen firstly on February 25th, 2019, when the demand for entire payment was made by the plaintiff, and then on 16th August 2019, when the defendant refused to pay. So there is, and Lord, one more aspect, Lord, I must be candid. We've been, at least I have been slightly enriched by reading a judgment passed by your lordship recently. There are no reliefs of any injunction in the plaint. The suit is for a specific recovery of money based on an oral agreement, purportedly repayable on demand, carrying certain interest. The 2 documents which are disclosed are the notices which have been issued by the lawyer making the demand for repayment of the loan. So 2 aspects, my lord. Firstly, although this may be a banker or because it's an NBFC, there are no mercantile documents. Suit on the basis of an oral agreement does not fall within the Commercial Courts Act for recovery of money.
Yes.
First point, my lord. If I'm unsuccessful, in the unlikely event I'm unsuccessful on this point,
Then with regard to section 12A, the leave that has been granted, there is absolutely no cause of action disclosed for immediate relief that is being sought. Lord, on merits also I'm covered by a decision of your Lordship, because your Lordship has recently held that when in a commercial suit, slightly unlike a regular suit, you have to disclose whatever documents you have as a mandatory.
Correct.
So when you're asking for an attachment before judgment or injunction, you have to come and disclose documents in support of your plea that I'm actually trying to siphon it off. If I don't have it, then it's a bald assertion. And he becomes an unsecured creditor, trying to make himself secured based on the 2009 judgment, all of that. So the second point is, there is nothing, no prayer for injunction in the plaint. There is no ostensible urgency pleaded in paragraph 19. The cause of action is pleaded to have arisen in 2019 and the suit is filed in 2021. Even if it is taken to be a commercial suit, why the mandatory provision of section 12A is to be given a go by, that is also not mentioned. There is nothing mentioned here, because I'm going strictly by the plaint. On the first aspect, that it is not a commercial suit. Lady Moon. এটা আবার কি এনেছো? কি দিলে? দর্শককে ঠিকঠাক দিয়েছো তো? So that this is a very off-cited, I will not waste the time of this court. I'll just come straight to the paragraph which is there.
Yes.
Paragraph 11, commercial action is referred to. "12 onwards, if your Lordship will allow me to place. No, 12 is, I'll just place these 3-4 paragraphs. The Delhi High Court in Kailash Devi Khanna
Not necessary. Not necessary.
This, your Lordship has also extensively held in another decision.
Not necessary. Yes. This is regarding mercantile document.
Just paragraph 15 once I'll place.
Okay, okay. No.
Just paragraph 15, I'll not trouble your Lordship with the rest. The case law on the subject would indicate that a mercantile document is a document used in a transaction or in relation to a transaction between merchants, bankers, financiers, and traders. In the present case, the statements in the plaint make it clear that the plaintiff lent money to the defendant by way of an oral understanding without formalizing or reducing such understanding in writing. The plaint does not plead the existence of an agreement, much less a written agreement involving a mercantile document. Then it is held that because it's an oral agreement and it does not naturally relate to a mercantile document, the court goes into a slightly higher scrutiny because it looks at in relation to and interprets in relation to be absolutely an integral part of the cause of action to file the plaint. It's too settled, I'm not troubling your Lordship with that, but that's why I pleaded the plaint. The plaint is only cast on the basis of a verbal agreement. There is no even nothing, no reference to any other document except those 2 documents given by the lawyer. This is on the first point, that if it's an oral agreement, it can't be a commercial dispute. Second, that leave under section 12A, that also could not have been granted in these facts. This is, knowing your Lordship's memory, this is perfecto electricals.
Recently.
This also I'll just place, my assessment of the bench will remember it. So I will just read the last 2-3 paragraphs,
Yes.
"23, if your Lordship just has a look at. Before that, your lordship has considered the entire law and traced how the law has developed.
Yes.
23, kindly have a look at. In the present case, though the plaintiffs have prayed for leave for dispensation of the provision of Section 12 of the Commercial Codes Act 2015, but considering the plaint as a whole, the documents relied by the plaintiffs and the cause of action for filing of the suit, this court finds that initially on the same cause of action, the plaintiff has filed an application under Section 9 of the Arbitration Act on 7 December, and on dismissal of the same, the plaintiff has filed a suit before the Alipur court on 20th December 2018, and after withdrawal of the suit on 10th October, the plaintiff has filed the present suit on 21st May 2022. The plaintiff, well, this line I'm relying on, the plaintiff also not prayed for any interim urgent relief in the plaint. Thus, from the facts and circumstances of the present case, this court finds that a judgment relied by the plaintiffs in the case of Srishti Infrastructure, this is distinguishable. The judgment relied by the defendants in the case of Mazhar Hussain and ASA International are squarely applicable in the present case. In view of the above, this court did not find any contemplation of urgent relief. Then your lordship looks at Order 7, Rule 11, paragraph 26. Kindly have a look at, Milord. Here also your lordship has seen the plain. There is actually no explanation for seeking dispensation when the admitted cause of action, so-called, has arisen in 2019. The suit is filed in 2021. Why I placed 23 is, at least in this matter, the judgment, they had approached different courts. First Section 9 and then withdrawn, then another suit. That they had done something. Here nothing and no pleading also. Paragraph 26, Manoj. In the present case, though at the time of presentation of plaint, this court granted leave for dispensation of requirement of Section 12 of the Commercial Court Act, but on receipt of writ of summons, the defendant number 2 filed the present application for revocation of leave and for rejection of plaint. The plaintiffs have given an opportunity of hearing the present application, and plaintiffs have also filed the affidavit in opposition to the present application. Considering that the above, this court finds that the issue raised by the plaintiffs, that there is no provision for revocation of leave, is not sustainable in view of the provisions of Order 7, Rule 11 of the Code of Civil Procedure. Lest they take this point that this revocation is foreign to the Commercial Codes Act, it does not really contemplate revocation. Paragraph 26. But 27 also, in view of the above, leave granted for dispensation requirement of 12A dated so-and-so is hereby revoked. GA number 2 is allowed, similar to mine. CS number so-and-so is dismissed. One last judgment I'll just refer to, my lord, is your lordship judgment, where this issue has now come about because of the division bench judgment, where what will happen under clause 15, I mean section 12A and section 15 and the interplay where I filed without. I'll just rely on this, my lord. One passed by your lordship on 25th of July 2025. Only for the aspect that the plaint has to be returned. So on that, so it will become an Order 7, Order 7 Rule 10 situation. So if Order 7 Rule 10 happen, then the injunction also naturally it expires by dint of law, because the suit itself is carried from one jurisdiction to the court that has jurisdiction to try it. Well, this judgment is only to buttress that submission, where your lordship considers the division bench judgment in Harshvardhan Khemka. In view of the judgment passed by the Honorable Division Bench at paragraph 3, the plaint along will be returned. So my first point is it's an oral understanding. It's not on the basis of a document, so it's not a commercial court. In the event your lordship holds against me, then leave under 12A be revoked, whereas there is absolutely no pleading why it should be. There are no urgent reliefs claimed in the plaint. Simpliciter mentioning that I will claim is not enough. You have to explain why you are, after all, a mandatory provision in law, which now your lordships have held consistently. And if your lordship finds favor with what I'm saying, then the plaint has to be returned. Well, these are my respectful submissions on this aspect.
Thank you.
But that at the time of that Ashma Latif judgment, my lord, that at the time of injunction also, that I'm not.
Counsel for the defendant has concluded his argument in connection with GA2 of 2021. Due to paucity of time, counsel for the plaintiff could not argue the matter. According case is adjourned. Let the matter appear on 20 August. 20 August.
Deeply obliged, my lord.
Grateful.
But I appear for defendant number 2 and 3.
Yes.
But on the last occasion, I was placing my argument, and my lord, that was not completed.
Yes.
My lord, I have already covered, my lord, certain issues on the last occasion, my lord. Now, my lord, I start, my lord. Once, my lord, the issue number 6, that is, my lord, regarding the delay part. My lord, that is, my lord, issue number 6 is, my lord, whether, my lord, the issue number 6,
yes,
my lord, has your lordship got it? My lord, whether the issuance of notices dated July 3, 2013, January 30th, 2014, and February 19/21, 2014, and issuance of notice of termination dated March 5, 2014 were justified, reasonable, and warranted in the facts and circumstances of the instant case.
yes,
Here, my lord, the notices were given, my lord,
yes,
when the plaintiff did not complete the project, and there was delay on the part of the plaintiffs. In this respect, my lord, the defendant on several occasions, my lord, by letter requested to the plaintiff to complete the project at the earliest. And in this respect, my lord, there were several letters were issued. Those are, my lord, exhibits 14, 18, 15, 16, 17, 19, 7, 21, 10, 22. So these are the letters, my lord, by which, my lord, the defendants railway always
exhibit.
These are the exhibit 14, my lord. May I?
Yes, exhibit 14.
Exhibit 14, 18, 15, 16,
18,
14, 18. Then, my lord, it is 15, 16, 17, 8, 19, 21, 10, 22. My lord, not chronologically, my lord, stated here.
Yes.
These are the, my lord, exhibits which have been marked.
These are the notices.
These are the notices. By these notices, my lord, the defendants, my lord, always, my lord, vigilant and, my lord, requested that the plaintiffs to complete the project. So delay is on the part of the, my lord, the plaintiffs to complete the project. Lord, the issue number 8 is the regarding the invocation of this bank guarantee, my lord, the encashment of the bank guarantee. My lord, the bank guarantee, the performance bank guarantee, my lord, this. And before that, my lord, issue number 7, if I place, my lord, in short.
So, issue number 6, these are the notices.
These are the
You have issued the notices to the plaintiff,
my lord,
requiring the plaintiff and informing the plaintiff that the time period is going to be expired or expired for completion of the work as early as possible. So, he has not completed the work. So, you have justified in terminating the contract. This is your submission.
Yes, my lord. That is my submission, my lord. My lord, may I place those letters, my lord, those exhibits?
Not mention the
mention.
You only mention the exhibits.
Yes.
And what is your submission? Then it is enough.
So I am, my lord, summarizing that, my lord, that is
No
my
problem, no problem. And what about the issue 7?
The 7, my lord, whether the subject contract stood discharged in the facts of the case and plaintiffs accordingly stood absolved from any further performance of their reciprocal promises under the subject contract. Here, my lord, the railway submits that plaintiff deliberately and negligently failed to complete the project under the subject contract despite granting 2 extensions by the defendant railway to the plaintiffs for completion of the said project. Hence, the plaintiffs cannot be absolved from liability of the performance of their reciprocal promises under the contract. Then, my lord, issue number 8, it relates to the, my lord, the encashment of the bank guarantee. The issue is the whether the invocation and encashment of the defendant number 2, that is railway, of the
Now,
bank.
what is your answer to the issue number, whether subject contract is to discharge
My
in
lord.
the facts of the case and the plaintiff accordingly stood absolved from any of the performance of their reciprocal promises under the subject contract? What is your answer to that?
So answer, my lord, thereafter in that next paragraph, I have said that the defendant railway submits the plaintiffs deliberately and negligently failed to complete the project under the subject contract despite granting 2 extensions by the defendant railway to the plaintiffs for completion of the said project. Hence, the plaintiffs cannot be absolved from liability of performance of their reciprocal premises under the subject contract. 2 extensions were granted. 17 months were extended. 27 months were the original time given, my lord, and thereafter by extension there were 17 months further granted. So even then, my lord, it was not completed, and that was the reason the termination of the contract.
Yes.
My lord, the issue number 8 is the, my lord, relating to, my lord, the invocation and encashment of the defendant number 2 of the bank guarantee furnished by the plaintiffs. My lord, the bank guarantee was amounted, my lord, 61,53,350, being the 5% of the contract value.
Yes.
And my lord, this was encashed, my lord, because there is a provisions, my lord, in, my lord, the contract that the, my lord, the due to failing to complete the project under the subject contract by the plaintiff, the defendant railway, after serving 7 days and 48-hour notices dated 31st January 2014 and 19/21 February 2014 respectively, and termination notice dated 5/3/2014 as per clause 62 of GCC 2001, terminated the contract for the said project, and in terms of clause 157 of chapter 6 special conditions of contract had encashed the performance bank guarantee of rupees 61,53,350. Such encashment of the performance bank guarantee was made in terms of clause 1.57 of chapter 6 special conditions of contract, part 1 of the contract agreement, which provides that whenever the contract is rescinded, the security deposit shall be forfeited and performance guarantees shall be encashed, and the balance work shall be got done independently without risk and cost of the failed contractor. Accordingly, after the said termination of contract dated 5/3/2014, the defendant railway has encashed the performance bank guarantee of rupees 61,53,350. These provisions, my lord, already in the contract. My lord, that is the special conditions of the contract, chapter 6. My lord, I am not placing, lord, that is there in the record. My lord, here what happened, my lord? It is pertinent to mention here that before termination of the contract on 5/3/2014, the plaintiff have filed the instant suit on 4/3/2014, praying for inter alia for stay of encashment of the performance guarantee amounting to rupees 61,53,350. The plaintiffs had obtained an interim order of injunction from encashment of the said performance bank guarantee from the single bench of the this honorable court, and the said order of injunction against encashment of the performance bank guarantee was vacated on 30th of September 2019 by the division bench of this honorable court. The plaintiff preferred a special leave petition to the Honorable Supreme Court of India against the said order of the Honorable Division Bench, and the Honorable Supreme Court of India has dismissed the said special leave petition. Thereafter, this encashment was made. My lord, the issue number 9 is in the event the answer to the previous issue be in negative.
SLP is filed against which order?
Against the order of the division bench, vacating the interim.
What was the finding of the division bench?
My lord, the division bench, the finding is
because the Supreme Court has not passed any findings, only dismissed.
No, detailed judgment is there. Very detailed judgment is there.
Where is that?
Can guarantee judgment, my lord. That I'm get it, my lord.
That invocation of bank guarantee they have challenged.
Yes, revocation of the bank guarantee. Invocation of the bank guarantee, my lord. My lord, the invocation of the bank guarantee they have subsequently by amendment of plaint have challenged.
No, what was how the division matter went to the division bench?
My lord, after filing a suit, they made a interim application, interlocutory application for an interim order for injunction against the invocation of the bank guarantee.
Correct. That's why I'm telling.
And
so that by which order this court has rejected that application?
My lord, by the learned.
This court single bench had restrained the railway from invoking. They had preferred an appeal. After a exhaustive hearing for several days, the court division bench found that it's a separate contract, so they can invoke. Now, challenging that, we went up to Supreme Court. By the time as they had already invoked, Supreme Court said that it's already been done. So, the appeal, the order was not interfered with. Coming back, we filed an amendment appeal actually adding to our claim. Now, that amendment was allowed by the learned single bench, honorable single bench, upheld by the honorable division bench. No appeal thereafter. Their appeal was dismissed in division bench from the amendment.
Here, my lord, the invocation of the bank guarantee after the interim order passed by the honorable single bench, my lord, it was vacated by the division bench, then it was incast. My lord, then, my lord, my lord, the issue number 10, the issue number 9, my lord, before that, in the event the answer to the previous issue be in the negative, to what sum or sums are the plaintiff entitled towards such compensation for loss and damage suffered by the plaintiff as a result of the invocation and encashment of the aforesaid bank guarantee. This was the one of the issue. Answer is, my lord, the defendant railway submits the performance bank guarantee of rupees 61,53,350 was encashed in accordance with the provisions contained in clause 1.57 of chapter 6 special conditions of contract part 1 of the contract, which provides that whenever the contract is rescinded, the security deposit shall be forfeited. Here the contract was rescinded, so security deposit, but there was injunction. That is the reason it could not. After that was vacated, my lord, it was, my lord, incast and shall be forfeited, and performance guarantees shall be incast, and the balance work shall be got done independently without risk and cost of the failed contractor. As such, the performance bank guarantee was rightly incast, and the plaintiff would not be entitled for any refund of the sum of the said bank guarantee. The issue number 10, whether the plaintiffs have become entitled to compensation for the loss sustained by the plaintiff in the facts and circumstances of the instant case. The defendant railway submits that these plaintiffs are not entitled for any compensation in the instant subject contract. Rather, the plaintiffs are liable for payment of loss and damages sustained by the defendant railway for non-completion of the said project. The plaintiffs failed and neglected to complete the project despite granting 2 extensions by the defendant railway to the plaintiff for completion of the said project. The plaintiff, instead of completing the project by their later date 14/2/2014, being Exhibit NN, has stated that the contract may be kindly closed without any liability on either side under force majeure clause as per clause 61 of GCC.
Exhibit 10.
They have
Exhibit 10.
Exhibit. This is below Exhibit NN, capital NN.
LNN.
N double N, my lord. My lord, kindly to.
Yes, NN.
Should I please?
No, no, it's okay.
Then, my lord, issue number 11. They wanted to close the, my lord, this contract under the force majeure clause. That can't be, my lord. And then, my lord, issue number 11. What sum, if any, are the plaintiff entitled to in the facts and circumstances of the instant case? The defendant railway submits that the plaintiffs are not entitled for any sum in the facts and circumstances of the instant case. The reasons thereof have been stated above. Lord, issue number 12. Whether the defendant number 2 is entitled to its counterclaim, and if so, to what extent? This is my counterclaim starts now, my lord. The defendant railway submits that since the plaintiff failed and neglected to complete the project, that is the bridge, despite granting 2 extensions from the defendant railway to the plaintiff, the defendant railway by its termination letter dated 5/3/2014 terminated the subject contract. After termination of the subject contract, the defendant railway invited fresh tender for completion of leftover work of the said project. Normally, bidders are not inclined to bid for leftover works. Hence, in the instant case, none had submitted any bid for completion of the leftover works. As such, the defendant railway had no option left except to abandon the existing work and shift the alignment of the said project to a different location. The defendant railway has suffered loss and damages due to non-completion of the said project to the extent of rupees 14 crores 68 lakhs 55,865.93 as per the following particulars. The particulars has been given, my lord. Serial number 1, that is, my lord, the more expenditure due to the increased cost value of the second contract. My lord, the original contract was about 12 crores and odd, and the, my lord, the fresh contract was, my lord, 22 crores. So there is
but there is the work site which has been allotted to the plaintiff. Plaintiff has executed some extent of the work, and thereafter he has made abandon, and you have called for the first tender. But none has appeared, none has participated in the said tender, and your authority has abandoned that. Correct. So, so how you claim the compensation or damages from the plaintiff on what basis? If that work has been abandoned by you, other parties have not come forward for complete the work. So on what basis you have raised the counterclaim of the 14 crore?
It has been raised, my lord, the difference. The difference of the cost.
What difference? Because you are giving the difference of the cost which you have given the another work not on the same site. Please take note of it. The work which has been allotted to the plaintiff, that none of the contractor has come forward to complete the work. If suppose some other contract come forward, executed the work on and above the contract work which has been awarded to the plaintiff, there was some argument on your side. But none of the contractor has come forward for complete the remaining work which the plaintiff left. Correct. And that's why your department has abandoned that work.
Compelled to abandon. Compelled to abandon.
Whatever it may be, compelled or not compelled, because the plaintiff is not, it is not your case, the plaintiff has restrained the other contractor to participate in the tender. It is not your case. or there is no complaint that the plaintiff has restrained any of the contractor to participate in the tender. It is not your case. Simply you have published the tender notice
for leftover works.
For the leftover work, but
When
none
no
has
bid
come
is received,
forward.
no bid
No
received,
person has come.
then
So
it was
your
abandoned,
department find that
and a
nobody is
different location nearby was allotted.
So you have shifted.
Shifted to
You have shifted the said work to other place.
other.
If you have shifted the workplace to other place, how you can assess the damages on that?
Here, my lord, the originally contract was given to the plaintiffs in
Correct.
2010.
Correct.
And the plaintiffs has to complete within 27 months.
Correct.
My lord, therefore, my lord, if the plaintiff had not completed, and then, my lord, the railway defendant was compelled to take further step for completion, and for that, the after termination, invited bid for leftover works. No one participated in the bid.
Correct.
They abandoned the project. Abandoned that site, and adjacent site a fresh tender floated.
Correct.
So it was in fresh tender, my lord. This the value which was my lord the confirmed. It is the 22 crores rupees of that project.
Correct.
And therefore the virtually, my lord, the loss of railway was about 10 crores. So that is the loss occurred due to the, my lord, the plaintiffs, my lord, the negligence to complete the project.
If you go by the another side, this is your one aspect. You go by the another side. Whatever the you have not gone through the evidence and the hearing subject to hearing of the plaintiff's counsel. If it is the case of the plaintiff that it is not possible for the plaintiff to execute the work, and that's why he has given a request to you, he is not interested to complete foreclosure of the work. He has given the letter, and on the basis of the foreclosure, without any liquidation, you have foreclosed. Without any liquidation and liquidated damage, you have foreclosed. Without any risk and cost.
Without any financial repercussions.
That's a risk and cost or financial repercussion. You have foreclosed and you simply have allowed. If you are simply allowed, and subsequently the other persons have come, you have issued the tender, none has come. So what the court will taken into consideration? What circumstances the court has to taken into consideration?
This assessment of loss has been made on the basis of the cost incurred by the railway in completion of the project. Originally, it was given to the plaintiffs, and plaintiffs.
That's what I'm telling again and again. It is not your case. The leftover work was completed by the other contractor. Then your case would have been different. If your case would have been different if the leftover work has been completed by this other contractor. So, and for the 14 crore, the other contractor has taken further 20 crore. That's why the 10 crore is difference. The 10 crore is the damages. That court can understand and that can be taken into consideration. But the said work none has come forward for complete the said work. How you justify that?
This is subject to the assessment of the honorable court, my lord.
No, not court will see damages. Court will not can see for the damages. It is to the law point the court can, but for the assessment of the damages, it is for the parties to bring on evidence to prove that yes, this is the damage caused and entitled for the damage.
So far, my lord, this amount has been placed here, my lord. The railway from its account has paid for this much amount, 22 crores for the project. And that is the reason after that amount spent and the amount in the original contract, making minus to that, whatever the coming, it has been placed here.
Correct.
Okay. Then, my lord, I have said, my lord, proportionate share of the railway personnel expenditure, including expenditure for organizing and other works for second tender estimated. Here, my lord, the workforce and the authorities and the manpower which railway engaged in completion of the second, my lord, this tender, second, my lord, after the failure of the completing this first contract, my lord. Therefore, the manpower cost and other cost, my lord, that has been, my lord, because the railway paying salary to the employees. So they are giving time to these all these things. So therefore, it has been estimated, my lord, 20 lakhs rupees towards the cost of the salary and others for the railway employees incurred for completing this project. And my lord, third, I have my lord, claimed loss of revenue due to slow train movement, both goods and passenger train, resulting loss in railway revenue estimated. So here, my lord, 3 crores 50 lakhs rupees. My lord, this is the claim made, my lord. My lord, if the project would have completed, my lord, in 2012 or 13, my lord, then, my lord, the third line would have been operative, and the goods train and passenger train could have availed of, and then, my lord, the railway would have earned, my lord, that freight and my lord, the fare from the passengers, my lord. So that, my lord, remained for 10 years lagging. So, my lord, for 10 years, my lord, the railway, that is, my lord, the mineral areas, that is that area, my lord. So the lot of minerals are carried from the goods train, my lord, and therefore the railway in this way, my lord, has suffered loss of 3.5 crores. That has been, my lord, I have placed. And, my lord, the fourth is, my lord, loss due to loss of image due to non-completion of the project. That railway is lagging, not completing project on time. So all these things, my lord, I have suffered a loss of 1 crores for this loss of image of the railway. So total, my lord, is
How you assess the image of the railway?
My lord, my lord, this, my lord,
you are not the private body.
Not private body, but railway is answerable, my lord, because in Parliament also question raised, my lord, why the railway not completing the project. So many questions are raised to image, my lord. That's why the, my lord, this is claimed, my lord, 1 crore, and total is, my lord, 14 crores 68 lakhs 55,865.93. This is the total counterclaim, my lord. My lord. Then the defendant railway further submits that the defendant railway invited tender to carry out the said project at new location to expedite the project, which was badly delayed, and the defendant railway changed the methodology of construction from well foundation to pile foundation. The project at the new location was completed in the year of 2019.
What was the time of completion of the second project, the shifted site?
My lord, shifted site, my lord, it was.
What was the original time period was given to the original contractor?
My lord, in second project, my lord, it was started on in the year of 2016 and completed in the year of 2019 within 3 years.
No, what was the time period given to the contractor in the tender work? When the work was awarded to the second work, the shifted work, what was the time period given in the original contract? And how much extension was given to that contractor?
My lord, that is not part of the, my lord, is here, my lord, in the written statement here. My lord, in that, my lord, if so, my lord, required, my lord, my client will place that. My lord. That is it started the, my lord, the second tender work on second tender, my lord.
Okay.
This
next,
and then, my lord, issue number 13. To what other and further reliefs are the parties entitled in the facts and circumstances of the incident case? The defendant railway submits that the defendant railway is also entitled to claim interest on the amount determined in counterclaim of the defendant railway by this honorable court. Further, the defendant railway is also entitled cost of the instant litigation from the plaintiffs, cost and interest. And, my lord, issue number 14, whether the suit is barred by principle of waiver, estoppel, and acquiescence. The defendant railway submits that the instant suit is barred by the principle of waiver, estoppel, and acquiescence for the reason that plaintiff did not make any money claim at the time of filing of the suit in the instant civil suit. The plaintiff on 6 June 2017 by amendment of the plaint dated 4/3/2014 incorporated a frivolous money claim of rupees 3 crores 85 lakhs 2,688.89 against the defendant railway. So this has been incorporated on, my lord, 6 June 2017 and in suit filed 4/3/2014. That time there was no money claim. My lord, issue number 15.
Yes.
My lord, whether the suit is barred by limitation.
Yes.
My lord, here the defendant submits that the said money claim of the plaintiff was afterthought and barred by the laws of limitation, as the original plaint was filed on 4/3/2014 and the money claim has been added in the plaint on 6/6/2017 by amendment of plaint.
6/6/2017.
6/6/2017 by amendment of plaint. As such, plaintiff's money claim is barred under Limitation Act 1963. My lord. My lord, here I place, my lord, the division first, my lord, suit, the limitation provided. My lord, kindly have a look, my lord. That is the
Get the limitation act. Yes, which article?
My lord, there is a suit relating to contract. That is, my lord, 55, my lord, of the first division 1, my lord, first. That is relating to suit.
3 years.
3 years. 3 years. So that, my lord, this from the termination is, my lord, on 4th of March 2014. So period starts from here, my lord. And here at this time, my lord, there is no claim of the money in the plaint, my lord. And so therefore, my lord, I submit, my lord, this is barred by limitation. My lord, issue number 16, my lord, I am coming at the end, my lord. Two issues are there.
Yes.
Whether the suit suffers from want of cause of action. The defendant railway submits that the defendant railway terminated the contract after serving notice dated 5/3/2014 in terms of clause 62 of GCC upon the plaintiff for failing to complete the said project. The said termination was in accordance with law and there was no genuine cause of action for the plaintiffs to file the instant suit. Now the last issue, that is 17, whether the plaintiffs are liable to pay cost and compensation to the defendant for committing breach of contract. The defendant railway submits that the plaintiffs have failed and neglected to complete the said project despite 2 extensions granted to the plaintiffs by the defendants for completion of the project. Further, the plaintiffs have realized the sum of rupees 6.7 crores from the defendant railway on account of running account bills for the said project. After the termination of the subject contract, the defendant railway had to get complete the said project through other contractor at a higher cost of rupees 10 crores approximately. As such, the plaintiffs are liable to pay cost and compensation to the defendants for committing breach of contract as claimed in counterclaim of the defendant railway. My lord, these are my submission, my lord. My lord, may I hand over, my lord, a copy of this, my lord, notes of argument to my lord?
Thank you.
Lord. Grateful, my lord.
You are only defend number 2 and 3.
2 and 3, my lord. And one is, my lord, secretary. Secretary is not implemented generally, my lord.
Okay.
That's why, my lord, I am now appearing for the 2 and 3.
My lord, I'll start with, my lord, the issues which are, my lord, at the bottom. Easier, my lord, to start.
Yes.
Now, my lord, today I find, my lord, from issue number 6, my lord, kindly, my lord, correct me if I am wrong. He has only read over to your lordship the issues. He has not substantiated from issue number 6 onwards today. But be that as it may. My lord, first, my lord, with the point it goes to the merit of the matter.
Issue number 6 He has relied upon the notices issued to you, subsequently the termination. So his contention under the 6 is that several opportunities were given to you, but you have not completed the work, and relying upon the chapter 6 of the contract, special condition, they have cancelled.
First, Millard, I'll go to Millard the legal points.
Yes.
Millard, which is easier. Millard, kindly have a look. Millard, question number 131. Millard, put to in examination in chief to Mr. Khunteta on August 1, 2024. Because Millard, that goes to the root of the matter.
Question number
131 onwards.
कम ना आपसे क्या करो बोलो, जब हो जाएगा 1 से चेक करो, ठीक है, टैग करके उसके बाद इस हाँ 131
हमारा फाइल टाइम तो देखना ये
तो बाद में कर
ये चीज और जुलाई ऑथराइज यही थी कहीं क्या बोला भी फाइल. But kindly see, he has not proved his written statement itself.
Just a minute.
131. Part to speak of Millard with the counterclaim. Shown the document. Kindly tell the Honorable Court what is the document.
Is a DW2, DW1.
DW1. This is the written statement filed by defendant number 2 and 3. What is your prayer in the written statement? I prayed that the plaintiff's case be dismissed. Have you made any counterclaim? Yes. What are your prayers? He quotes the amount. Kindly tell the what is the document. This is the additional written statement by defendant 2 and 3. Where is the contents? Whether the contents of the addition are true and correct. As per my knowledge, true and correct. So Millard, he is not the author of the written statement. He has not signed. So Millard, he has to prove that he has seen the person several times signing in front of him. He knows his signature. He is acquainted with the signature. So Millard, the written statement, which is the defense of Millard, the respondent, defendant number 2 and 3, is not being proved. My lord will come back to your lordship's Millard, memory Millard. My lord had put a question that what is your authority to appear before this court? He said that a 1992 document is there authorizing this list of persons to appear and authorize. Then my lord, next day, my lord had adjourned the matter on that day. Next day, he came back with an authorization and put it before lordship that as per the desire of the court, this authorization is being made. My lord had recorded in the order that it's not my desire, it's the need of the law. So, my lord, I will also take that point that my lord, his evidence is of no merit at all because he was not employed at that point of time.
No, that's why the evidence led by the defendant,
yes,
the DW1 is not the person who is actually acquainted with the facts. He has stated with regard to the office order and on the basis of the document.
And he stated in oath that he is in 2018, he is in employment. Correct. The suit is of 2014.
Correct. He stated.
That
is not denied.
Now, Millard, to prove Millard his case, Millard, another person came, DW2. Millard, he said that he is acquainted with some of the letters. My lord had put a question to Millard him that where are the authors are in service? He said yes. So if the authors and the signatories are in service, Millard, there is basically no basis of a Millard secondary evidence being laid. So the authors have not come before a lordship's court to say that this is my signature. I am the author. So Millard, the first contention, which takes care, I think, Millard, from issue number 11 onwards to till the end, that the written statement in itself has not been proved.
Yes.
Millard, no document in support of the contention of the defendant, that he had the personal knowledge from 2014 onwards till 20 and onwards. Number 3, Milad, the authors have not come forward before the Lordship's court to depose that I am the author. Have sent a Milad, I think Milad, he was not even that of such post also. And he said that the authors are still in service. Number 5, Milad, with regard to the counterclaim. Now, Milad, my learned senior Milad had Milad one by one Milad read over the counterclaim to your Lordship. Milad, kindly Milad see a single question being put on the counterclaim 7 except question number 134. He has to prove 14 crores, any document has to be disclosed before your Lordship. Now, Milad, the entire written statement, entire Milad, the counterclaim is Milad without any documents. And Milad, I'll take the responsibility to submit before Lordship without any evidence. Now, Milad, coming back to the Milad issue that Milad, most of the Milad, the claim of the counterclaim which has gone Milad by the railways is on account of Milad the loss of goodwill. Now, Milad, he has to bring some documents before the Lordship that my goodwill has been hampered like this. Milad, my Lord will see Milad while Milad sitting in court number 41, my Lord recollect Milad when our PW2 and PW3 came. Milad, each and every documents and slips, Milad, vouchers were proved in bunches. Now, Milad, may I put the question to myself, Milad? What document has been shown by the railways attached to the written statement or attached to the counterclaim or proved in evidence that Milad, this is the document to show that 14 crores is being loss suffered by railways? Now, Milad, today I find that he correctly, Milad, usually we put this issue everywhere that whether the suit is barred by limitation.
Yes.
Now, my Lord will see from the records, Milad, I am getting the order. Milad, with regard to the money claim, the suit was filed with regard to the bank guarantee. Now, Milad, the money claim, we had approached the Milad arbitral tribunal being formed by the railways. Milad, at that point of time, these judgments of TRF and those were not there, 2014. Now, Milad, arbitration and went on for some time. Then, Milad, they had also filed a Section 8 application before this Honorable Court, before Mr. Justice Sen, Soman Sen was taken up the interlocutory bench. Now, Milad, the arbitrator had written back to the railways that the claim is more than 20% of the total BOQ. So, it's beyond the arbitral reference. So, Milad, it was returned back to the suit court. So, Milad, the money claim was admitted by them. And Milad, my Lord, Anefan was not appearing, Milad, at that point of time. Milad, I'm sure he is not aware of those orders. Milad, a senior advocate appearing on the railway panel, he said that yes, Section 8 he withdrew, and Milad, the entire money claim was being put before this court.
Where is the order of withdrawal?
Milad, I am just getting, Milad, I think it's of 2016.
2017,
6 June 2017. It must be in my Lord's record. I will, Milad, bring the hard copy tomorrow. So, Milad, if Milad, we were proceeding before the learned arbitrator, no question of Milad limitation comes. And Milad, I find Milad, my learned senior said that they have made the money claim first time in 2017. You came back, you admitted my claim that it's not bound by arbitration in 2016. You withdrew your Section 8 in 2016.
When you invoke the provisions of the arbitration,
Milad, it was collateral, means going simultaneously. We came back 2015. The monetary claim was before the arbitral tribunal.
That is the only thing, because they have raised a specific plea that 4th of March 2014.
The suit was filed.
You filed the suit because when you are the termination.
My Lord knows the suits are always filed to restrain the Milad from invoking.
Correct. Now, that's why.
Now, Milad, the money.
4th March 2014.
Absolutely.
And it is telling that 4th on 2015 money suit within 3 years. So within 4th March you have to file the money suit. That means March 17. 3rd March 2017.
Section 8 was withdrawn in 16 only.
Correct. I am coming to that. So he is telling that is after the 3 years.
I'll show the order.
Section 55 will come. Article 55 will applicable. So the 3 years has gone. Now you are telling that So though you initiated the civil suit challenging the invocation.
Invocation,
Guarantee.
restraining them from
Invocation of the bank guarantee. That's why there was no claim in that.
Naturally.
In the suit. And subsequently, you have also initiated the arbitration proceeding.
Simultaneously in
that was gone. In the meantime, it was referred to this court, and they have
They had initially filed a section 8.
Section 8.
Subsequently, they withdrew by going to the note of the arbitrator that more than 20%. It's in 2016. 6 June 2016. Milad can take note of that. Milad give a note of that order. Milad, I'll.
Okay.
So, Milad, if it is in 2016, so apparently it is not barred.
Okay. Yes.
Now, Milad, the issue of damages being suffered by the railways, that if they have themselves have abandoned the position, the site, Milad, with deepest of respect, they can't expect the contractor to complete the Milad. We have taken a point of before the Milad all along a point of Milad section 56 of the Indian Contract Act, supervening impossibility. Now, my lord, it's an admitted case that the first BOQ consists of the scope for soil investigation lies with the contractor. Milad Vision Lab, Milad soil investigation report was prepared by them. Now, Milad, it was handed over. My learned friend says to restrict the time and to save some time, we had handed over. Milad, in return, what we had suffered? We had suffered, Milad, removal, Milad, of that scope from our work, and Milad, reduction of, Milad, the amount. Milad, we proceeded with the, Milad, the job. What we find? We find, Milad, hard rock. Now, Milad, PW2 had substantiated, Milad, an expert witness, had substantiated before our Lordship's court that there is a difference between well foundation and piling foundation. Now, Milad, they had, Milad, relied upon a well foundation. Milad, our contention was that all along that well foundation is not possible because for well foundation, there has to be blasting. And blasting means, Milad, I should have a blasting license and the cost. That cost was not there in the BOQ for blasting. So, Milad, our contention was all along that piling is the only solution. Milad, there are letters at Galore from 2012 onwards when the work has started that first of all, you revisit the soil investigation report because it is fallacious and it is not correct. Number two, you revisit your method because well foundation is impossible because in a river bed, well foundation is not being accepted. Number three, Milad, suggestion from our side that piling method is the only method. And Milad, coming back, Milad, it took a U-turn when Milad, the second tender they got, Milad, no tenderer. They had to shift the entire site.
Project is.
And Milad will find from the third tender, it's piling. Well foundation has been abandoned. So, Milad, what we have been saying from 2012 that Milad well foundation is not possible has been given an assent by their engineers only while Milad floating the third tender for the remaining work. So, Milad, the issue of Milad damages being suffered doesn't arise because you have yourself shifted the site. So, Milad, the provision of section 56 clearly comes into play. Because it's your investigation report which has induced me to come and you have deducted the amount from my BOQ, reduced my scope by doing the investigation yourself.
Okay. So, with regard to the limitation, I have one point.
I'll show the order.
One question. No. So they filed a section 8 withdrawn, then arbitration. When the arbitrate,
Millet section 8 and arbitration is going on. So Millet, they filed a section 8 here, then arbitration is going on. So you dismiss this suit.
So when your arbitrator has passed an order, he is not having the.
Millet, that's all written in that Millet Justice Shomention's order. I'll just carry Millet. I'll come back tomorrow, Millet. They are fixed also. But it's, I can come back tomorrow, Millet, with the order.
Okay, no, you compile that order so that
one order, Millet, I'll show. So Millet, that order, Millet will kindly Millet see, Millet, it clearly says that we are withdrawing section 8. So because more than 20% of the entire BOQ, so it should be adjudicated before this court. So Millet, limitation does not come into play at all. Suit is instituted in 2014. Millet, the order has been passed in 2016. So Millet, it is within much more within 2017 period. Sharabata fix আছে? Come back tomorrow.
Tomorrow আছে কি?
I'll bring that order.
Counsel for the defendant concluded his argument and filed written notes of argument. Let the same be kept with the record. Counsel for the plaintiff has started his argument, but due to paucity of time, hearing could not be completed. It is fine from the record. The matter is already fixed tomorrow. Let the matter appear tomorrow at 11:30. $11:30 though?
11:30. Tomorrow and day after also.
Okay, no.
I'm gonna try to complete within that period. I'll be very short.
Okay.
So that before vacation we can complete. Good.
Yes, next. Assigned. Patru.
Well, the turn of the events bring this matter back to your lordship. Your lordship had heard it. And in fact, I had almost completed. Then there was a change in determination.
That's why after going through this list of my
so this went before Justice Mukherjee. Then we brought it to the notice of Justice Mukherjee that
no,
so then again that got released and it has come back now.
That's why I'm telling after going through the non-commercial list, I find that this court is commercial and non-commercial both.
So there are other non-commercial which will come back. This is just one of them.
Yes.
I'm sure, my lord, Mr. Bose will take today at least. Tomorrow also I am to come back at 12:30.
হ্যাঁ করিস
Take time.
আর ঠিক আছে এখন
না এখনো জুড়ছে ভেতরে
আচ্ছা আচ্ছা ঠিক আছে করো My lord, I'll briefly tell your lordship, my lord, your lordship had taken copious note, my lord, so unnecessary troubling your lordship makes no sense. I'll just give your lordship the background. Well, if your lordship takes the plaint, I mean the application, the cost title, that itself will give a complete insight into my cause of action and why we are before your lordship and my reliefs in the suit. If your lordship will see, the first defendant is the bank. I mean, not a bank, a non-banking financial company. Now, my lord, my entire challenge is against the actions of the bank. Now, what has happened is, my lord, the bank, the non-banking financial company, the NBFC, had given, my lord, several loans. Now, these are all group companies. My lord, defendant, now there is a chart which I want to start with, so it will become easier. It will come back to your lordship. My lord, kindly see, there was a settlement agreement. If I start from the settlement agreement, everything will become clear. My lord, if your lordship take volume 2 and come to page, yes, my lord.
201.
It starts at 197, 201. I'm obliged. Here your lordship will find, and then if we tally this with the cost title, everything will become clear. Now, if your lordship will see here, these were the loans. If your lordship will see, this was the settlement which was arrived at. It was a composite settlement between the NBFC and all the companies put together. So the exposure at that relevant point on the date of settlement, whoever had whatever, all of them were in default. No doubt about that. Now that your lordship will find at page 201, top one paragraph, and everything will become clear. The obligers had availed financial facilities aggregating to such and such from Kotak Mahindra, which is the defendant number 1, that in above financial facilities there are amounts due and payable by the borrower obligers to such and such for various loan accounts having outstanding of 27 crores. The details of the total. Now, my lord, your lordship will first see number 1. Now, my lord, Mohan Motors Distributors Private Limited. My lord, here your lordship has made a note that this is the company in liquidation.
Page 222.
Correct. Obliged, my lord. My lord, kindly turn to the next page. Your lordship will see 2, 3, 4, and 5. So these are the other companies. Now, one company, 2 and 3 are plaintiffs before your lordship, which is, my lord, Mohan Motors Services Private Limited. And that, my lord, that is serial number 4 at page 202, and serial number 2, which is P3, plaintiff number 3 or petitioner number 3. So, my lord, we are only concerned with Mohan Motors Sales and Mohan Motors Services.
Yes.
So, my lord, this is the plaintiff number 2 and 3. If your lordship sees the cause title.
Yes, plaintiff number 2. Serial number 2 is the plaintiff number?
Right. Well, plaintiff number 3.
Correct.
And 4 is 2.
Yes.
Service and sales. Now, my lord, your lordship will see the outstanding. The last figure on the right is the outstanding.
Yes.
Well, these were the two outstanding of these two companies.
1 crore 92, 1 crore 92.
1 crore 92 and 63 lakhs. Now, my lord, your lordship can also make a note that serial number 3, Mohan Motor Udyog, is in liquidation.
Correct.
Then business is 1.99 crore. So, my lord, these two companies went into liquidation in 2020 and 2021. And, my lord, this agreement is of the agreement is of 30th of January 2020. This particular agreement. Now, if your lordship will kindly see, what happens here is, based on this, the legal proceeding, based on the settlement, they had already given notice under section 13(2) of the SURFACE Act. Proceedings were initiated. So, my lord, everything was settled and it was agreed that they will withdraw all the proceeding based on this settlement, and that was given effect to, and they withdrew the proceeding, including the arbitration proceeding that they had initiated, and they had not taken any further steps in terms of the securitization proceeding. Now, my lord, your lordship kindly comes to clause 10 at page 205.
Yes.
Here your lordship will find the name of a company by the name of Narbe Ram Leasing. That, your lordship, is, my lord, the defendant number 4 or the respondent number 4 in this application. The 4th defendant in my suit. My lord, one thing I ought to have told your lordship, my lord, the guarantors. My lord, kindly, my lord, allow me to trouble your lordship with the guarantees. Here your lordship will find who are the guarantors. That your lordship will find. My lord, kindly take the beginning of the agreement at page 198, where borrower 1, 2, 3 are given. If your lordship turns to page 199, after borrower number 5, your lordship will find guarantor number 1, guarantor number 2. The first plaintiff is the second guarantor number 2. So he had given a corporate guarantee.
Yes.
And also security. Now, if your lordship comes back to page 10205, which is clause number 10.
Yes.
The guarantor number 1 and 3 have approached KMPL, which is the first defendant, and requested KMPL to give consent to lease out immovable property, particularly mentioned as Schedule 2, annexed here to 1, Narbhiram leasing for a period of 99 months, and further agreed to provide consent to appropriate the monthly rent, maintenance facility receivables towards part payment of the outstanding amount due and payable to KMPL under the financial facilities. So these properties which were attached, or I stand corrected, which were the security towards the credit facilities given, they said you release these properties, I will give it on lease to Narbhiram. Narbhiram will pay the lease rental, and these lease rentals will be adjusted
In the rent.
and for that there is a separate escrow account which was also opened, that your lordship will find at clause 11. Kindly take once immediately the next clause. KMPL has agreed and provided his consent to the guarantor number 1 and 3 for leasing the immovable property, Schedule 2, to Narbhiram. Then, my lord, kindly turn to the next page. Description, which your lordship will find at page 212. Then, my lord, kindly take the first bullet point where it says 80 lakhs would be paid. The lessee Narbhiram shall pay an amount of 80 lakhs as an interest fee non-refundable deposit. Then, my lord, kindly take the next bullet point, which is 10 lakhs 79,000 per month.
Yes.
For the first 36 months, then the lease rent increases from 10 to 12 lakh 47. That is from 37 to 72 months.
Yes.
And thereafter increases further to 14 lakh 14,000. So, my lord, now today we are in the 14 lakh phase. So now, my lord, then your lordship will also see, kindly take Roman 5 at page 207.
Yes.
The monthly rents, as stated above, shall be first utilized for the repayment of the outstanding amount due and payable by the borrowers and guarantors as mentioned in your letter dated such and such. So, well, whatever is the total outstanding dues which is mentioned, 27 crores, that will be adjusted from this. Then, my lord, event of default is prescribed. Then, my lord, kindly take a 208. That is the clause by which guarantees were released in order to give effect to this settlement. Now, my lord, I have already given to your lordship the page numbers that the two companies, which is Uddog and the other one is distributor, when they went into liquidation,
yes,
that your lordship will find from page 222 and
228.
228. Now, my lord, what is important is the date. Well, lord, one is, my lord, the CIRP date is 17th of March 2020 and 24th of February 2020.
Correct.
So, my lord, our respectful submission before your lordship was, and the position of law as it stands today,
You're not
is that,
concerned with these two companies.
yes, because you cannot appropriate against the companies which is in CIRP because it is hit by section 14, and once it went into liquidation, it is hit by section IBC 31. 33(5). IBC Well, section 33. Well, the prohibition which is there to proceed to recover against the corporate debtor at the moratorium stage post CIRP under section 14, my lord, the same situation continues once the corporate debtor goes into liquidation, which is covered by section 32. Now, that your lordship will find, the embargo continues, that your lordship will find in 33 subsection 5. Because the entire logic, as your lordship is aware, my lord, now Vishal Jaiswal and onwards the Supreme Court has settled, my lord. So, my lord, if you have a claim against the corporate debtor, which they did, so they become as a creditor, secured or otherwise, they have to lodge their claim at two stages. At the CIRP stage, they have to file their claim, and thereafter, once it goes into liquidation, because this company has gone into liquidation before the liquidator, so which is the resolution professional becomes the liquidator, he lodged their claim, and the claim will be considered, my lord, kindly once take section 53. So their claim has to be considered in accordance with the provisions of the section 53 of the Insolvency and Bankruptcy Code. This is the only manner in which the debt of the corporate debtor can be recovered. There is no other mechanism known to law.
Yes.
With respect to debts of the company which is in liquidation under the IBC. Kindly it is section 53, distribution of assets, which was 529 and 529A of the Companies Act 1956. These are parameteria provisions under the IBC code, which is section 53. So the two debts on the day they went into CIRP, so you could not have appropriated any further towards those two companies. Now, my lord, what we have done is that we prepared a chart that you have been receiving based on the lease, say 10 lakh, continuing, and thereafter 12 lakh, thereafter. So till date, from the date of execution of the lease till date, how much have you collected? So that amount will be appropriated towards the outstanding dues. Now, my lord, kindly come back to the settlement agreement once. I just wish to draw your lordship attention to the two outstanding dues of these two liquidation companies which are in liquidation. Your lordship will see the first company which was in liquidation is the serial number 1 at page 201. Their outstanding
1 crore 63 lakhs.
No, 16 crores 37 lakhs.
16 crore.
16 crore 37 lakhs. So you have to stop taking 16. So let's put it. So this agreement was of 2020, and they went into liquidation they went into CRP on February 2020.
Yes.
So practically nothing could have been appropriated in respect of this company, which is 1637. Now, my lord, if your lordship takes out 1637 from 27 crore, what remains? My lord, then your lordship also, we need to also, my lord, deduct the other company which went into liquidation, which is the serial number 3 at page 202. That would be, my lord, Mohan Motor Uddog. So there your lordship will find there is a outstanding dues to the extent of 6 crore 94.
69 lakhs 41,000. Yes, 6 crore 94 lakhs 12,000. Yes.
So added together কত হয়েছিল? আচ্ছা এটা পরে এই দুটো অ্যাড করে বলো কত? I'll give you a lordship. This will come to 6 crore 39 and 16. About 22 crores. A little about 23 crores. So, my lord, effectively, my lord, 23 crores they cannot legally recover from the total outstanding of 27. So even if we take a figure of 23, what they could have recovered is 27 minus 23, that is 4 crores. Now, my lord, based on this agreement, if you're simple mathematics, we'll say how much they have recovered. My lord, they have been fair to us. In their opposition, they have unequivocally admitted the extent to which they have received, or they have first is how much by way of lease rental they have received. So the appropriation will come later, that the court will decide the appropriation. So, my lord, kindly see how much they have received. My lord, if your lordship takes the opposition filed by the defendant number 1, page 16. Kindly take the opposition of affirmed by Shashwat Sagar in June 24
Yes.
to GA1. My lord, kindly take page 16, 16. My lord, kindly take paragraph Roman 8. Thus, till the date of affirmation, page 16, 16. Till the date of affirmation of the aforesaid suit, from the date of execution of the aforesaid agreement, that is 4 years, 3 months, the respondent number 4, being the lessee, which is my lord Nadbhiram, deposited on behalf of the plaintiff herein only a tune of
5 crore.
5 crore 68. So, my lord, this is an unequivocal admission. So, you've received that money?
Yes.
Right. Against the admitted outstanding of 27 crore. Now, my lord, kindly take the particulars. He has also received that 80 lakhs. Apart from 5 crore, he says this was by way of lease rental and aforesaid total amount post receipt of 80 lakhs.
Without
Yes,
security.
the initial amount which was given by way of lease premium security, that 80 plus is. Now, my lord, your lordship will kindly turn the page. So, my lord, interestingly, your lordship will see at page 19 that till the date of filing of the suit, which was in June 2024, they have been receiving the enhanced lease rental. The last paid enhanced lease rental as on the date of filing of the suit was 12,40,850. So till June 2024, they have received. And they continue to receive.
Yes.
Now, as per your chart, take the calculator.
Yes.
My lord, you could have at best realized from page 201 and 202 of your settlement agreement. My lord, how much, my lord, if I may just trouble your lordship once, I'll just give your lordship that maths. From serial number 2, serial number 4, and serial number 5.
192 plus 63 plus 190.
Correct. This comes to how much? Calculate kodo. Calculate tomra kode dao na.
4.55.
Judge করে দিচ্ছে well, it comes to about 4.55. So you have in paragraph 16 always, you have already admitted unequivocally that you have received 568. So that's why I have a claim for refund. Now the question is, no, what are you doing? He continues. Malad, the golden hen is still laying eggs and he's continuing to enjoy the eggs. You can't do that. Because your liquidation claim against the two companies has to be, my lord, illegally, it is unenforceable through the settlement agreement. By operation of law, those debts,
yes,
which admittedly form a part of the settlement, cannot be appropriated any further. You have already lodged your claim with the liquidator in respect of those two companies. And interestingly, you are the secured creditor in those two companies. You are financial creditor. So you are a part of the COC of those two companies.
One logic, yes.
So you cannot appropriate against the debt of those two companies. So then what remains that you are today, you are appropriating in excess.
So your contention is that their claim is total 1.55 as per this schedule, as per the agreement, but they have realized of the total 1244.
Yes.
1244. So you have paid the extra with regard to the two companies.
Yeah, they have realized extra.
Extra, and two companies who are in liquidation, they cannot claim the said amount from you. That is your simple.
They cannot claim through this process anymore.
Correct.
Because through this process,
Liquidation.
the outstanding due already stands settled. So plaintiff number 2 and 3 has to be discharged. My debt is totally discharged. And the guarantee of the first plaintiff should also be released.
Okay.
And you must stop appropriating. You cannot take money from the lease anymore, because whatever you have taken in excess, so you have to now refund. So that will be eventually decided in the suit. But now, my lord, what we want is they have to be stopped from realizing any further under the settlement arrangement. Number one. Number two, they have to stop, my lord, or they have to give me a no objection certificate to the extent that my debt has been entirely adjusted and my debt stands satisfied. And they have to also release the security of the first plaintiff company. My lord, these now, my lord, your lordship will see. Huh? Now, my lord, yes, the guarantee part I'll just show you. Now, my lord, I have not guaranteed for all 5. So this is also an admitted position. Now, I'll kindly come back to the settlement agreement. So where is that? Now, my lord, kindly take page 299. Oh, the second volume. It's not there. Lord, kindly take, possibly it is in the 3rd volume. My lord, kindly once take the trouble of looking at the 3rd volume. Well, if your lordship takes 293, now, well, interesting is, well, kindly make a note of the date.
Yes.
5th of March 2024. So now, my lord, if your lordship reads this with the chart in the opposition, I'll just trouble your lordship once. My lord, that chart which is at page 17 onwards. So when they issue this notice on March 2024, so effectively they have already appropriated in excess of almost 4.50, 4 crore 50. So they are issuing notice under 13.2 for what?
Recovery.
Whose recovery against whom? There is no debt. So anyway, that is not under challenge before your lordship. What I want to show is that this is under challenge before the debt recovery tribunal, separate proceeding. Now, what I wish to show your lordship is, my lord, kindly see my security that I have given, 299. So this is your 13.2 notice.
Yes.
My lord, kindly take Mohan Motor Distributors. Distributor ta koto?
Mohan Motors.
Distributors.
Yes, private limited. Yes.
Yes, my lord, distributor your lordship will find is the my lord, kindly see, I have given the guarantee. My lord, I am showing the guarantee given by the first plaintiff. Your lordship will see the first plaintiff is Kalpataru Banijya. On whose behalf have I given the guarantee? I am showing your lordship, my lord. Now, my lord, this is distributors. I have given the, if your lordship will see the second column, your lordship is facility and security documents. Then my lord, see deed of guarantee executed by such and corporate guarantee by such and such, and Kalpataru, which is the plaintiff. So I have given guarantee towards distributors. Now I'll just show your lordship how much is the total claim of distributors. Just give me your lordship, you kindly give me a moment. The distributor's claim I'll show your lordship is distributors was 16 crore 37 lakh, which is in liquidation. So my lord, this company distributor is in liquidation. So this guarantee you cannot invoke. He is in liquidation now. My lord, kindly see. Mohan Motor Uddog. Your lordship will see credit facility. I have not given any guarantee towards Mohan Motor Uddog. Page 300. Kindly see serial number 2.
Yes.
Then my lord, services, no guarantee given so far as I am concerned.
Yes.
Now my lord, sales I have given a guarantee to the extent corporate guarantee, your lordship will see Kalpataru guarantee has been given. So I have technically given guarantee for 2, which is sales.
One is for the
and distributor.
And
Sales.
Sales private limited.
Yes. So I can be only, so my guarantee has to be discharged so far as these 2 are concerned. Sales is my lord 1 crore 92 and Mohan Motor Distributors is in liquidation.
Yes.
And the other interesting aspect is you are continuing to realize the lease rental. So there is no breach. So this is my alternative argument. My first argument is that 2 company in liquidation, you
paid
get
extra.
you paid extra refund. Now, assuming for the sake of argument that you still have a right to realize, there has been no breach. You don't complain of breach. So where is your cause of action now to recover? Because there is an existing arrangement in place. You are realizing based on the existing arrangement,
yes,
the lease rentals have been deposited in the escrow account, yes, which you are appropriating in pro tanto satisfaction of your claim against the 5 borrowers. But for the sake of argument, hypothetically, if your lordship takes away the 2 companies in liquidation for the time being, let's for the sake of argument take that they have also not in liquidation, that they have a right to realize. Even then there is no breach. If there is no breach and the situation continues, how? And there has been, so you don't have a cause of action to initiate proceeding for realization. Because
continuing receiving them.
So the settlement agreement is itself a contract.
Yes.
So unless there is a breach of that contract, and the only breach is that if you fail to realize the lease rental from Narbiam, and in your affidavit, you have unequivocally admitted that you are still continuing to realize lease rental through the escrow arrangement from the 4th defendant lessee. So it continues. So you have no further cause of action. So effectively, my lord, you cannot take further steps. This is the other aspect. So that under these circumstances, if your lordship will see our prayer, what we have claimed by way of an interim orders at page 27, Injunction restraining the respondent number 1 from receiving lease rentals from the respondent number 4. So if your lordship is of the prima facie view that the money recoverable by them is less than what they have already realized, then they have no further right to realize. Number 2, your lordship will see injunction restraining the respondent number 1 from acting contrary to the terms of the agreement and in making any demand without giving credit to all sums received. So basically, I'm asking for specific performance of this agreement, that you are acting, you are realizing. So if you are realizing, you have to give credit to the amount you've realized under the agreement, which is not. Why not? Because your lordship will see that notice, issuance of that notice, that is contrary to the agreement. You could not have issued that notice. Injunction directing the respondent to make over to the petitioner the title deeds. Because why? Because the debt stands satisfied. The guarantee automatically should stand discharged under the Contract Act. Now, these are the limited prayers that I've sought for in the injunction. Now, they had taken in their opposition a point of maintainability. Now, I must also say, initially when we moved the ad interim order, your lordship had recorded all the facts and only on the ground that this suit may be, yes, my lord. Your lordship was prima facie of the view that the suit may be barred under section 34 of the Securitization and Reconstruction Act and had accordingly refused to grant us interim order. In appeal, my lord, we secured an interim order and thereafter we are back. But here, in respect to the maintainability point, my lord, we had already relied upon a few judgments. They must be in your lordship brief. One is, my lord, 2023 volume 1, Supreme Court cases, page 1. I think, my lord, that should suffice because that takes into consideration the previous judgments.
VKC?
Yes, my lord. VCK, yes, yes, that
VCK, sorry.
yes, VKC. That takes into consideration. আমার বই আছে দেখো খোলো debt law 2023 VCK. I've got it here. Is it marked? Just check. But here that Nahar Industrial and the entire
considered,
everything has been considered. Your lordship got the judgment? Yes. But your lordship will see in the page 7 of the report, if your lordship will find, each and every judgment has been considered. So, my lord, repeated, unnecessarily repetition, my lord, I don't want to make this that case of that Jagriti matter. One issue, 25 judgments. My lord, that is, in fact, there's a Supreme Court judgment of Justice Bikramjit Sen. It went up from Calcutta High Court. He deprecated this practice. He said that you are wasting judicial time. One judgment on the point,
considered all the judgments, so what is
that is sufficient. Multiplicity of judgment on one point, that is why we are unable to deal with 36 judgment. He's shown 10 judgments on one point. Well, here your lordship will find, if your lordship starts from the bottom, your lordship will find all the judgments here are considered. So, Bernard, so if we refer to this judgment, which takes into consideration Obhijit Tea, Ranjan Chemicals, Indian Bank, ABS Marine, Nahar Industrial, all that takes care of the situation of the bar of a civil suit so far as section 34 is concerned. Section 34 is basically a clause which ousts the jurisdiction of the civil court. What it does is, and it gives the remedy to the party to go before the debt recovery tribunal. Now, my lord, all these judgments and this present VCK judgment says that, my lord, not all disputes are within the jurisdiction of the debt recovery tribunal. But the disputes which are covered within the jurisdiction, my lord, 34 will act as a bar in respect of those actions only. Not in respect of every action. As a hypothetical example, today if I want to sue the bank for damages that I have suffered for the action of the bank, do I have to go to debt recovery tribunal to file the suit? No. So, but here what do I ask for? I am asking for specific performance of a settlement agreement. I cannot bring this action before the debt recovery tribunal. So we say that 34 is not a bar. This is, my lord, if your lordship will see here, this is what it says. If your lordship kindly take para 43 at page 27.
Section 9.
Which is, my lord, the paragraph starting with our view, page 27.
Yes.
Paragraph 43. We must note at the threshold itself that there are no restrictions on the power of a civil court under section 9 of the code, unless expressly or impliedly excluded. This was also reiterated by a constitutional bench judgment of this court in Dhulabai versus State, which is, your lordship, is the 68th Supreme Court. Thus, it is in the conspectus of the aforesaid proposition that we will have to analyze the rival contentions of the parties set out above. Our line of thinking is also influenced by the three-judge bench of the court in Dwarka Prasad Agarwal, wherein it was opined that section 9 of the code confers jurisdiction upon civil courts to determine all disputes of civil nature unless the same is barred under any statute, either expressly or by necessary implication, and such a bar is not to be readily inferred. The provision seeking to bar jurisdiction of a civil court requires strict interpretation, and the court would normally lean in favor of construction which would uphold the jurisdiction of the civil court. Now, if we turn to the objective of RDB Act, read with the scheme and provision thereof, it is abundantly clear that a summary remedy is provided in respect of claims of banks and financial institutions, so that recovery of the same may not be impeded by the elaborate procedure of the court. The defendant has a right to defend the claim and file a counterclaim in view of subsection 6 and 8 of the section 19 of the RDB Act. In case of pending proceedings to be transferred to DRT, section 31 of the RDB Act took care of the issue of mere transfer of the bank's claim, albeit without transfer of the counterclaim. Thus, if the debtor desires to institute a counterclaim to be relegated to a proceeding before a civil court under section 1911, though such determination is to take place along with the determination of the claim for recovery or proceeding. We are thus of the view that there is no provision under the RDB Act by which the remedy of a civil court by a defendant in a claim by the bank is ousted, but it is a matter of choice of the defendant. Such a defendant may file a counterclaim or may be desirous of availing of more strenuous procedure established under the code, and that is a choice which he takes with the consequence thereof. Then, my lord, interestingly, my lord, if your lordship will take the questions are framed at page 50, para 56 at page 29. Well, this is the issue which is before your lordship. Para 56. Is the jurisdiction of a civil court to try a suit filed by a borrower against a bank or financial institution ousted by virtue of the scheme of the RDB Act in relation to the proceeding for recovery of debt by a bank or financial institution? Then, my lord, your lordship will find the conclusion is at para 60. The judgments in Obijit and Ranjan Chemicals are held not to be laying down the correct legal position. The judgments in Indian Bank and Nahar Industrial are affirmed except to the extent that they allow the transfer of a suit from civil court to DRT. Even that part is overruled. Now, my lord, interestingly, if your lordship, since your lordship is looking at the judgment, my lord, kindly have a look at the language of the section itself. The answer is there. If your lordship takes, which is pari-materia to section 18 of the other act, in fact, my lord, the language of section 18 is stringent than that of section 34 of the Securitization Act.
Yes, section?
My lord, section 34 of the Surface Act. The language itself makes it clear that not all proceedings are barred.
Yes.
No civil court shall have jurisdiction to entertain any suit or proceeding, then my lord, in respect of any matter
Yes.
which a debt recovery tribunal or appellate tribunal is empowered by or under this act to determine. So my lord, it has to be a proceeding in respect of a matter which the tribunal has jurisdiction to entertain. So if I file a suit which is beyond the jurisdiction of the debt recovery tribunal to entertain, so that will not come within the purview of the bar contemplated under section 34.
What is the suit you have filed here?
Now kindly have a look at the praise in my suit. Well, it is set out in my interlocutory application. I think it is set out. But kindly come to page 23 of my application, paragraph 46. All arising out of the settlement agreement,
Yes.
which is a concluded contract. And my lord, kindly see my press, see declaration that the defendant number 1 is obliged to give credit to the amounts received under the agreement dated 30. So this is my suit. So all the relief that I claim in my suit is based on the settlement agreement, which itself is beyond the scope of the jurisdiction of the debt recovery tribunal. So how is my suit barred in law?
Yes.
So these are my respectful submissions. Well, I have cited one more. Also, kindly, I'll just give you lordship the paragraph number. Judgment. There's a division bench of Bombay High Court. (2021) Supreme Court cases. SCC Online Bombay 466.
Yes.
Paragraph. Well, this is also, if your lordship kindly turns to, the page numbers are at the top. Well, what was being considered is the bar, and whether something similar in nature can be ordered or not. Your lordship will see 34, section 34 is considered at page 40. On top, your lordship will find the page numbers, absolutely where SCC Online is written.
Yes, yes.
Yes, then my lord, kindly take
paragraph 15.
It's a longish judgment, my lord. Kindly once take para 15. It starts from Mardia. My lord, it considers every possible judgment on the issue of bar under section 34 and section 18 of the RDB Act, both. Then the relevant would be page 62. Your lordship will kindly take once.
Page 81. Page 81.
Page
paragraph
8, no, my lord, page 62.
Abhishek.
If your lordship will take once. There it refers to the Calcutta judgment, Abhishek Bose.
Correct.
And thereafter, if your lordship turns to the next page, after emphasize supplied, then thus what is manifest is that the DRT must be found to have the same power and authority to decide the objection claim raised in the same manner which the civil court could have decided. If that not be so, then the jurisdiction of the civil court cannot be said to have been ousted. We find that the above statement of law well defined the position. Then your lordship will take kindly take Nahar Industrial is considered at paragraph page 81, and then my lord kindly take page 82, para 25. A meaningful interpretation has to be put to the language of the bar as contained in section 34 of the Surface Act, so that the object and purpose sought to be achieved by the act is not rendered illusory and is fulfilled. Then after it continues, now my lord kindly see the answer at page 83. And my lord kindly consider C and D. Kindly take C, D, and of course E. The jurisdiction of the civil court to decide all matters of civil nature, excluding those to be tried by the Debt Recovery Tribunal under 13 and 17 of the Surface Act in relation to enforcement of security interest or security creditor, is not barred under section 34. Then D, where civil rights of persons other than the borrower or guarantor are involved, civil court would have jurisdiction, that too when it is prima facie apparent from the face of the record that the relief claimed is incapable of being decided by DRT. Then my lord E, even in cases where the enforcement of a security interest involves issues as indicated in Madhya Chemicals of fraud as well established within the parameters laid down in IS-Swami, a claim of discharge by a guarantor under section 133 and 135 of the Contract Act, semicolon, a claim of discharge of a guarantor under section 139, 120, 143 of the Contract Act, then then 56 of Transfer Property Act shall have jurisdiction.
Yes.
So these are my respectful submissions.
Thank you. Counsel for the plaintiff has concluded argument in connection with GA1 of 2024. But due to paucity of time, hearing could not be completed and defendant could not be able to argue the matter. According case is adjourned, let the matter appear tomorrow. 12:30. Hey.
Yes.
Well, the matter, I believe, tomorrow fixed at 12:30.
It is.
Yes.
Unless you don't want to do it.
No, obviously.
Excuse me, Lord.
Yes.
Only item number 78. We have filed new application of a suit, rejection of the plaint. Can I take it up? Because the next retirement date is on 18th. I've taken the concern of my friend. 18 is already date being fixed for
Commercial, non-commercial.
commercial.
Item number
78, no?
17.
78.
Yes.
The actual retirement date was on 18th. 18th is the
of-
date fixed for hearing of other application. It can be taken with that date.
18th of this month.
This month.
18th at 3:45 p.m.
Okay.
That matter, that restaurant.
Let it come on 18.
Yes.
18th at
Much obliged.
Item number 78 regard Kuno. It is informed by the learned counsel for the parties that the connected matters are fixed on 18th of August. 18th of August
18th of August.
at 3:45 p.m. Let CSCOM 701 of 2024 along with the connected application be placed on the same day.
Much obliged. Grateful.
30th July, your lordship has passed an order in terms of prayer A. It should be, instead of prayer A, it could be prayer 1, lordship, that someone for direction for appointment of an auditor, lordship.
Prayer 1.
Yes.
Counsel for the official liquidator has mentioned the matter for correction in the order dated 30th July 2025. Counsel for the liquidator submits that, official liquidator submits that in paragraph 1, line number 2, this court has allowed the prayer within bracket small a, but it should be prayer within bracket numerical 1. In view of the submission made by the counsel for the official liquidator, and after perusing the summons for direction in the order dated 30th July 2025, in paragraph 1, line number 2, the prayer A shall be read as prayer 1.
I am grateful, lordship.
Your Lordship. Your Lordship, may I be permitted to mention a matter? Your Lordship, this is a company application. Your Lordship, I'm praying for leave to file with short cost title. I do not have access to the full cost title and the CP has been disputed.
What application you want to file?
Your Lordship, I'm a shareholder. I just want to bring on record certain properties of the company, Your Lordship.
So you're not having the cost title?
Your Lordship, I don't have access.
Who are you?
I'm a shareholder of the company, Your Lordship.
Shareholder of company.
Your Lordship, may I have your Lordship's leave to mention one matter? Your Lordship, this is that matter where the CP number is not available, Your Lordship. We had mentioned it several times, Your Lordship. The department and the office of the official liquidator is not able to inform us about the CP number, Your Lordship.
Have you got the CP number?
In which matter?
Voluntary one.
Also, we have not received any information regarding this.
Lordship, we have visited the office of the official liquidator as well as, Your Lordship, the department.
Whom you have contacted? You're not contacted the official liquidator. You're not aware.
Lordship, in that
Matter, who is the liquidator? We have
Your Lordship, it's a matter of voluntary winding up, Your Lordship. The official liquidator had filed a report.
voluntary binding up, Lordship, they have not submitted the report, so we cannot file a report. They can file the application.
Do one thing.
But
Lordship, the office of the official liquidator had filed a report that is on record, Your Lordship. It is recorded in the order passed by Honorable Justice Sanjeev Banerjee, Your Lordship.
my God.
It is of 2007, Your Lordship. 2007.
No number.
Lordship, this is the copy that we have. It is not available on the website also, Your Lordship.
How you have taken on record this? Where this order was passed? Which order, which file this order was passed? You are not there. No.
Lordship, the order was...
Nothing is there. So how it can? No, this is not the original order.
Order has passed. No?
So the record is not available.
Company has dissolved.
Yes, but the assets have not been distributed, and we have to appoint a new voluntary liquidator because the
Why we have appointed a new voluntary liquidator?
because
Order
the
has been
earlier one has passed. The assets have not been distributed.
Liquidator has passed.
Yes, yes.
Official liquid. So what you want to file?
Lordship, it's an application for appointment of a voluntary liquidator because the earlier liquidator has passed away and the assets have not been distributed, Your Lordship.
What is the company name?
Chemical and Tar Products Private Limited.
You see the company name is anything is pending with you. You do one thing.
Lordship.
The name of the company be given to the official liquidator.
Lordship.
And you check from the name of the company if any proceeding is or anything is pending because there is some order. But my officers have already checked the total briefing on CISS also. Now nothing is available. So please check from the name of the company. Might be there. Check it.
Lordship,
Contact the official liquidator.
in case it's not, then I'll mention it next.
We will see.
Grateful, Your Lordship.
May I will Lordship kindly to mention one company petition for inclusion in the list.
For what? For what? Inclusion in the list for what?
For hearing.
What is a prayer?
These He has got dismissed, my lord.
Huh?
He has got dismissed, my lord.
What?
The company petition
Company petition dismissed.
has dismissed. Thereafter, it has been restored, my lord.
Correct.
And now, my lord, it has been listed, my lord.
See that is what is the number?
CP number 214 of 2002.
Okay, take it. If it yes, call the list.
Lordship, in this the last order passed on 25th June 2025. The last line, Lordship, of the order.
Yes.
What's the last order? Allowances to the company instead
Acha.
of 3,000. Only rupees 3,000 is in place of 2,000. So, Lordship.
Per month. In the officer direct. The matter is listed as to be mentioned on the prayer of the officer liquidator for correction in the order in the judgment dated 25th of June 2025. Counsel for the officer liquidator submits that, and the officer liquidator submits that in the judgment dated 25th of June 2025 at page number 12. Last second line, page number 12, last second line. It should be read as instead of rupees 2,000. And submit that in the last second line. No, and last second it is recorded that it is recorded rupees 3,000 instead of rupees 2,000. In view of the submission made by the counsel for the in view of the submission made by the official liquidator in the order dated 25th in the judgment dated 25th June 2025 at page number 12, last second line, the amount shall be read as 2,000 per month instead of rupees 3,000 per month. This order may be incorporated with the judgment dated 25th of June. Yes, next.
My lord, this is my application.
But I am for the official liquidator.
I'm appearing for the workers' union.
Yes.
My lord, the company has gone into winding up in liquidation by order dated 27 July 2004. My lord, substantial sums are due to me. The Supreme Court has also said that I be paid off expeditiously. Nothing is being done. I have now come across a very valuable property belonging to the company, which the official liquidator has taken no steps in respect of, and which is still lying in the possession of third parties. I've identified these properties. I have found out the
okay, you have
municipal
served,
records.
you have served the copy to the officer?
Yes, I have.
Yes, yes.
You go through and submit the report.
That's what I am praying for at this stage. Let them submit a report in respect of this property.
Correct. That's a
That I'm appearing for the joint action forum, Millard. On the last occasion when the matter was before Millard, this is Sogata Majumdar at that time, while the official liquidator had brought on record the way and manner in which they are willing to pay the dues of the workers, Millard, a considerable sum has been paid, Millard, but the only difficulties with regards to the PF dues of all these workers, Millard, most of whom are at the fag end of their life, and some have died, Millard. There was one observation by my lords that with regards to the PF amount, let them take out a fixed deposit, or rather pay to the PF authorities, and accordingly the PF authorities will deal with the amount. But if the workers are not enjoying the benefits of their amount,
connected with that matter.
It's the same company, but that is it. But what I'm asking for is just let the liquidator file a report.
Whether the BIFR case is pending here or just before Justice Sugata Majumdar.
No, Millard. This entire case has now been transferred because of the change in determination, Millard.
Okay, now
determination.
So now order is passed in this application.
This application.
Okay, let the official liquidator submit the report.
This pertains only with regards to the land, Millard. But with regards to PF dues on the earlier occasion in the report of the official liquidator, Millard, they have mentioned No, that my learned friend's application can also will be taken care of, but will address, allow me to address a simpler issue.
Earlier order is there.
With regards to PF dues, let them determine the amount and give it to the PF officers for it to be disbursed to others. The workers will all die without enjoying the fruits of their.
Who has filed the application? You have filed the application.
Yes, the application was filed on the basis of that application only. These orders were passed.
Okay, I have been informed that your application is pending before the Justice Majumdar for as parted matter.
Yes.
So I cannot pass any
That's
order
not
in
here.
the matter.
That's a separate application pending.
Part heard, I am not aware of the part heard part, but then yes, it was largely heard by Justice Majumdar.
That is part heard. That's why it is here.
Please check it. Please check it. If it is
I will check. I will check. Then I'll pursue there.
And then before the Justice Majumdar, if it is not there, bring the last order. Then I will see to that.
Yes, because I was under the impression that since the entire matter has been transferred to this jurisdiction now, whatsoever, I'll check it.
Matter is concerned, that's a totally separate aspect. Malad, there is a typographical error in my application. The premises number has been wrongly mentioned. I've
what number?
Leave to file a supplementary affidavit just for the correction. I've just said that it's wrongly mentioned here. Instead of by typing mistake, it's gone down as 22 instead of 55.
Where?
My lord, if my lord can pass an order in terms of prayer A for the time being, that will serve the purpose.
Supplementary affidavit.
My lord, that is only to correct 22 to 55, nothing else.
Where, which paragraph?
Of the supplementary affidavit. My lord, paragraph 4.3. Address of the property which I found out belonging to the company. That's the only thing.
Okay,
by typing mistake, it's gone down as. My lord can pass an order in terms of prayer A that will.
55 হবে তাই তো
50 to 50 আপনি অ্যানেক্সটা দেখুন অ্যানেক্সটা দেখুন না বেসিক্যালি ভুলে গেছে অ্যানেক্সটা ওখানে সব ঠিক আছে 55 to 22 হয়ে গেছে
so it is to be 55
yes instead of 22
that's the whole
why
summons substance of the supplementary affidavit
why
summons substance of the supplementary affidavit is that but my lord, this property extremely valuable property over 150 katas of land just in the possession of outsiders.
One of the tenants, is a government of West Bengal. Warehousing, they are
asking.
Two tenants, I understand there are two tenants. They were still from the before the company went into liquidation.
Yes, what have they done about it for the last 15 years? I am to be paid.
The applicant has filed the present application, praying for a direction upon the official liquidator to file report.
My final prayer is for sale, but at this stage I'm only asking for
company's premises at 55 Canal Street.
My lord.
55 Canal East Road, Kolkata. And allied prayers. Full stop. The applicant has also filed a supplementary affidavit stating that in the application as well as in the prayer portions, the company premises number is inadvertently recorded as 22, but the same has to be read as 55.
Right.
My lord will take page 22. This is what I've got. I mean, this is what this possibly the OL doesn't have. This I've got for them.
In view of the above, the company premises number shall be read as 55 in all places of the application being CA 55/2025, including the prayer portion, instead of premises at premises number 22. Yes, sir.
My lord, let the affidavit be. Let them also show in what by authority these people are claiming to be entitled to be in possession.
For the applicant submitted, the application has already been served upon the official liquidator. Accordingly, official liquidator is directed to file report by
2 weeks.
2 weeks.
3 weeks. 2 weeks. 2 weeks. 2 weeks. Within 2 weeks, after serving the copy to the learned counsel for the applicant, let the matter appear on 27th August.
27th.
Deeply.
Yes.
Yes, my lord, I am for the official liquidator. My lord, as per your lordship's order, last order, my lord, the property has been sold. My lord, if your lordships kindly see your lordship's order dated 25th June 2025. This is my report.
For a
My lord, the highest offer in the open auction, my lord, the official liquidator received for a sum of rupees 8 crores 94 lakhs. My lord, that
I
is
am appearing for one of another prospective bidder, but I could not participate in the auction bid. But
But
I am
page
I
5,
am
page
based on
5
a
of the
property which is adjacent there. So I came to learn and I was informed that a auction has already taken place. But I have a offer which is higher than the highest bid. And well, I have come with 25% of the my bid amount of 10 crores. I have come with, my lord, 2 crore 50 lakhs. So if your lordship grants me a chance, my lord, a notice can be served upon the highest bidder and an auction can be, I can get a chance.
Participated.
My lord, your lordship kindly takes my report, page 5, my lord, page 5. I have given, my lord. There were 2 participants, out of which, my lord, the highest bid we have received 8 crore, my lord, page 5, paragraph 8.
My offer is
7 and
substantially
8.
high.
7 and 8, my lord, kindly see. 8 crore 74 lakhs 31,247, and out of which, my lord, we have received, as of now, I understand that we have received more than 30% of the bid amount, highest amount. And if your lordship kindly takes the bid proceedings, annexure C, page 24.
Company will gain, my lord, if
No, I am not objecting to that. I am just intimating your lordship's report.
if an opportunity can be given, my lord, I can.
But you are not participating.
Yes, I accept. I have not. No, but highest bid, he has not acquired any right by an highest bid.
Prior to the auction bid consideration. Everyone, suppose this auction is set aside and the third party comes tomorrow and says, I have also had a highest bid, then again this second auction to be set aside, your lordship. This cannot be.
Then in that case, your lordship will do one thing, my lord, kindly do not confirm it today. Let me file an application. I will come with some judgments where if it is permissible for the court in any situation, if I can show your lordship, if your lordship is satisfied, I get a chance. At least, my lord, let me come up with an application and I shall try and satisfy your lordship, my lord. In certain situations, it is permissible. Specifically when, my lord, it is for the benefit of the company. And it is not, my lord, my offer is not merely 10 lakhs or 20 lakhs. There is substantial difference.
Yes.
Yes, my lord, I have got no objection, my lord, for the benefit of the creditors in general. If better offer is, my lord, I have got no, but subject to, my lord, the secured creditor Punjab National Bank as the auction
If your lordship provides, I can deposit this as a.
You are appearing.
Auction button, Tambekeshwar Foods Private Limited.
Learned Counsel appearing for the official liquidator has submitted the report wherein it reveals that after the publication of the auction notice, two companies,
yes,
2 persons.
My lord, annexure C, page 24, my lord, kindly see. The company's name is there, one of
companies, namely Tambekeshwar Food Private Limited and Shri Karni Developers have participated in the tender process, and it is found that
page 5.
It is found that Tambekeshwar Food Private Limited has quoted the amount of rupees 8 crore.
Yes, my lord, 8 crore 74 lakhs, 38, paragraph 8, my lord, kindly see.
247 and has also deposited 25 deposited an amount of rupees 2,18,57,812 being the 25% of the bid amount. Full stop. Learned Counsel. And what is the good name? Mr. Rahul Singh, Learned Counsel appearing for the the Trambakeshwar Food Limited submit that his company has quoted highest bid and the same is to be accepted. Mr. Sakya Sen, Leonard Senior Counsel, appearing for
MNE Components Private Limited.
give the name. MNE so and so and submit that he is the adjacent plot holder of the subject property, but inadvertently could not participate in the tender process, but he is ready and willing to pay the much higher amount than the highest bidder.
10 crores your lordship can write.
Much higher amount, that is about rupees 10 crore.
And my lord, I have also brought a earnest money deposit also, demand draft. 25%.
Much higher than the highest bidder, and he is ready to deposit the 25% of the said amount.
Yes.
Full stop. This court find that as the official liquidator has published the tender and two applicants have participated in the tender, and the highest bidder has also deposited the 25%, and as such, before accepting the report, one opportunity should be given to the company. What is the name? To file an appropriate application for quoting the highest bid of rate within a week.
Yes.
Within a week after serving the copy to the official liquidator as well as the highest bidder. Let the matter appear on 13th August 2025.
13th August.
Or 20th August.
20th August. Kindly give 10 days instead of 7 days.
A week? Okay, 10 days. Within 10 days. 1 week bola na?
Yes.
10 days.
Obliged.
Next.
But leave to file wakalatnama in the department for the purpose of that application.
File with the wakalatnama. If not accepted,
because actually I am an intervener, that is why they are not accepting.
The Mr. Sen is also the advocate on record of so and so company is given liberty to file wakalatnama within a week from date. Mr. Sen and the advocate on record of Trambakeshwar and so and so is given liberty to file wakalatnama within a week in the department. Next.
It's 8/2/38. Is that Avni projects the home buyers matter? I appear for the resolution professional of this company now. Now, let me be very honest. The first item 8 is my learned friend's application. 83, the item 9 is I am asking for recalling of the order passed in 82, which was treated as the lead matter because this is where I argued that the matter has to be transferred to the national company. I had finished my arguments when we came up with a solution to cut short the matters regarding the other home buyers. Your lordships have passed an order. We showed your lordships the circular that COC, if it decides, the RP can go register the flat and all. Now, what has happened subsequent there to I'll just hand up a chart to your lordships. I'll just give as many charts to my friends appearing. At least, no, that's not for you. Yes. Now, if your lordship sees this chart, already some of the flats have already been deed of conveyance has been already been executed. Would your lordship sees the chart first? CA 62. We have the deed number. Already we have the deed number
registered.
So CA 62. Extra. CA 62 can be disposed of. I don't know who is appearing for CA 62. Now CA 46, its deed number is awaited. Its registered deed number is awaited. CA 47, your lordship sees, we have the deed number. Then for CA 60, 50, 54, it's been processed because they have nothing. It's pending. Now, CA 7, we have the deed number. CA 66, we have the deed number. 7 registered deed number is awaited. And 81 is pending. These are the people who have paid the entire sum of money.
Which one?
From item 1 to item 9.
Item 1, 2.
Item 9, the first lot, my lords, item, they are the home buyers who have paid entire consideration. No problem.
Only some of the persons is required to have the deed
registration. Yes, my lord, it's been processed already. My lord, I hope, my lord, if someone is there among 62 to 81, 81 I heard. 65 is
65 is not here.
No, 65 is in the other lot. My lord, I'll coming to the so my lord, 46, 47 and 66 can be disposed of then. My lord, if my learned friend is there, my lord, they can, my lord, this.
Okay, I will then
Yes. So my lord,
so 62 nobody is there. 46 you
46 my friend is there, my lord.
Yes, 46.
47 and CA 66. My lord, item 2, item 3, item 7.
So CS 46 awaited, deed is awaited, but you are
Yes, but it's registered, the number.
Okay,
It's done.
Okay.
Yes. Now, my lord, the remaining ones would your lordship sees from 10 to 29. From this, my lord, from the records that are available with the RP, it's showing because, my lord, the RP was not given any books of accounts by the erstwhile management of the corporate debtor. But whatever little we could get, my lords, from item 10 to 29, the sum that are due and outstanding are mentioned in that chart. From the home buyers. Once that is paid, my lord, automatically, just like the other matters, my lord, it will be registered.
So nobody is there. Why?
I am there in
For
item
item?
24 if your lordship takes in this chart.
Item 24.
81.
C81. Item
Yes.
24.
18,702.
18,702.
So you can pay can pay your 1 fee to the
Whenever that day comes. As of now, my lord, we have.
I mean, I don't know. We were having a discussion, very light conversation about this. Now that the national company law tribunal shifted to near the, we oftenly say near the Bangladesh border because we get network connection. Then, nevertheless, we were discussing. It takes almost 1,500 rupees on an Uber to and fro for the juniors to go. And we were discussing the we started off with 340 rupees practice way back in 2011. Now, if you expect the juniors to start practice at 340 and 500 and go there, then there'll be only liability, no nothing on the chart. So, I mean, let's not discuss about 18,000 feet.
As far as item 24 is concerned, my lord, if your lordship takes this email, we have already written to the RP that we are willing to pay the 18,700. Thereafter, the RP has been very cooperative. We have met the RP. My lord, this will be resolved. Either paid or either way, this will be registered.
It's 18,000.
Yes, my lord, it will be paid.
All these, my lord.
21.
Yeah.
10, 11, 12.
Okay, 21. And with RP, and we are willing to pay.
You're good.
So, my lords, your lordships can record that and that willing to pay and direction for registration, my lords, can be given. That's not a problem.
21. We have paid all the dues.
21.
Can 65. Item number 31.
31 kothay ache?
31 is
There is no 31 on the list.
29 on.
That it's item 15. Item 15 on the list. On the give the chart. 15.
Item number?
We have paid all the dues.
Chart. Wait, photo name. Photo name. Photo name. Right at the chart. Right at the
61. 31. 65.
Well, item 15 on your lordship's list.
Yes, it is there. So, you paid.
No, so, but it's written received rupees so and so on 18 and for balance amount provided proof of payment maybe for CRP. Well, we have asked for proof of payment. As of now, it's been showing as 2,65,542. No. So just
So you do one thing.
Sit with the RP, show the proof of payment.
You go with the show your proof of payment and show to the CIRP and
communicate with the RP, Malad, and because RP
then he will give the list to him.
Lord, I am doing that to resolve all the matter because Malad, otherwise I'm not Malad.
Public interest doing it.
Otherwise, Malad, and to reduce your lordship's cause list, Malad, so that Malad, at least out of 38 matters, 30 matters go outside the company court.
That's why I'm telling to my officers, I find earlier only the 13, 14 matters in the company matters. Now I am finding the 90 matters in my list, in the company list. So I have to say, no, company court has to be established.
But we are more than happy if it is, if comes back from NCLT to company code.
True. That's
All of us will agree on
yeah,
that.
that item was one
Not because of the distance and anything. We thought that we are much better off in the company code when it went.
So far in respect of the official liquidator is concerned, because most of the property is under the possession of the official liquidator. And one of the some of the properties which certificate was also given for handing over possession prior to the liquidation, that was there. So I am neither doing anything.
That's right.
But that's why I want.
That's why
this
now
thing
only the
I have to know, because ultimately possession is required to be handed over. But I do not know which flat. Kindly see, the deed is there, but which flat number I do not know.
No, that is there mentioned in CA, the respective CAs and all. I'm sure he has a copy of it.
I will see
Because may I say this?
Yes.
Would your lordships then, I don't think there is anybody else who is appearing.
For item number 25.
Serial.
You are appearing for whom? Huh?
No. Not old, not
One
old,
to,
not
1
old.
to 9 you are there. 1 to 9.
Which দেখো না অয়ন ওইটা দেখে দেখিস না সিএ নাম্বার দেখে বলো এটা দেখে বলো
Let's just disclose one of the flat numbers, because it's very difficult.
Now then I have to disclose my order also, it has to be recorded.
Yes. These are mentioned in the respective CA. So কোনটা বলো কোন CA নাম্বার গুলো বলো তোমার?
CA number 61, which is serial number 14.
14 very well.
14 received rupees.
Result, we have paid the balance due.
Yes, received 10 lakh.
It's received.
10,000. Yes.
77, serial number 20.
Yes.
Have result that
Not available.
14.
No.
No. There is a due, but not available. Records
Document is not available.
You need to sit with the RP to show the proof of payments.
So, Lordship, I am subject to instructions that the petitioner has presented the RP, Lordship, and thereafter shown everything, and the RP was satisfied that they are.
So has he called you for registration? I have to take because so then that's what I'm saying. If it's the RP is taking if they have confirmed.
Just confirmed that there are no rules now.
Which one?
CA 77.
20.
20.
Yes.
Then your lordship, CA 67, which is serial number 26, we have paid.
Received.
Yes, Malad. So Malad, all these will be registered because I'm sure they have been told inform them about.
CA number 26, 67.
CA 67
and also 27.
27 is receivable.
27 is not received.
We have already paid.
This is show.
Then it has to
be updated in the record.
Let it be updated and come on the next date.
Yes, very well.
2nd July.
Very
okay,
well.
You pay. Let it be updated and come with the list.
Yes.
Or you get the certificate from the CIP. So
I
am coming.
The ones which were in the top list, those to be disposed of.
46, 47, 66.
Right.
Correct.
46, 47, 66. This has to be disposed of. Malad, yes, Malad. And Malad 65, my learned friend is there.
You're 65.
65.
Serial number 15, my lord.
সেটা কি ওরা বললো না একটু 65 ও বললো তো একটু বলেছে তো
Received 17.
He has to my learned friend, my learned colleague mentioned just now, he has to approach the RP to reconcile the accounts.
Because only 17,000, so but pending is 2,65,000. So you have to.
They have already paid, but the slip was not presented before the.
Correct. You go to the CIRP, show
the RP, show the bank statement, the proof of payment,
whatever it may be. Then it may be renewed and come with the certificate or like this. Then the court will pass.
My lord, for item number.
27.
CA koto? CA koto? CA 11 is not running.
No, that is not running.
Malad, this is Malad accounts to be updated. Malad, my learned friend for that.
Update, then come. Update and come. So any other?
For item number 25, it shows that we have to.
Receivable.
Yes, my lord. Yes, my lord. But my lord, what had happened was there was a report submitted by the RP pursuant to the order of this honorable court, mentioning a figure that around 5,40,557 was due from us. consequent to that report, we have made that payment of the residual amount, and we have sent a letter to RP also stating that we have already made the residual payment as per your report only.
Lord,
But
let
my
him
lord, we
sit with
haven't.
the RP, it will be done. If in case they show the
My lord, we have given the RP the letter along with his report.
Okay, you do one thing. You next go to the RP and said this amount. If he say now this is not the amount, my mistake it is there. So convince
be
if it is.
reconciled, my lord.
I'll be.
The
My
RP
lord
is,
just
it's not an
sees this
adversarial
letter.
litigation.
My lord, if just my lord sees this letter.
Lord, I can't, my lord, my lord, verify each and everything because my lord, the RP is not here. I have not been served with a copy also.
Yes.
But the RP has been served. This
Erroneous.
is the report of the RP.
No, I have not been served.
This is the
Okay. Okay.
payment.
Buyers handed over the HON'BLE code India. It is written by you, na?
Yes, my lord.
Let he verify. Let he verify and come.
Very well, my lord.
You send this. You have supplied this letter to the RP.
Yes, my lord.
Let the RP declare it is erroneous or you have to pay. If it is clear, then the court will pass an order. Disputed question, how the court can.
My lord, if my lord can only direct the RP to consider this.
You
letter.
go. If it is not considered, then come. First, you go to the RP. You have submitted this letter.
Yes, my lord.
So go to the RP.
Lordship, item.
Just approach his.
Lordship, item
Meet him,
number
ask your
12,
client to meet
I
him
am
and get it done.
for
He's
the
doing it for
applicant,
everyone.
and
Why not?
item number 40, I am for the respondent. Those two matters are item number 12.
Item number 14, a respondent.
12 and 40.
Ah,
12 I am for applicant.
Yes,
and
yes, CA number ta bolo.
number 9. 12 হচ্ছে 9
CA 9.
আর CA 74.
Okay, I am taking from the
9
list.
and 74, I don't have it.
That will be better.
Maybe some other matter.
So I am coming by this list.
Yes.
Then we'll tally this and
yes,
I'll pass off.
yes.
Item number.
Lordship, my instruction is those.
Okay, I am calling the list. Item number 8. What is C82?
Your Lordship, I am appearing for the applicant in the.
C82 is not here.
You know, 82 is not a home. 82 is Reliance saying that we had given a property on lease to the corporate debtor. They wanted possession of it. The court allowed that, but without this thing. But now, your Lordship, Section 14 moratorium is there. Even the lessor cannot recover the property from the lessee if it is in possession of
Your
the
Lordship, on the last occasion when the matter was.
Yes, I said I'll not move it.
Okay, I am not taking the matter. Pass over next week.
So just that interim order should be extended.
Maybe
83 interim order should be extended.
20th, Your Lordship.
Not a problem.
Okay.
Interim order may be extended.
Item number 8. As per the submission made by the counsel for the petitioner. You are for the petitioner?
Applicant. Yes,
Applicant.
in CA.
The case is adjourned. Let the matter appear on 20th August 2025. Interim order is extended till 27th of August 2025 or until further order, whichever is.
Which your lodges may keep it on the 27th.
27th,
Malaj. Both of us are agreeable. 27th.
27. Now 9 is CA 83.
Both are connected, Your Lordship. Item 8 and item 9.
8 and 9.
9 is where the interim order has to be extended in CA 83.
Okay. Interim order in connection with CA 83. Yeah. Okay. Next. Item 10.
The matter in which we have already paid for the report of the RP.
That one.
Yes.
CS6.
Yes.
Okay, I am adjourning it. I am not passing any order. You go and check. Come next week. Not today. 10 is not today.
Item 10, will you take this on record or should we?
You go. If it is not come with the application, then I will direct. Before that, you go and because you have submitted the representation, you meet this RP. If it's taking care of it, if it is otherwise, you come with an application, I'll pass it off. Yes,
my request to my friends is let their clients not just write a letter and this is.
Oh, that's what I'm telling. Go and say
their phone numbers and because he's very cooperative. He's doing it for everyone.
Yes. Go.
He's doing it for everyone.
With your client, sit with the RP, show the payment. If it is there in dispute, it can be resolved. Yes, 11.
Your Lordship, the registration is complete. The number 8 in that table, registration is complete.
8. Did not awaited. Okay, record and not. Where is item number 11 there?
But your lordship just can record that it's been registered. They want to withdraw the withdraw as infructuous. This
No, the
stuff has
plot number
withdrawn.
plot number is to be. Otherwise,
Oh,
the
but that I also don't have. I don't have copy.
What is the flat number?
He also does it. It's
There's no schedule.
Just kindly direct the RP Malab to submit a.
We'll file a composite report on the next day with the deed number and the plot numbers. We can do that.
Flat number 1E.
Where you got?
1E, block 3.
Where you got?
Page number 32.
Okay, I am not record 11. Counsel for the applicant submit that deed has already been registered, and as such is not intending to pursue with the present application. In view of the submission made by the counsel for the applicant, CA number 30 of 2019 is disposed of. Next. This is which one? 8 na? 12.
Lordship, this is my application registration. CA number 9.
Oh, there are this 9 and
9 and 74.
This has to stand over. These two people are claiming the same flat.
Yes.
So title dispute that can't be anyway be decided by your lordships in a company jurisdiction right now.
Lordship, my prayer is kindly hear the two matters separately.
Okay. No
CA
problem.
number 9 and CA number 74.
Serial number?
CA number 9 and CA number 74. Serial number 12 and 40.
12 and 14.
12 and 40.
40.
These are anyway not included in this list.
Okay. So I am not today. Come on the next week. Not today. Serial number not today. Not today only. Yes, next.
Your lordship, 13, 14 and 15 is not here in the list provided by the RP. It has to be taken up.
Number CA number bolo?
CA number 13, 14, 18.
13, 14.
18.
18.
All right, I'll take instructions. It is also
Not today.
registration.
13, 14, 15, not today.
Oh, listed in a code.
Table does.
These are for registration.
Yes, absolutely.
Well, we'll take
Not
it.
today.
Not today. Okay. Very
Yes, 16.
Registered already.
CA number 19. Which number?
16 is CA number 19.
19. No, in this it is there in the list.
Yes, your lordship. Yes, your lordship.
Serial number?
CA?
Serial number 9.
9.
Anuki Devi Agarwal. Yes. CA 81. That is CA 81. Aha, ওইটা নয় ওইটা কেন দেখছো বারবার বলছি এটা যে দেখতে
CA 81.
Your lordship.
No, it is not there.
It's not there, but she's seeing a differently.
CA 18 is
Yes, CA 81 is not. It is not. So there is some dispute.
CA 81 is by whom?
Kindly come to 9.
It's there. It's item 9. It's item 9.
Lordship kindly sees the cause list.
Ah.
CA 81 is the old number. The new number is CA 19.
It's item 9, Malaj. It's been also same order. Same order. It's been done. The registration has been done. It can be disposed of.
Old number is 81 of 19.
Yes.
81 of 19.
Yes.
And your serial number is 9.
Yes, serial number 9.
But you kindly see that is completed, not completed.
That's completed.
Completed.
Your lordship.
Malaj, this list was prepared for last week. So, Malaj,
16.
in between also.
Counsel for the applicant submit that with respect of the flat of the applicant, deed has been registered, and as such nothing remains in the present application in view of the submission made by the counsel for the applicant. CA 18 of 2019 within brackets old CA 19 of 2019 old CA 81 of 2019 is disposed of. Yes. Then next.
17, 18 and 19 is yet to be considered by the RP. It's
Not today.
In that table.
Not today.
So CA?
CA 21, 22, 25.
Next. 20, CA 36. Not there, not today. Next.
Your Lordship, 21 and 22 already registered.
But your Lordship says CA 46 in the previous one.
No.
36. So sorry, I'm sorry.
Serial number 2 and 3 in the table.
2 and 3.
Yes, Your Lordship.
So first is 2. First is 46 is a 2.
Yes, Your Lordship.
Same. Counsel for the applicant submitted. In respect of the flat of the applicant, deed has been registered and nothing remains in the present application. Accordingly, CA number 36, CA number 46 of 2023 is disposed of.
Same order for 22, item number 22.
2247. Same order.
47.
22 same, disposed of. Next. 23.
23, 24 and 25 yet to be taken up by the RT for consideration.
23, 24, 25, not today.
CA 48,
52, 54.
26.
52 is there. No, Malad, it's there. It's there.
Which one? 24.
52 is there. And 52. And what was the other thing?
But,
What is he said?
Your Lordship, we are yet to take instructions from our team.
29. So CA 52 will be, Malad, they have to, Malad, make this payment.
Yes. Tax receivable.
Yes.
Next. 26. CA 55.
The CA 55 is done already. But Malad, the deed, I think it's been processed. It's at item 5 on your Lordship's list. The list that I've handed up. CA 55.
Okay, not today.
Radhesham Agarwal.
Not today. Next.
Item 27.
56, your Lordship, yet to be taken up by the RT for consideration.
Not today. Next.
Yes. 60. Malad, I think it's not been done.
Not done.
Very well.
Not today. Next.
29, your Lordship, payment is complete.
Photo, CA number?
CA number 61.
Received, yes. 14. Serial 14.
Yes, 14.
Same. Applicant, counsel for the applicant submitted. Plat, with respect to the plat of the applicant, deed has been registered and nothing.
No, deed has not been registered.
Deed has not yet been registered.
Deed has not been registered, Malad.
Payment is complete.
CA 61 payment is complete. Deed is not registered.
So
simply not today, Malad.
Not today.
Simply not today. Approach the RP and this.
Not today. Next. CA 64. Not today.
My lord, I'm for the applicant. But the proof of payment is required to be provided to the RP, my lord.
Made before the CPI. Not today. Next.
Your Lordship, the item number 32.
32 is what?
Item
CA number?
Serial number 14 in that list, your Lordship.
CA 61.
Yes. But it seems it
No.
No, where there is a 6624, is a 6123.
61 is item 14.
yes. It's which item number is taken 32.
66 is not here.
66 is not there in the list. Your
And not today. Next.
Lordship.
6724.
Not there in the list, your Lordship.
Not today.
34, 35 and 36 minute I'll have to take instruction whether if it can be.
What was CA number? CA number? 68.
Not today. 34, 35, 36.
68, Malad, its receivable is there. 68, 69 and 70.
70.
Malad, its amount is receivable from them. It's item
I'll have to
16,
take
79.
instruction whether Millet.
Go sit with the CRP, IRP and
CRP and do the resolution professional and let's get it fixed.
yes, 37.
37, 38, 39. I am for the applicant.
39 actually, 38 will be the matter.
CN 71.
Yes, 71, 72 and 73.
71 is receivable
Yes, my lord.
and 72 receivable. 73 receivable. Take instruction.
My lord.
Not today. 37, 38, 39. Yes, next.
Only one ticket. Item number 32. The registration is complete. It can be disposed of.
32.
Yes. I missed. It's my
66 of 24.
item number 7. Your Lordship.
66 of 23, my lord.
Here is the 23. Here is the 24. Here is the 24. Okay.
Your lordship,
Name is same.
Naveen
So where is the file?
But maybe then, my lord, mistake from our end.
Item number 24.
होता ही पड़ा है तो।
32. Item number 32.
petitioner's name is Naveen Kumar Pandey.
হ্যান্ডলেস কাজ করাচ্ছিস দেখেছিস তো তোমার দশটা হ্যান্ডলেস কাজ করতে কাজ করি বেড়ে গেল ইউ থিঙ্ক দ্যাট এখানে আমি 10 টাকা করে কাজ করবো
Mr. Banerjee has appeared in 50 matters in 50 seconds. And that is something that
and they think everyone is generous to give me 50 fees. I'll leave practice for the year right now. If I get the 50 fees right now.
Naveen Kumar Pandey.
Yes, your lordship. Serial number 7. In the list.
Yes,
Here is item number
This is that.
32 ना. Item number 32 dispose of में आएगा.
CA 66.
Item number 32 counsel for the applicant submitted. The nothing remains. Dispose of 32.
Yes.
Yes. Next.
Item.
What has happened? 40. 40 also not today, na?
40.
Not today. Next.
41, my lord, as per the list, it shows, my lord, the payment has been made. I'll have to take instruction with regard to the registration.
Received payment.
Yes, yes,
Not
received
today.
payment. Yes,
Not
this
today.
should go on. Yes,
Not today.
yes.
Your lordship, kindly sees serial number 20 of that list.
Yes.
Payment received in full.
Order as payment made in full. Yeah, this should be, I think, registered then.
Registered. Not today.
Not today. Yeah, approach kore na.
Yes. Next.
43, I am for the applicant minor, serial number 21, amount receivable.
Receivable. Not
No,
today.
not today. Malad, she has to pay.
Yes. Receivable.
Yes.
Yes.
Not today. Next. 44. 79.
44 is 79. 79 is item 22 on the list.
Received.
Yes,
Registered
received on 26/6 so and so.
Not today.
So it should be, they should approach and they should
Not
get it
today.
done.
Next. 80. Receivable.
45, yes.
Received but not registered.
Yes, Malad. 45 is 80, yes. Yes.
Received, not registered.
Yes.
Not today.
Milord, 46 is item 24, Milord. I handed over the email that we are willing to pay. Milord, just grants a simple not today. We'll come back with whatever.
Not today.
Your lordship yet to be taken up by the it's not itself.
Not today.
40?
47.
What is the C number? 84.
Yeah, 84. 84 is not here.
Hey. Yes, Malad, we'll take it.
Not today. Huh?
For the official liquidator.
CA 76.
Not today. 70, CS 76 not there.
CA 76. Malad, 76 is not there.
Not there. Not today.
76 is not there.
Not there. Not today. Yes, next.
49 for
49,
I am for the
49.
official liquidator. Yes, I am for the official liquidator.
This ends the Avni matter Malad, till 48. Your lordship has kept it on 27. Malad.
अभी जितना मैटर है ना ये सब 27 को है.
On the top, Malad, so that we can come and complete.
27 को ऊपर में कर दो ताकि जितना होगा देख लेंगे.
I am grateful.
ये कोई में रख लीजिए. Disposal individual. 76. निकाल नहीं क्या कॉल करो. हो गया. ठीक है. नेक्स्ट. 49.
Lord, I am for the official liquidator. Lord, your lordship, kindly see these are the
Fire general insurance.
yes, madam. Lord, that
Directed
is
to
with
verify
regard to
whether the quotation complied with all requirement. Yes.
Madam.
Have you verified the quotation?
Yes, madam. Kindly see there is a minutes also
Uh,
in between the parties.
Yes.
Kindly see the minutes of the meeting held in between the parties.
Yes. So let us submit the report. Further quotation.
Yes.
So I am adjourning for 2 weeks. Learned Counsel appearing for the official liquidator has handed over the copy of the minutes of the meeting dated 30th July 2025, wherein the representative of Messrs. Elegant, ELEGNT, System Power Web Private Limited stated that quotation for cloud storage, server and AMC will be submitted to the office of the official liquidator through email within a day or two. In view of the above, the case is adjourned. Let the matter appear on 20 or 27? 27.
27. I'm deeply obliged.
The minutes of the meeting be kept with the record. $50.
45, 40, 49 and 50, all three matters are same, related to each.
Similar.
Same order may be passed.
49, 50, 51.
Now, 49, 50, 51.
49, 50, 51, same order, huh?
Same order.
Chapter 52, I'm for the official liquidator. Lordship, the company has been dissolved. On the earlier occasion, Minor has been pleased to direct the official liquidator to submit a report. So, accordingly, I'm filing the company has been dissolved, and Your Lordship, the necessary funds have been.
So, for what remains?
Zero.
So, I am accepting this report
Lordship.
and I am disposing of CA2.
Lordship.
What about the CP?
Lordship, that is the CP arising out of which the binding everything goes,
total.
Lordship. Everything, the company, the proceedings of this company closes.
Record and order. Learned counsel for the official liquidator has submitted the report. Let the same be kept with the record. It is found from the report that in terms of the order dated 18th June 2025, the official liquidator has deposited the balance amount of the company in liquidation with the company's liquidation account as per the provisions of section 555 of the Companies Act 1956 with the Reserve Bank of India, Kolkata. It is also found that by an order dated 7th June 1966, the company has been owned up and the official liquidator was appointed as liquidator of the said company. Now, the company has been dissolved and amount has been deposited. Considering the above, this court find that nothing remains in either in the CP 169 of 1965 or CA number 2 of 2024. Accordingly, a report submitted by the official liquidator is accepted. CP number 169 of 1965 along with the CA 2 of 2024 are disposed. Next.
53 and 54, my lord, are two similar matters. Your lordship would recall. Your lordship had passed, my lord, kindly sees, my lord, order dated June 18, 2025. Your lordship wanted us, my lord, to give an opportunity.
A fixed matter, tha, na? It will take long time.
Short.
What is the order?
Very short matter. Your lordship wanted us, my lord, to give our, my lord, whatever evidence we have with respect to our claim from airship. Lord, we have submitted few documents, but Lord, they are asking for succession certificate. Lord, that will take much time. Your lordship knows, Lord. Kindly sees, Lord, what documents we have given. Kindly, Lord, have a look, Lord.
Death certificate, copy of certificate, Aadhaar cards. So who are the applicant now?
Lord, I am the applicant. I am not the heir of the contributories. Lord, I want, Lord, there are no, Lord, liabilities left with the company, only the assets. Lord, those assets have to, before dissolution, Lord, the assets have to be distributed to the heirs. Lord, I claim that I am only the remaining heir. For that, Lord, I have given an affidavit affirmed before the magistrate also. Lord, they are asking for probate or, Lord, letters of administration or
do one
succession.
thing. Take this and you submit the report.
Lordship, it's a monetary claim. So
Correct. That's what I'm telling you. Submit the report. After submitting the report, if it is required, by this order, the publication, wide publication is to be made. If any is coming, then we can direct. If nobody is coming,
oblige.
That will be
Lordship,
better.
this is for 53 and 52 is my application for dissolution. So unless it is
53 and 54.
Unless it is accepted,
54.
unless it is cured.
Yes.
So
The earlier
if it is cured, then the dissolve automatic.
That will follow.
So you do one thing, whatever the document they have given, to submit the report, what difficulties you are finding. If it is not, then the court will pass appropriate order. Publication
And
is
it
to
will
be
save some time also. Oblige, Lord.
Grateful, Lordship.
I am not passing any order.
Lord, passes an order. Passes an order. Passes,
Counsel for the
passes an order.
counsel, counsel for the applicant submit that in terms of the order passed by this court dated 18th June 2025. The applicant has submitted relevant document showing that the applicant is the legal heir of
Lord, the contributory, Lord.
is the legal heirs of the contributory, namely Surekha.
Yes.
Ratanlal Surekha and
Rajkumar Surekha. Heir of Rajkumar Surekha, who is, Lord, the only son of Ratanlal Surekha, being the contributory of Lord.
Legal heirs of Rajkumar Surekha and Beena Rani Surekha. Counsel for the counsel for the official liquidator submitted, though the official liquidator has received the documents and he prays for time to file report. Let the report be filed within 2 weeks. List the matter on 20th August 2025.
Grandfather's property.
2020.
20.
Grandfather's property.
Yes.
Grandfather's property.
Let's see what it. Item number
55, 56 and 57.
My lord, it's a 1 minute matter. My lord, 55, 56, 57.
My lord, this is company application, my lord. I am for the applicant.
No, fixed matter, 3 p.m. matter.
Lord, I am for the official liquidator.
Yes.
My lord, as per your lordship's order, my lord, we have communicated, my lord, Mrs. Paranjay Konar and Associates for the purpose of, my lord, the demarcation. My lord, we have received, he has done so, but we have received a letter.
Which one?
My lord, not about Dotto matter.
Item number?
Item number 6.
5, 6 and 7.
CS 26. CS 26.
No, fix.
My lord, item number 6, my lord, I am appearing for the applicant, my lord, Ranjana Datta.
5 is being called, so they have to wait for 6.
5. Let the 5.
Right.
Item number 5 first.
Well, this is the matter with the compilation, which we think is convenient, but it is indeed inconvenient. So, well, I'll now try and make things convenient for your lordship.
Prior to my lord making things convenient, my lord will kindly see my lord last order, where my lord recorded that he has to clarify that he is appearing for whom. Let him clarify.
Yes, I have taken instruction, Mr.
Yes.
We are appearing for Arundhati Datta.
Only Arundhati Datta.
Well, there are 2 applicants.
Yes.
So we are appearing presently, my lord.
No, not presently, my lord. Let them say only Arundhati Datta.
Well, then we have to say more. If he is insisting, we have to say more. Yeah.
No,
so you please.
You are arguing on.
I am arguing on behalf of Arundhati Datta, one of the applicants. They have caused the other applicant not to pursue. So very good. So we are. So far as Arundhati Datta is concerned, yes. Well, on the last occasion, I had shown to your lordship the division bench judgment.
Yes.
But if your lordship recalls one thing, probate granted, division bench, probate rejected. Matter goes to the Supreme Court. Now, Supreme Court, my lord, who takes the matter to the Supreme Court? My lord, the executrix
of the will
and the beneficiary. So it was the beneficiary's appeal. Now, my lord, interestingly, my lord, kindly take the cost title of the SLP. My lord, kindly take the cost title of the specialty petition. We were the caveators here. So we were naturally parties to the appeal proceeding before the Supreme Court.
Yes. Supreme
My lord, kindly, I will trouble your lordship once with one of the volume. My lord, kindly take volume 10. Volume 10, 1442 of volume 10. Body.
Yes. 144.
1442.
1444.
It's okay.
1444. Atanu Datta was the applicant.
Correct. Now, my lord, let lordship sees the 1444. Correct. 1444.
As same as
My lord, kindly see Rama, Surojit, Sharbojit, Anima. So Anima was my mother. So Anima was my mother, but these were the caveators. Now, my lord, your lordship now will see this specially petition. There was a compromise petition filed in the specially petition on the basis of which the specially petition was disposed of. My lord, kindly have a look at the terms of settlement first. The terms of settlement is in volume 4, page 226. Two to six.
226.
226. কত?
Volume 2. Two to six.
Yes, madam. 226. No, 226 is terms of settlement.
No, 226 is the order of this court. Justice Pateria order.
But my 226 shows. এটা দেখো, এটা দেখো, দেখো, দেখো না।
1326.
One যেটা উঠে দেখো না। এই তো, volume 4. এই তো, এটা দেখো না, এটা কি? 226 না কি?
না, এটা তুমি application করতে। ঠিক আছে,
না, এই তো
তুমি
volume
এটা থেকে
4
refer
তো।
করো। Volume 9, 1326.
ভলিউম সব বহুত এখানে কি করে এলো আমার kindly take volume 9 1326 at least the 26 is common. I am at 226.
This is the type 2.
But kindly see that settlement is between, I have shown your lordship the cost title. Now see the settlement is between Otonu, Roma, Shurojit and So Anima is not a part of the settlement. Now, my lord, your lordship will see now the settlement.
But Anima was alive at that time.
No, my lord,
in the SLP it is recorded as she died late.
No, that was later. If your lordship will see.
Of terms of settlement, she
was alive.
She was alive.
And kindly see the date
She
of the
died
terms.
2001 after probate was granted.
Probate was granted by whom?
High Court.
My lord, kindly take, my lord, the terms of settlement clause A and B.
First, if 1444, 1444.
Yes.
Post title of the Supreme Court.
Yes.
SLP.
Yes, my lord.
It is recorded late Anima Datto.
No, but she died thereafter.
They are referring to the application they filed in Supreme Court, recalling application.
Correct. He is right. He is right. He is right.
That's filed in 2023.
Okay.
He's right. He's right. That is the application seeking leave to recall. So that application which stood rejected, so that is the cost title of that application.
Okay.
So where is original SLP? Now, where was that? Where was I? Now, kindly take the terms of settlement, clause A and B.
Yes.
Parties herein above have resolved in the premises above and proceeding and have settled the disputes in the following manner. So they have settled their disputes in the following manner. Well, this is in a, my lord, kindly make a note that this is arising, SLP arising out of a probate proceedings. So the jurisdiction of the testamentary court is limited. This is not a regular civil proceeding. It's a testamentary proceeding. So in a testamentary proceeding, there's a compromise. Now, I'll take your lordship to the judgments. What is the effect of a compromise in a testamentary proceedings?
permissible?
No, absolutely not. Terms of settlement. Says A, the probate case be allowed and the judgment and order of the division bench of Calcutta High Court will not be given effect to, which is the judgment by which the probate was set aside, and the probate be granted to Otonu Dotto, the appellant above named. So they inter se agree on this. Who will the probate be granted to? So probate court has rejected. Now by compromise you will grant the probate. Now let kindly see Otonu Dotto. B agrees to transfer assigned respondent share of Yudhishthir Dotto in respect of these two properties, which is not relevant at this stage, my lord. What we are concerned about is A. Now, my lord, apropos A, my lord, kindly first take the judgment of this High Court, which has been affirmed by the Supreme Court not on one occasion, repeated occasions. My lord, AIR 61 Calcutta, page 359. তোমরা একটু এটা ফলো করবে নিজেদের গল্প না বলে জাজমেন্টটা বার করে দাও যাচ্ছে
1961 Calcutta.
ये AIR 1961 Calcutta 359 Division Bench Judgment of Justice PB Mukherjee. Till date followed by the Supreme Court.
Parapet, that's why.
My lord. Kindly take para 22. So, my lord, the proposition which I wish to address before your lordship is that if there is a settlement in a probate proceeding, A, what is the effect of the settlement? B, even assuming if there could have been a settlement, the settlement is at best binding upon the parties who chose to enter into that settlement, but not beyond that.
Parties to the agreement.
Parties to that settlement. A, first is, what is the effect of a settlement in a probate proceeding?
Correct.
Is it permissible in law? Number two is that if it is permissible in law, it is inter se the parties who has chosen to enter into some kind of an arrangement, whether it is terms of settlement, otherwise. Now, before this, my lord, I should have shown your lordship one thing, my lord. It is my mistake, my lord. Lordship will pardon me, my lord. Kindly see the Supreme Court order by which the probate the SLP was disposed of. Just a few 2-3 lines order, my lord. This your lordship will find. I hope that page number tallies. I'm sure it wouldn't. 1197 is what I have, which should be a part of volume 4. Right? Supreme Court. আরে তোমার তো এখানে লেখা আছে এখান থেকে বার করো আর তোমরা কি দাঁড়িয়ে দাঁড়িয়ে তোমরা একটু হেল্প করো অ্যাসিস্ট করো পেজ নাম্বার গুলো বলো আমাকে বলো না সত্যি তাই ভলিউম 8 1197 মানে 1197
Yes.
volume
Volume 8.
Yes, it is there.
My lord, grateful. A joint application dated such and such. My lord, kindly make a note of the date as well, my lord. Page 1197. A joint application dated 11th of March 2000 has been filed by the appellant and the respondent number 123 to record a statement arrived at between the parties. Kindly make a note, to record a statement arrived at between the parties. The original of the terms of settlement has been signed by the parties. Application has been signed by the council. Terms of settlement are annexed to the joint petition. It will therefore be treated as an order in terms of the settlement, to the joint application. IA and appeal are accordingly disposed of in terms of prayer A and B of the joint application, compromise application to form a part of the record. Now, my lord, interestingly, come to my lord A and B. A says what? Not to give effect to the division bench judgment. I will show you lordship judgment or what do you mean by when parties say you will not give effect to the judgment. So it will be inter se between the parties. a declaration by a court is a pronouncement in rem. A testamentary court, when it grants a probate, it's a declaration of the fact that the will, which is a conscious decision of the court by looking at the will, that has happened. What? The probate court is the court of conscience. What does it do? It cannot be influenced by a private arrangement. Court gives the seal of the court that yes, authentic will, probate granted to the executor. Now, what is inside the will? The probate court does not decide title. So the appeal court said no, probate cannot be granted to this will.
Correct.
So rejected the grant.
Correct.
So by compromise, you cannot undo what has been done by the division bench. So there cannot be a grant on compromise, unheard of in law. So now, my lord, you apropos this, my lord, kindly have a look at the judgment of the Calcutta High Court.
What would be effect of this Supreme Court order?
Supreme Court did what? Supreme Court said what, my lord? Kindly let us have a look at the Supreme Court order. Some parties came, said settled, terms of settlement recorded, disposed of. Disposed of. There is no adjudication of any rights, anything. So it was your special leave petition, like I come before your lordship's court, file a suit against defendants, say 1, 2, 3, and 4. I come up and say that defendant number 1 and defendant number 2 has settled with me. I file a compromise. Your lordship see 3, 4 days, said I want to withdraw the suit based on the terms of settlement. So why would the court look into it? Signed by the parties, signed by the advocates in terms of order 23, in accordance with law, disposed of. So now that settlement, the parties have chosen to settle their dispute according to the arrangement. Now, court did not adjudicate the validity of the claim of the plaintiff or the defense of the defendant in the suit. So no one can say that there is an adjudication of the disputes on merits. So in a proceeding, parties compromised. So the effect of the compromise is an arrangement which gives rise to a fresh cause of action to the parties, whatever they want to do. But there is the adjudication process has not been done, has not been undertaken by the court. So here is a situation where this was undertaken and the court came to a conclusion that there is no probate. Probate cannot be granted to this will. Challenge, compromise. So you compromise, that is an arrangement. So the court of conscience, the decision of the court of conscience cannot be affected by an arrangement inter se between a few parties.
Okay.
Now let's kindly take 61, Calcutta paragraph. So, my lord, effectively, if your lordship sees, the division bench order remains on, but naturally it has to be, if it has to be set aside, it has to be set aside by
Supreme Court.
the superior court. You cannot say by compromise I set aside the judgment of the court. You may say that the parties will not give effect to the judgment. My lord, it is one thing to say that, my lord, the parties have settled. Court has come to a decision. Suppose your lordship sitting in the interlocutory bench decides an application. There's an order of injunction passed. I'll take a cue from what fell from my learned friend. I suffer an injunction. I am the defendant. Then there's a compromise between the plaintiff and the injunction. Plaintiff and the first defendants out of the several defendants. That defendant says that very well, I will, whatever is your entitlement, I'll pay you. Let's come to a settlement. Because the injunction hurts me, you withdraw the suit. I accept it. I withdraw the suit. Now, Mala, does that mean the conclusion arrived at by the court while granting the injunction that stands set aside? So the court came to a prima facie finding and then granted the injunction. So that remains. Like your lordship will see that today, if there is a finding of a court
How does it remain?
Because your lordship will see, when a law has been decided, it can only be set aside by a superior court.
No, that's, see, I appreciate. As per the division bench set aside the probate.
Yes.
They challenge in the SLP.
Right.
SLP pending.
Right.
Out of 4, 3 settled with the appellant. And court has recorded that the settlement.
So let us make
not
it
to
things simpler for them. Let us say all of them are to an arrangement. Let us, for the sake of hypothetical, all of them agree to a settlement.
Not to give any effect in terms of the settlement of the High Court order.
No, that was the terms of settlement.
In terms of the settlement,
Yes.
not to give any effect to the High
Correct.
Court order.
Does that mean the finding or the proposition decided by the division bench of any particular court, or any court for that matter, that gets obliterated? So it is a reported judgment today.
Then if that order is not been given effect to, then the single bench order will be effective.
No, giving effect to inter se by the parties. So the judgment remains. Parties have chosen to enter into an arrangement not to give effect to that order because it affects their right. But does that mean the judgment, which is a declaration of a law in rem, that gets obliterated or that gets affected?
Okay.
So my respectful submission before your lordship is that never gets affected. A judgment can only be set aside, modified or altered by a superior court. Inter se by compromise, parties cannot have a judgment set aside because court has already applied its mind in a adjudication process, in an adversarial system of litigation, has come to a conclusion. Well, that is exactly what these judgments say. Well, kindly have a look at this. Correct. Well, kindly have a look at para 22 of the judgment in the Carapiets case. A point of probate practice of great importance, however, remains to be disposed of. The learned counsel for the parties appear to have agreed to certain arrangements for disposal of the estate of the testator. These terms, which are described as terms of settlement, are supposed to be signed by all the interested persons. We are asked to keep these terms on the record of this court. A court of probate always shies at terms of settlement. A court of probate is said to be a court of conscience, which is not to be influenced by private arrangement of the parties. Either it grants probate to a will or it rejects such grant. For such a court, it is said, there is no middle path for a happy compromise. The rule of law is stated to be that there can be no probate by consent. So, my lord, all this, that I have got this, you have got, you may have entered into an arrangement. That arrangement is inter se. Like it rightly pointed, I mean, this is the law as on today.
So what has happened after this order? After the Supreme Court order? Probate granted by?
Short point. Can this be heard by a company court?
Company court?
Company court. My lord sitting as a company court.
So, my lord, today, no, my lord.
Will my lord set
No,
aside
no, no.
probate sitting in a company jurisdiction? That's my only, my lord, I may be wrong.
Now, my lord, now kindly see what is my challenge here. My challenge is that I am one of the successors in the ordinary line of succession. Now, if Yudhishthir Datta, the testator, if the will which has been set aside, thereafter, that means, my lord, intestate succession. So I am one of the legal representatives in the ordinary line of succession. So I have entitled to share. Now, why before the company court? Because, my lord, this company in which Yudhishthir had shares had 3 contributaries. He was one of them. no creditors. Assets of the companies have been sold from time to time. The proceeds are lying with the official liquidator. Official liquidator has disbursed some of the proceeds, some are still lying. So I am not getting my entitlement as the legal heir of judiciary because.
So whether the legal heirs and title can be decided by this court, or you to get the title decided by the appropriate court, then you come with the title.
No, my lord, what I am doing is that I am saying that I am a legal heir.
Correct.
I have gone to the official liquidator.
Correct.
Now, official liquidator says, by referring to these probate proceedings, that you are not, I cannot recognize as you as a legal heir because of this probate proceeding.
Correct.
So he has rejected my prayer.
Correct.
So when I filed this application, there's a division bench judgment which says that this is considered to be an appeal from the order or the rejection of the official liquidator. So this is like an appeal. So whereas it has been rejected by the official liquidator. So my lord, I say that I am in the ordinary line of succession. I am there. So this has to be decided by the company court because it flows out of a company proceeding. Now, my lord, here the only situation is.
Yes, and until the probate has not been upset by the competent court, whether the company court can enter into the
Well, there is no probate in the eye of law.
Yes, they are telling
No, what they are saying, I'll clarify that. My lord. What they have done is.
After the order of the Supreme
Yes.
Court, probate granted.
No, there cannot be two probates. Probate has been set aside by the division bench.
No, subsequently, in terms of this, that's why I'm asking specific.
Yes.
After this 2000, the settlement decree
Yes.
and settlement order passed by the
Yes,
Supreme
yes,
Court.
yes.
Supreme Court, the date is not legible here. So after the order passed by the Honorable Supreme Court, whether the probate was granted or not?
April 2001.
Nullity.
Nullity.
Complete nullity in the eye of law.
Whether the company court can decide with regard
No,
to nullity.
your lordship need not decide it. All your lordship has to say is that when a division bench of a court, whether this court or any other court, even the division bench rejects the grant, then what happens? Then there is a compromise.
But when the probate was granted, where are you?
The mother was alive.
Where are you?
No, where were you, Bernard? I did not get notice.
If it is granted, so now they are having the probate, and the probate, they are claiming the probate, and the official liquidator has rejected your claim with respect of the probate.
No, my lord, I'll tell your lordship what.
So how this
The probate that they say that they have obtained pursuant to the arrangement, that terms of settlement,
maybe,
right? So that probate, based on that probate, they are saying that now that is a probate to which will, it is the same will,
correct,
in respect of which it has been rejected.
Yes.
So that subsequent grant based on the compromise is a complete nullity in the eye of law.
Correct. I am totally 110% with you.
So
But-
your lordship is that,
But
how would a
this
company court,
sitting in the company jurisdiction
yes,
can decide the probate granted by the competent court is not in accordance with law. If suppose the total court is with you.
and I'm absolutely, your lordship need not repeat, my lord. I have understood. Your lordship, my lord, if I may just paraphrase what, my lord, what is passing through my mind.
April 20, 2001.
No, my lord, I don't dispute the fact that they have obtained that probate pursuant to the terms of settlement. What I am respectfully submitting is that is a nullity. My lord, what is a nullity in the eye of law? There need not be a declaration in respect of what is a nullity in the eye of law. No court has to examine, my lord. There are law based on the Evidence Act, my lord. Your lordship is aware, my lord. What is ab initio void or what is nullity in the eye of law? No court needs to declare that. Suppose, my lord, hypothetically, if there is a contract which is contrary to Section 28 of the Contract Act, or an agreement contrary to Section 28, I don't need to go to court and seek a declaration with respect to that. It is a nullity for all times to come. A court, suppose, my lord, a matrimonial court.
But the nullity has been declared by the court. So which court is proper to declare that is a nullity?
No, I am saying that declaration is not required.
If it is not required also,
yes,
So the probate remains.
No, my lord, the division bench also remains. Now, my lord, what I am saying, so my lord, it's a peculiar situation I can appreciate. My lord, there are two things. One is a probate granted, possibly by the single judge here, and there is a division bench on the same will has rejected the probate. And apropos that, there is another situation, there's a compromise. There's a terms between a few parties. And based on the term, a probate has been granted. So now, would the company court examine that? Or who will examine that? If I go before the civil court, or which court will I go to? He said that if it is a nullity, it's a nullity for all times. So now, my title or my entitlement based on a legal A has been refused. So I say that my entitlement comes based on intestate succession. Somebody comes and produces a document and says that, see, you don't have a right, I have a right. So based on that document, it has been rejected. So I cannot go from the official liquidator's rejection to the civil court. So I can naturally come before the company court. So that is the jurisdiction that I have invoked. So now, in a situation like this, my lord, a nullity situation, my lord, I have to come back with your lordship with some nullity decision.
No,
my lord, I show your lordship a few judgments that I am saying. It says that this situation will create a situation where subsequent it will effectively become a nullity.
There was no judgment subsequent to Supreme Court order being passed whereby probate was granted.
There was a probate granted,
No,
2000 Act.
সেটা রেজিস্টারের কাছে গিয়ে ওই অর্ডারটা দেখিয়ে প্রবেটটা নিয়েছে কোনো কোর্টের জুডিশিয়াল অর্ডার নেই. This is the
No, but I am, my lord, I am told, my lord, if your lordship 16886, that's not a probate granted by the court, but it possibly by the registrar. Kindly, my lord, have a look at 886. But I don't know. I'll just have a look at page 886. কি দেখালে এটা? Volume 6. 392 বলছে। 392. It a probated part? Well, I'm not been able to understand. He says that a probate has been granted. Where is that probate? Let my learned friend first show which probate is he referring to before we go into that argument of nullity. Well, he is possibly referring to page 392. Well, 392 would be possibly Lordship volume 4. Volume 3. Volume 3. 392. তুমি দেখো না 392 টা বার করে kindly give me a moment. Kindly give me a moment, my lord. 392 আমি বলিনি ও বলছে।
Kindly come to 392.
392
handwritten probate.
দেখ 392 দেখাও।
I request my learned senior friend.
392 দেখাও না আমার থেকে বার করছো প্লিজ আমার
and judicial order let him make it.
How this probate was granted?
Who granted?
Supreme Court order settlements.
Supreme Court এর পর কোনো Calcutta High Court এর judicial কোনো expert নেই.
Drawn up the probate by the department.
সেই ডিপার্টমেন্টের কাছে সুপ্রিম কোর্টের অর্ডারটা দিয়ে কোনো probateটা drawn up.
Where is the Supreme Court order?
Supreme Court order, my lord, 1197. Volume 8.
সুপ্রিম কোর্ট থেকে ফেরত এলো এসে এখানে রেজিস্ট্রারের কাছে অর্ডারটা দিল দিয়ে বলল
Your lordship ballot got that. Well, 392 kindly have a look at 392. I was under the impression there is a probate court has subsequently granted a probate.
That's why I'm asking.
No. So they bring the Supreme Court that whatever that arrangement and get a probate drawn up.
My lord, who signs in a probate? After my lord grants the probate from the department, ও যা বলছে তুমি বলে দিচ্ছ না জেনে আমি তো অ্যাডভোকেট অন রেকর্ড অফিসে আমি কাজ করেছি।
Well, it appears that
probate drawn up করিয়েছি আমি।
there's a registrar high court original side. Well, there's a grant.
probate যা বলছে বলে দিচ্ছ আমার কথা শোনো একটু। It's been a false position.
Well, there does not seem to be any
সই করে probate সারাদিন probate drawn up করিয়েছি আমি বছর পর বছর।
তুমি তো জানো, আর কেউ না জানো নিশ্চয়ই আমি যে
Well, what my learned friend is referring to page 392.
according to this is not a probate. কি বলছো? যা বলছে দেখিও না।
Yes, correct. No, because if you come to the 1197.
Yes.
1197.
So, beloved, effectively what has happened is this drawn up probate is basically based on an arrangement.
Correct.
That arrangement says probate to be granted to Atanu. So that is being shown and a probate has been granted.
Probate case is allowed.
No, my lord, kindly have a look
And
at
that's why 1326.
one.
The prayer A.
Yes.
Correct. The first is the probate case is allowed. Probate case is allowed means the probate is granted to the will.
My lord, where is your lordship referring to?
1326.
1326. Yes.
A.
Yes.
The probate case is be allowed and the judgment and order of the division bench not to be given effect to.
Correct.
And the probate granted to Atanu, appellant above him. So probate
Be
granted.
granted to Atanu. So this was one of their terms.
Correct.
So this terms is between the three parties.
Correct.
So they bring this term to the Calcutta High Court.
Correct.
And have this probate drawn up.
Correct.
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 No, man, the question is that, my lord, what is the effect of this probate?
That's why if you are telling that
Yes.
as per this compromise, altogether four parties,
Yes.
including Anima,
Yes.
but Anima is not the party to the settlement.
Right.
And they arrived between these three persons along with Atanu.
Right.
So this Anima has not, the Anima share is not to be given effect to in the will.
Right.
It is your case.
Correct.
So if it is so, whether the company could go on into is to go into, or you have to file the appropriate application before the court with regard challenging the probate is not in terms of the Supreme Court order.
No, my lord, I don't need to say that. Why? I'll tell you, lordship, my lord. Supreme Court said what? Supreme Court just disposed of the proceeding based on the terms of settlement.
No, terms of settlement, prayer A is specific.
Yes, my lord. A and B of the terms of settlement.
And
Yes.
A is the probate case be allowed.
My lord,
Probate
kindly
case
have
allowed,
a.
then we have
Yes.
to go to the PLA. What is the
Correct.
application? What is the prayer of the PLA? There must be one prayer. Probate be granted in terms of the
Yes.
last will and
Yes.
testament of
Yes.
creditors
Yes.
also.
Yes. So prayer A and B was of the terms of settlement.
Terms of
My lord,
settlement.
kindly have a look at the order of the Supreme Court. I'll just read it out for your lordship's consideration. It says IA and appeal are accordingly disposed of in terms of prayer A and B of the joint application. So nothing more, nothing less. Now, if your lordship will see previously, the first paragraph, it says joint application filed appellant such and such to record a statement derived at between the parties. The original of the terms of settlement has been signed such and such. Nothing more than that. So, my lord, my respectful submission is that based on this, it is at best an arrangement. Now, if based on this arrangement, you have agreed to do whatever, but if the division bench was not there, things would have been different. But if that when the division bench is there rejecting the probate, and that judgment is not set aside by a superior forum, by arrangement, you cannot have a probate granted. So such a grant of probate to the will, you could have arranged to have certain immovable properties or assets inter se settled in a way parties may have agreed. That's a different issue. If the, my lord, usually these probate settlements, your lordship will find that the parties instead of, my lord, involving themselves in acrimonious litigation, they decide to come to a settlement. So all the assets and properties of the testator are divided mutually among the parties, and that is the settlement. But that does not necessarily mean there is a grant to the probate. So that's a settlement arrangement between the parties, but there is no grant to the will. So
And suppose
yes,
a partition suit is filed.
my lord.
Partition suit dismissed. Went to appeal. Party settled, terms of settlement entered. Appellate court passed the decree in terms of settlement. Terms of settlement be a part of the decree.
Correct.
What remains further?
No, but now, my lord, this is the apparent distinction between all proceeding and a testament proceeding. That is what Carapiet says.
No, that's I'm telling you are 100% right.
Yes.
Even I am with you
Yes.
with regard to the portion of the anima. Anima is not the party to the settlement.
Right.
And it is not disputed that she is not a legal heir. She is the legal heir. She is one of the person who
Right.
can get the share from the ancestor property. And she is not a party, though she was the party till the SLP was, she is also party,
Absolutely.
but in the settlement.
Right.
But whatever it is, rightly, wrongly, whatever it is, the Supreme Court accepted the terms and conditions and Supreme Court consciously has recorded the appellant respondent 1, 2, and 3.
Right.
Supreme Court has not recorded all parties.
Right.
All parties. It has recorded 1, 2, and 3.
Correct.
And probate was allowed. So
Right.
probate was allowed with regard to 1, 2, and 3. With regard to the 4, but here the probate was granted as a whole.
Correct.
In terms of the will.
Right.
So if you are agreed,
Hmm.
you are claiming the share of anima. So you have some other way. How the probate now sitting in the company court, can this court
Hmm.
in the company jurisdiction can enter into this fact or can declare that is a nullity?
No, Lord, your lordship did not declare. The
If I-
declaration of nullity is
if
not
it-
required.
If not
Not
declare,
required.
if I say I can this court ignore? No, it is the anima has not been considered, and the Supreme Court is not then she is entitled. So that's why these applicants are entitled.
Absolutely.
Can
Why not, madam?
Can this
In my respectful submission, your lordship, this court, the company court would have sufficient jurisdiction. Why? I'll tell your lordship, my lord. When member of a company or any creditor, contributory, secured, unsecured, any creditor has any claim towards the company, lodges his claim, and that claim is suppose rejected or allowed or partly rejected, comes before your court. It comes before this court in appeal from the order of rejection. Then court examines the claim also. So then effectively the company court is then exercising civil jurisdiction. So that company court in a winding up proceeding is limited to 434, 433, 434 of the 56 Act. Now, my lord, while examining claims, and when a claim is rejected, and the party whose claim has been rejected comes before the company.
the order of rejection?
Well,
Where
there
is the
is
order of rejection?
yeah, the order of rejection, and tell your lordship, my lord. No. Are order of rejection by the official liquidator. I'll just give you lordship the page number.
Finally, I will look similar 1242 passed in this proceeding by a coordinate page 1242, volume 9. But their submission was before this court, your lordship's court, 1242.
তুমি
What
ওটা
was
বার
the
করো,
observation?
তুমি ওটা না দেখে তুমি ওটা বার করো। Official liquidator rejection order টা check 541
Around time was granted.
541 volume
There he is declaring the probate null and void.
five four one ও যে পেজটা বলছে তুমি ওটা খোলো, আমি 541 দেখছি। আমি তো দেখছি, তুমি ওটা খোলো।
With regard to other release, it was set, Mellot only left open.
541 ও যেটা দেখালো পেজটা খুলে দাও। আরে ও যেটা দেখাচ্ছে ওটা দাও। Unfit for court proceedings.
613 appeal ছিল, ঠিক আছে,
Completely unfit. 1242
আমাদের একটা appeal
সব্যসাচী ভট্টাচার্য, এটা কি প্রসিডিং জিজ্ঞেস করে তো।
CA 20
এটা কি প্রসিডিং? এটা কি প্রসিডিং?
Yes.
Kindly see 16131.
Page number 11.
Volume 11. Kindly see who has preferred the appeal and what was the status of Onima. He was proposed from the probate. 1613. Volume 11.
Volume 1613 Aruta 1412.
She has not challenged the order of granting probate. She was pro forma. Can she challenge now? Kindly see the cost type. What Mr. Bose is submitting, she accepted the probate order. She was alive in her lifetime.
Yes, Mr. Bose.
Which page number is your lordship looking at? 12? No, first your lordship takes 1242. He referred to 1242.
Yeah, 1242. This court has current. Yes, your recall application is there before the Honorable Supreme Court. So that's why you have some breathing space. The court has not gone into. Court has not gone in.
Correct.
The area cannot be granted.
Correct. Now, my lord, he shows
1614.
1613.
Appeal.
Appeal cost title.
Memo of appeal.
Yes.
Filed before the division bench, which you are arguing now.
Yes.
The anima is a performer respondent. She is not the appellant. She is not the appellant.
Oh, if she is not the appellant, that means she accepts the probate.
Why not? If
If
she is aggrieved,
yes,
she could have been the
kindly-
appellant or a separate appeal. Either it's in this case she should be an appellant or it's a separate
Well,
appeal.
kindly appreciate, good, bad, indifferent, whether I file an appeal or somebody else file an appeal, the probate was set aside.
Probate was set aside. That's
correct.
Different.
So that means,
and if they went to the Supreme Court,
yes,
Supreme Court, these three persons who were contesting
correct,
the appellant before the division
they
bench,
compromised.
They compromised.
They joined hands with them.
Correct.
Now the question still remains that there is no probate in the eye of law. When the matter was before the Supreme Court, there was no probate. So that is why they went to the Supreme Court.
Correct.
So at the Supreme Court stage, there was no probate. Probate was set aside. So then the persons who challenged, now just because somebody who has challenged has compromised, does not mean that there is a grant.
But the Supreme Court probate allowed. Prayer A probate allowed.
No, my lord, if your lordship will see,
That's why
that was not.
See now the
No, if your lordship will see,
four documents is here important. 1326.
Correct.
1444, 1444, 1197, and now 1614.
1614.
1614 is the appeal.
Yes.
Cost title of the appeal.
Yes.
1326 is the terms of settlement.
Yes, my lord.
1197 is the Supreme Court order.
My lord.
And 392 is the probate.
My lord.
These are the four documents.
Correct. So now, my lord, apropos what fell from your lordship, now if the persons who have challenged the appeal, if they have compromised, so the others, my lord, if your lordship will see, possibly there were two appeals, if I remember correctly.
Only one appeal.
One appeal. 1613.
No. So far as the probate is concerned,
yes,
once the probate was granted, was there একটা appeal ছিল না দুটো appeal ছিল? একটাই appeal ছিল. So there was one appeal, and the one appeal was by three persons, and these three persons joined hands and entered into the arrangement with
Atanu.
And of course the executor and the Otonu, my learned friend's client. Now the situation is, if the probate has been rejected and subsequently there's a terms of settlement, so there is no adjudication of the rejection, but there is just the terms. Would that give effect to a grant or not? So would that compromise give, or the consequence of a compromise could be a grant of a probate?
That's what I'm telling. As per law.
Yes.
As per certain law, there cannot be a compromise in the probate.
No, it cannot. There cannot.
Has
No,
to be
they
court-
can be a compromise, my lord.
That outside.
But compromise can be arrangement of assets,
That's why.
but not
Not
to
with
the
regard to
grant,
will. Yes.
not to the will.
Not to the will.
Yes.
Not to the will.
Yes.
With regard to the property. That's outside
Yes.
of the court.
Yes. Yes.
settle,
Right,
go
right,
for the
right.
mutation and whatever it is.
Yes,
There
yes,
is nothing.
yes. So there is no grant to the will.
Correct. For that, I am with you.
Yes, my lord.
But see, here the problem is that
Understood.
that has been accepted
Understood.
by the
Understood.
Supreme.
Understood. So, my lord, allow me to come back with that answer to this question. Let us follow.
What further?
No, my lord, if in law I can show your lordship that this grant could not have been granted, and if a nullity need not be challenged, so then the situation, my lord, whether it is company code, civil code, now then what effectively now what?
And second thing, what is the ground in a review application before the Supreme Court?
Same ground. Same ground.
If the Supreme Court has not accepted your
Now,
review,
kindly have a look at the order by which my review application or the recall application
whatever it is,
was
review,
rejected.
recall, whatever.
But kindly have a look at the language.
1195. দেখো আজকে বাড়ি যাবে আজকে করে দাও শেষ করে দাও স্যার এই মিটারটা এই না স্যার এই যে
1195. Yeah, it's here, my lord.
আমি আর বলবো না আমার বলা দরকার নেই ডান
Is Mr. Bose.
My lord. Kindly see this one. Lord, I had filed an application seeking permission to file a recall or modification application. So that application, this IA such and such, seeking permission to file recall and modification application is dismissed. Heard learned counsel appearing for the parties, we are not inclined to entertain this application. However, liberty is granted to the applicant to work out her remedy in the manner known to law. Accordingly, miscellaneous application stands dismissed. Now, my lord, what do I do with this liberty? So now, my lord, I have exercised the liberty granted by the Supreme Court and I am pursuing this application, which I say that, my lord, no probate could be granted by this court.
That's why, Mr. Subject to correction, subject to correction. So this recall application filed by you in connection with the probate proceeding, which went from the single bench to the division bench and to the Supreme Court.
Yes.
Correct. And the Supreme Court has given you liberty to work out your own remedy before the appropriate court. And the appropriate court, probate court granted the probate.
No, my lord, here it says for my
Work
remedy, I go before the appropriate court.
Correct, that's why.
Correct.
So the appropriate court has granted probate, rightly or wrongly in terms of the Supreme Court.
Right.
Rightly or wrongly.
Rightly or wrongly by the correct.
Correct. So now whether this court can go into the probate proceedings.
Understood.
That is the thing.
Now, so my lord, I have to come back with that company code, probate code. So, my lord, there is no dispute that I have a right.
You have a right
to seek revocation of that grant.
But which code?
Now the question is that whether it is the company code or the civil code. Whereas, my lord, if your lordship will see,
now it is a testament in original testamentary.
Yes. Very well. Understood. I'll come back on this. No, my lord, in a situation where the rights have been affected, and my lord, my right is what? It is getting affected because the other side shows the probate and the official liquidator say that because of the probate, I can't give you.
Because he's right.
Right.
He cannot go.
So technically, I'm right. He's right. So that's why that technically, since he has the probate in front of him shown, which is granted by according to the official liquidator by the appropriate court. So, my lord, my rights are affected. That's why I am challenged that before the court. Now, my lord, at best, what can happen? If this court gives a finding that no, this court does not have the jurisdiction, then I have to go before the other court. Very well.
That is
understood.
Kindly see 1446.
এটাও লিখে রাখো, এটাও লিখে
Kindly
রাখো।
see 1446 কেন লিখে রাখো না, ওটা তোমার ইনকনভিনিয়েন্ট কম্পাইলেশন আছে। 1446 volume 10. Kindly see paragraph 3 onwards. Can you re-agitate all these things? What is the full point before Supreme Court? All illegality done by me.
আরে কিন্তু লিমিটেশন গ্রাউন্ডেও দিয়েছে 2017 থেকে আমি কেন
That লেখা নেই।
No, that's correct. In this application,
every point taken. What is agitating before your lordship now?
Naturally, I went for recalling of the order.
This court can't go before the company court and argue.
Mr.
So this
Mr.
is not
Bose-
the
Mr.
liberty,
Bose
but
is
that is the probate
having a
grant
good
of probate.
experience of the liberty of the Supreme Court. Other matter, Mr. Bose has argued about 6 months.
So I don't say that he has no right to bring his point of jurisdiction when I exercise my right of liberty, which he has rightly done. Now the question is that whether it will be the company code or an appropriate testamentary code. Very well. Understood.
That this can't be that.
अरे जानले की आस्था.
Contentious causes.
I'll come back. I'll come.
Mr. Bose knows that this is not the code.
No, my lord, the question is that.
Let apply the mind.
Yes.
No. Come back.
Sitting in the chamber,
My lord,
the mind will fresh.
Yes.
My lord, if I do not find any authority which would say that in a situation like this, it cannot be the company code, but it has to be the testamentary code, regardless of whether it is a nullity or not, then my lord, why should I trouble your lordship? My lord, I have my remedy before the testamentary court. I'll go before the testamentary court.
Unnecessary delayed. I mean, setai bolchi.
So that's what I'm saying. So there's been a delay. My lord, here is a grant of 2001.
Already 2001, 25 years gone. So
25 more days. Like, may I take your lordship's kindly? My lord?
I think is the reserved for us.
Counsel for the applicant has argued the matter at length and prays for time. According to his judgment, let the matter. ये 20 तारीख को 13 तारीख को कोई फिक्स है क्या? 13 तारीख को कोई मैटर फिक्स है?
Did it 2013? Let us
No,
see.
let us see. वाला फिक्स है ना? So 20 को नहीं फिक्स है ना? 20 फिक्स नहीं है ना? Let the fix at 3 p.m. on 20. 13 other matter is fixed. Already Mr.
That
Mukherjee.
is, I think not for 2 p.m.
No, but the other matter is to be
Fixing
taken.
it on
20. 20 at 3 p.m.
Liquidation. Or my lord, can we come back any day non-company day?
No.
Can't
We'll come back on 20.
now it has come into.
Whatever he does, it will not be there. My lord, no court can say this.
Let come.
Grateful.
6 is also.
So far in the 6 is concerned, my lord. As per your lordship's, kindly see your lordship's order dated 16th July. Your lordship some direction.
My lord, I am appearing for the applicant.
But page 3 of your lordship's order, the lordship was pleased to appoint.
In view of the submission, counsel with respect to party, so and so appointed as a special officer for the purpose of demarcation of the land. Yes.
Now,
What
my
has
lord,
happened?
inspection has been taken, but he is ill, my lord. He has given me a email that he will take another 15 days time.
Time is required.
Yes. Number 2, my lord, he cannot, my lord, there is an order, my lord, construction of the boundary wall. He is the surveyor, so he
He
cannot.
can only upon construction, he has to show the boundary.
No.
One thing has to be recorded that he is only representing. That might have been recorded and my lord.
Last one, Mr. Bose submitted. He is only representing
Yes.
the applicant.
And
number
other
two.
applicant is not proceeding.
Applicant number 2.
No, and the other applicant is not.
Okay, let it submit the report.
No, my lord, in case of construction of boundary wall, my lord, the official liquidator is seeking leave that all the parties should be a meeting and decide how the construction of the wall would be made. My lord, that is page 3, my lord.
Yes.
It says that upon construction of a boundary wall.
Yes. Who will bear the cost of the boundary wall if the demarcation?
We are not there.
My lord, it was already, it has been already been decided, my lord. The official liquidator was supposed to do, my lord, because as per the last order of this.
Official liquidator with regard to the demarcation, construction of.
No, my lord, the construction, my lord, since the official liquidator is having the money from the properties, my lord, it has to be contributories has been amicably decided, my lord. My lord, in my application, my lord, may I refer the. My lord, may I have your lordship's kind leave to come back on the next date, my lord, because I need to identify, indicate the minutes of the meeting which has been between the contributories, my lord, wherein it has been held.
My lord, they are 3 same property.
Same.
Yes.
My
Yes,
lord,
ma'am.
I'm filing the reply to the.
My lord, this is not for this matter.
Now, 7 is what? 7 is also appointed. Commissioner was appointed.
No, 7.
No, my lord, 7 is a different matter, my lord. Item number 7 is one. My lord, let the surveyor first demarcate, my lord, first demarcate and provide the demarcation surveyor report, my lord.
7 is separate
Malad-
application. Press করছে কি?
My lord, I am for the applicant, my lord. My lord, one of the contributors, Mr. Shushmit Dotto and Rathindranath Dotto and Ms. Ranjana Dotto has filed an opposition.
Seven.
Reply, my lord.
Give the
to my
copy.
position.
Counsel for the applicant has filed reply. Reply.
27,
Let the same be kept.
We have also not received.
Counsel for the
My lord, I have also not received, my lord, for item number 7, my lord.
applicant has filed reply, affidavit in reply. After serving copy to the land counsel for the respondents, let the same be kept with the record. This is the matter.
এটা রঞ্জনা দত্তটা দিয়ে দিন
Yes, next.
My lord, item number 6, my lord.
Not next Tuesday, next Tuesday.
My lord, grateful, my lord.
6 and 7 next Tuesday.
My lord, grateful.
Huh? 6 and 7. no?
In 55, I appear for the applicant.
এ দিলেন রঞ্জনা দত্ত দিলেন
55.
55, my application, my lord, company application. And my lord, here, my lord.
But I appear for my lord the applicant in 57, my lord. These are all.
My lord will see the last order, my lord passed. That's why it's appearing on the basis of the prayer made by us. My lord, there are two creditors who are fighting among themselves, asking for division of the little bit of money that is left. I am the sole contributory. All the shares are vested in me. I have come across certain properties which were inadvertently left to me in a will, from which I realized that these properties are the welfare of the company. I have asked for, my lord will see paragraph 4. I have brought these on record. I was given leave to file an affidavit. I filed an application. I have annexed a copy of that application to this affidavit. That application is coming up next Wednesday.
My lord, here, my lord, on the last occasion, your lordship directed to file an affidavit stating the what assets left.
Yes.
That has not come here, my lord. They are making an application, making complication.
Very well. If he doesn't want the money, I'm withdrawing it. That is the, well, he has not read it. It is, all details have been given. My application itself has been annexed to the affidavit.
But they are making application
Of course
instead
I'm
of
making
giving the details of the assets.
If application, what is the prayer in the application?
Prayer in the application is that the OL take over these original deeds from me.
Where is the someone?
Well, today what is appearing? I was directed to file an affidavit. I filed an affidavit. In that affidavit, I've annexed a copy of an application I have taken out,
Correct.
which my lord is given leave today,
Correct.
and which is coming up next Wednesday. In my application, everything is annexed, and that application itself is part of this affidavit.
Give the copy.
My lord, I have not received.
filed a separate application. He filed the affidavit disclosing his application also.
Yes. But
So you take-
everything is there. If it
take
doesn't open the
this.
annexures, what can be done?
You go through this. Yes.
My lord, I should be given a copy, my lord.
Copy.
I am.
Well,
so-
I'm an outsider. I do not know who's appealing for who.
My lord, I am appealing for Saurashtra.
Yes.
Very well.
This has been served today.
Yes.
And
Yes, you
order
go.
was, my lord, within 10 days.
Listen, I am doing it only so that he gets paid.
Okay. So you go through next
If
week.
the standard
If it is prolonged, my lord,
Okay,
Please
sir.
prolong
Come on
it.
next week. Come on next week.
Lord, but thereafter, my lord, it should not be prolonged. Whatever the assets have been disclosed, the official liquidator will be directed to take.
Exactly. That is my specific.
You serve the copy to the official liquidator.
Yes, I have.
You go through
That's
this.
how receipt,
You
yes.
file the report.
And it's coming up on Wednesday. I mean, let him file a report.
Mr. Rudradeep Chaudhary, London advocate appearing for the shareholder of PC Roy and Company, has filed affidavit disclosing certain documents after serving the copy to the London Council appearing for the parties. Let the same be kept with the record. Full stop. The official liquidator is directed to file the report.
My lord will record that I have served everything.
Record it. File the report within 2 weeks. Release the matter on 20th August.
That matter has been, the application is coming up on next Wednesday.
Let it come. I'll see to that. Because they have to file the report with regard to their
They
document.
could file it. I've given all the particulars that if they could,
Let them come. Because
instead of giving them 2 weeks, I was thinking if my lord gives them
Okay.
1 week, then the matter could have been
this will be
expedited.
your application will be taken along with on 20th. If the application will come and this court find that it is to be recorded, it will be heard along with that on Wednesday on 20. Yes, next.
Milord, 56, 57, Milord, maybe stand over together, Milord. Just maybe, Milord, come up.
56 is they are connected matters. If this is solved, everything gets solved.
20. 56, 57, 20.
together, analogous.
20th. 20th August. Next.
58. Up to 58, there was the application for dissolution, Your Lordship. So we have, company has been dissolved and Malor has been pleased to pass a direction to file a report to that effect. After taking the amount for the auditor. What's the number? 58. No. So therefore, Your Lordship, this is the application, this is the report, Your Lordship, company has been dissolved.
Yes. Company has already dissolved.
Company has already been dissolved, Your Lordship. My lord has been pleased to direct to file a final report to the effect after disbursing all the payments.
When the company was dissolved, by which order?
Lordship, it was pursuant to the order December.
December 24.
There was a direction published for advertisement.
Yes. Official regulators shall publish the advertisement in accordance with Prayer C of the summons direction and shall furnish report.
There are also several orders. 12 February 2025, Your Lordship, there has been an order passed by my lord. For appointment of an auditor.
Now, what about the dissolution?
Lordship, these are the various steps of dissolution, Your Lordship.
Correct.
Pairs which were sought for in the application. One after the other, Your Lordship, these applications pairs have been sought for and have been applied. Lordship, after filing this report, Your Lordship, the final dissolution will be done.
Correct. That's what I'm telling. You're telling that it has been dissolved. You file the report.
Yes.
So amount has been deposited. 3,27,000. Yes. So what order is required further now? Where is the summons direction? So prayer B already over, C also over, D also over. D is to pass an order, dissolution. Dissolution order is not passed.
Lordship, that is, I'm seeking prayer D, Your Lordship.
Payment is already there. E already passed.
Pass, it's only D which is to be complied with.
This is for the permitting officer liquidator dispose of the book and papers of the company.
As well as F.
That's why. This could find that publication was made on 10th of January 2025. But none has come forward for raise any objection. The Punjab National Bank is a secured creditor, but no objection has been raised on behalf of the bank. Subsequently, auditor was appointed, na?
Auditor was appointed.
Subsequently, auditor was appointed and submitted the report. After the report submitted by the auditor, in terms of the order passed by this court dated 16 July 2025, an amount of rupees 3,27,489.57 is transferred to the Reserve Bank of India under Section 555 of the Companies Act after deduction of all liquidation expenses. Today, the official liquidator has filed the report. Let the report be kept with the record. Considering the above, this court find that the amount has already been deposited in the Reserve Bank of India in terms of Section 555 of the Companies Act, and nothing remains in the present application. Thus, the company is dissolved and the official liquidator is directed to dispose of the books and papers of the company in liquidation immediately after the expiry of 5 years from the date of dissolution of the company in liquidation, as laid down in Section 550 within bracket 1 and within bracket 2 of the Companies Act. CP number 245/73 along with the CA1 of 2024 is disposed.
The applicant, Lord, but I'm representing the.
I'm appearing for the respondent, Your Lordship, State of Bihar. They have served the affidavit in reply to the opposition filed by us. Though it is belated, Your Lordship, some time may be given to get ready with the matter. 2 weeks time may be given. We'll get ready and argue the matter 1 minute.
What is your
served on 29 July, my lord?
It was to be served by 7th of July, Your Lordship.
What is the prayer?
Lord, my prayer is for Lord compliance of an order which is at page 59. My lord, in respect of this, my lord, proceedings, my lord, which was disposed of by this order, my lord, the state of Bihar was directed to carry out certain rectifications in the, my lord, the record of rights, wherein, my lord, 4 plots which, my lord, we had acquired, the company in liquidation had acquired, my lord, that was wrongly recorded, 2 in the name of the state of Bihar and 1 in the name of another gentleman. My lord,
so how you come into the picture?
Lord, I'll tell you, Lord, Lord, through acquisition
proceedings. Correct, acquisition proceedings.
Thereafter, my lord, state of Bihar was given an option. My lord, this is, I'm talking about, my lord, in 1978. My lord, the state of Bihar was given an option to, my lord, of first refusal to purchase the land. They did not do it. My lord, it came to the till of the company. My lord, now after it came to the till of the company, my lord, this went all the way up to the Supreme Court. My lord, they challenged the order. My lord, thereafter, division bench dismissed their appeal. My lord, even the Supreme Court, my lord, did not interfere with the findings of the, my lord, single judge. My lord, thereafter, my lords, while, my lord, trying to sell those plots of land, my lord, in order to realize money, my lord, we found that these 4 plots out of these 153 acres of land, my lord, this was, my lord, wrongly recorded. It was not in our name. My lord, we approached the state of Bihar, they did not, which necessitated the filing of the application in which this order was passed. My lord, that application is CA 481 of 2017. Lordship will see the order. My lord,
okay, let come. This is not ready.
My lords, as your lordship please.
Counsel for the applicant has filed a reply.
my lord, affidavit in reply to the
Filed
opposition.
affidavit in reply to the affidavit in opposition filed by the state of BR after serving the copy to the London Council for the state of BR. Let the same be kept with the record. List the matter on 13th August.
My lords. Great.
Your
May I-
Lordship, I was praying at least 2 weeks' time may be granted because senior counsel from Your Lordship, senior counsel from Mr. Umesh Prasad Singh will be appearing, Your Lordship.
Okay, come on 20th.
Your Lordship, sincerely obliged.
Lord, I am appearing for the applicant, Lord.
Lordship, in item number 68, there was a direction for us to file an affidavit in opposition that was not in the record. May be permitted to file it.
Reply has already been filed, Lord, and it's not record. Lord, may I but short prayer, in this prayer, in this case, I'm praying for a twofold prayer, Lord. Prayer is to register and execute deed of conveyance for a sale in respect of plot number 12 under the RS Dag number such and such, my Lord, and also, my Lord, to grant to return me a settled amount of rupees 22,000. What has actually happened, my Lord? My husband purchased a plot of land, my Lord, in the year 1976. My Lord, thereafter, my Lord, this company went into liquidation. My Lord, this company thereafter, my Lord, this company went into liquidation in the year 1978, and there was an order of the High Court by virtue of which, my Lord, the official liquidator directed to sell the assets of the company. So, my Lord, there are two plots, plot number 12 and 13. 13 has been registered in my favor, but 12 has not been done, my Lord. We have paid the amount prior to that, prior to went into liquidation. Now, my Lord, we are regularly pursuing the matter. My Lord, my husband died in the year 1987. Thereafter, Lord, I am regularly pursuing. Now, Lord, what the official liquidator said, my official liquidator said that you have to take an order from the High Court. If the High Court passes an order, then we'll execute the deed of in your favor, my Lord. So, my Lord, and they have filed an opposition, but we have also filed a reply to that.
What is your stand?
My Lord, the respective plot, the piece and parcel of the property which my learned friend is referring to is not in the assets. That property has not been included in the assets, so we cannot execute or go for the deed of conveyance at this juncture. There's a huge lapse of delay.
But my Lord, the amount
There are two adjacent plots. One plot has been registered because that was indicated in our assets also. So that has been complied with. We have registered, but the part which is not in our assets, in the schedule of assets, we cannot proceed with the conveyance. And absolutely after a long delay. The reasons of the delay has not been even explained in the application also.
Well, try to explain the reason. My husband died in 1987, but thereafter we are regularly pursuing the matter. We have written
87 when you filed up to 2025.
It has been
87 and 25.
We are pursuing the matter before.
Property is still there or
No, the property is
in
there.
occupation of the other persons?
No, it is there. What I'm humbly submitting, Lord.
Occupation of the property.
Lord, Lord, what I'm humbly submitting before Lordship, kindly, my Lord, thereafter, my Lord, I am pursuing them. It's not that, we have subsequently we wrote a letter, my Lord. They are saying, my Lord, that they somehow they are saying that because we have paid the amount. That is, my Lord, I have annexed the documents, my Lord, that I have paid, and my Lord, it is settled, my Lord. They are supposed to return me the amount of rupees 22,000, but they are also not. That amount is also not returning, my Lord. The amount which I have paid to them, my Lord, that is also not returning to them.
Not to them. It is not to the official liquidator that they have paid. They have paid to the erstwhile owner. Not to the official.
No, it was paid to the erstwhile owner, my Lord.
You have paid the owner.
Yes.
So how the officer?
Then no, it has gone into liquidation, my Lord. Then thereafter, my Lord, it has been done.
What has happened after the liquidation?
There was an order of 1985, my Lord, sell the assets, everything, my Lord. So thereafter, my Lord. So Lordship will kindly, my Lord, only, my Lord, my respective submission, my Lord. That
come next day,
Next Wednesday.
Next one.
Counsel for the official liquidator has filed affidavit in opposition. Let the same be kept with the record. The petition already filed the reply. List the matter on 13th.
13th.
August. Next.
My application, my Lord. I had rented out a portion of land to the company in liquidation, my Lord. The company, this land was adjacent to the company's owned land. Both the lands were used to construct a factory, my Lord. In liquidation, the entire property has been sold. When it's an unvetted position, that mine is the rented portion, and so basically I'm a landlord. I have made an application for rectification of that deed and getting back the possession of the area owned by me. That's undisputed. But this application has to be heard with the next matter. My lord, on the last occasion, I directed them to supply me a copy. I have not received a copy yet, my lord. So both have to be order of 16 July, my lord. CA number 17 was directed to be supplied to us, my lord.
Lord, I'm handing over the summons and my lord, the affidavit. But this is for dissolution, yes.
So, my lord, this dissolution cannot happen before my application is heard.
All entire sale has been, my lord, done. Entire assets and properties were sold. Distribution was also made. So nothing remains. So that is the reasons for which, my lord,
my properties.
Yes,
my application has to be heard.
Identify the property.
And it's in the sale notice.
At the time of the sale, tender and the sale, who has identified the property?
But the surveyor was appointed, my lord, the sale was conducted, my lord, with the intervention of the court, and my lord, they did not raise any objection.
No. There is no occasion to raise objection, because in the sale notice, there's a portion which is rented out, which cannot be sold. They admit, but when the deed of conveyance is executed, they convey my property also. There's no reason for me to object before the sale had happened.
Have you disclosed the deed?
Yes, everything. I have disclosed their sale notice, my lord.
Have you disclosed the deed?
No, my lord.
They have filed their opposition.
Opposition, you have not disclosed the deed. And you have not disclosed the total proceedings.
We have disclosed the deed, my lord.
Most importantly, proceedings of the liquidation.
No, my lord, that was possibly
that is required.
My lord, kindly grant me leave over.
That is required.
Well, kindly
since beginning the notice.
Yes.
Court order, notice, the inspection, then the tender, and
everything.
Which portion. And the valuation, valuation report, which portion of the valuation?
Yes.
That.
Yes. Very well, my lord.
My lord, kindly passes an order, my lord. Yes, my lord.
Yes.
The counsel for the official liquidator is directed to file report disclosing the
737.
Disclosing the total proceedings initiated by the official liquidator for that was dissolved. Company dissolved.
No.
The next application.
The next, my lord, matter is made an application.
Obviously.
Liquidator for disposal of the property of the company. Let the report be filed within 2 weeks.
Within 2 weeks.
Within 2 weeks. After serving the copy to the land counsel for the applicant. This is the matter on 27th of August.
Very well, my lord. I'm deeply obliged. But next matter will also stand over, because that's for dissolution. That cannot happen without this.
27.
Yes.
I'm deeply obliged.
Yes, next.
But here your lordship's direction was that we have served the notice upon the ex-workers. But if your lordships kindly see your lordship's last order.
Response to the advertisement published in the English language, only 2 ex-workers of the company have sent response to the official legal. According to the official issued notice to the said ex-workers with respect to the claim. Yes, they have issued.
Yes, my lord, I am submitting the report. There are 2, my lord, only 2 persons, my lord, the notice they have received, but they did not respond. And 2 response already with the official liquidator. And remaining, my lord, there no effects, no service effect. My lord, kindly see all the, my lord, I have disclosed all the, my lord, the track reports. 88, my lord.
Or delivered?
No.
Not delivered.
Not delivered.
So publish the notice.
84 not delivered. And
how many workers are there?
184.
Total.
Total.
So out of 84, how many workers have been have received?
No, out of which, no, 88 workers, we have served notice upon the 84 available, the address, out of which, 4 has been received. 2 received, but no response, and 2 make a response with the official liquidator. So our respectful submission that we have got the money. So if we can, pay the 4 persons who have already response. Otherwise, this amount will go to the contributors.
Correct.
Ultimately, contributors. 2 things, 2 prayer. Either, my lord, the 4% may be paid by the official liquidator, and my lord, a fresh notice.
Have they came?
Yes, they have two of them as respondent with the official.
Whether they came to the office of the
Yes, official liquidator. So two response has been received by the official liquidator, but two of them received the notice, but no response has been made. So that 4 we can make a try, and balance we either, if your lordship kindly direct them to make a fresh advertisement, we can make a
is to be made.
publication. This publication has been made, already made.
Where is that?
This is publication.
No.
It is mentioned in the report itself.
Now, where is the publication notice?
My lord, it was in the previous report, my lord.
Previous report
Submitted with your lordships.
No, you have published the notice. You by name you publish.
By name. By name has.
It is only the advertisement to the ex-workers, creditors approved.
Yes.
How they can identify? You by name you have to publish.
By name, my lord, it's very difficult and my lord, very costly. It would be
No,
possible.
what I am not. This is okay, but you put the names. It may be one page. It may be 1, 2, 3,
4 names.
It has to be.
Yes.
Otherwise,
very well. Very well.
Otherwise, what? How it can?
Yes. Yes.
Ex-workers, you
Those
have
are
given
the
this.
4 people's, my lord.
IEC Limited. I don't know whether if the children are there.
Right.
Original workers died.
My lord.
So that may be.
Very well, my lord.
Official liquidator has filed report in 2 volumes disclosing the service of notice upon the ex-workers of the company in liquidation. It is submitted that out of the 88,
yes, 88,
out of the 88 ex-workers, 4 ex-workers have received the notice through postal service,
and 2 of them has responded.
Out of 4, only 2 ex-workers have response to the official liquidator, and 2 have not come forward. 2 have not come forward. Full stop. Counsel for the official liquidator submit that the amount is still laying with the official liquidator, and if the ex-workers has not come forward for claiming the amount, the amount will be is required to be deposited in the account of contributor.
Yes, contributors.
Contributories. Full stop. Considering the above, this could find that the ex-workers are entitled to get their remuneration. It is a remuneration or what?
No. It is their claim, my lord.
Ex-workers are entitled to get their claim from the fund available with the official liquidator, and as such, official liquidator, and as such, this court finds that, and as such, it is for the benefit of the officers, for the benefit of the ex-workers, the official liquidator shall publish another notice in English daily newspaper as well as in Bangla newspaper by disclosing the identity of the ex-workers by claiming the claims and objections within a period of 2 weeks, within a period of 4 weeks.
4 weeks.
4 weeks from date after publication of the notice. The official liquidators shall submit report within 2 weeks thereafter. List the matter on List the matter on 24th of September.
Deeply blessed.
2020.
My lord, on compelling circumstances, my lord, I am praying leave to mention item 69, my lord. In this matter, what happened, my lord, this is an application by the, my lord, company. The winding up petition, my lord, there was a direction against the company to secure an amount by way of bank guarantee, and, my lord, the dispute was relegated to suit. The petitioning creditor had filed a suit. So we have filed a bank guarantee. We are renewing the bank guarantee, my lord, time to time. Now we have find out the suit has been dismissed.
Which
Item 69.
69 of company matter.
Yes. Now, my lord, problem is that this bank guarantee I am directed to be furnished, and I am continuing. Is last expiring on 9th October. My lord, suit is not there. If I once again I have to, my lord, extend the bank guarantee, then I will, my lord, facing problem. I have sent the notice. The advocate has refused to accept the notice because they have no connection with the client. So I have sent it directly to the petition creditor. Any day, if your lordship take up this matter before 9th.
Before 9th of?
This is very small matter, my lord.
9th of, no, next will be on 13th only.
But the direction is that I have to furnish a bank guarantee, and if they do not file the suit, then I can pray leave to, my lord, return of the bank guarantee. That's the situation. Lordship, kindly, once again, if your lordship kindly see the order passed by the winding up, honorable winding up court. This is at page 8. The type copy is at 8A. I have secured the principal claim.
Secured by way of bank guarantee
yes,
to the satisfaction of the registrar within a period of 4 weeks. And in the event such security is furnished, the petitioner creditor shall file a suit within 6 weeks. In the event security is not furnished, the petition shall be stand admitted and it will be open to the petitioning creditor to apply the advertisement. Yes.
Yes. Now, problem is that they have filed a suit.
Okay.
But I have found out in 2017 the suit got dismissed.
Correct.
Now that annex that I have annexed at page 14.
Correct.
So now, my lord, the last in 2024, I have, my lord, renewed this bank guarantee.
What do you want now?
My lord, I would have asked for a prayer in terms of order in terms of prayer A, but my service is not complete. So therefore,
the notice come on 13.
So I may not, my lord, I may not be directed to once again renew this on 9th August. That's the difficulty, my lord.
Do one thing. You. So if the bank guarantee is gone, it is not reviewed, it is not reviewed.
It alive as on date.
As on date, but 9th August, I don't think the 9th August will be taken up. Today is the 6th.
Yes, before 9th it will not be taken up.
13th it will be taken.
Very well, my lord, I shall renew my prayer.
Renew
my prayer, but I will, I was paying for a order, but it's not complete. That's very well.
Lordship, may I be permitted to mention one CS 15 of 2007, which is fixed tomorrow under the heading witness action at 2 o'clock. Now, my lord, in this matter, I'm led by Mr. Shakhu Sen, senior counsel. Now, Mr. Sen is having some difficulty tomorrow at 2 o'clock. If your lordship kindly fix another date, I will
tomorrow 2 o'clock with the cash.
Lordship, item 67. Lordship, item 67. I am for the official liquidator, Lordship. I am only praying for 2 weeks' time to file my reply. On last occasion, your Lordships directed us to file.
Next day, you renew a prayer, no problem.
Good. Item numbers. I'm only praying for a direction of service. This is a restoration application filed in 2018.
Submit.
One line from your lordship.
Not required.
Kindly, it's an old advocate on record has changed that.